to this conference. Just a few minutes for opening addresses. We will speak in Italian, so we will switch for a few minutes in Italian and then we come back to English. It's a pleasure to give the floor to our Vice Dean, Professor Matteo Kosulic, that will speak on behalf of our Dean, Paolo Carta, that is out of office in that time. Thank you very much.
Buongiorno, nice to meet you. Io sono, come è stato detto, il preside vicario della facoltà di giurisprudenza. In genere la vita del preside vicario è una vita beata, tranne quando il preside è fuori sede, e oggi è uno di quei giorni. Questo ve lo dico soprattutto per giustificare la circostanza che potrò stare poco con voi, quindi porterò i saluti, seguirò un po' nel pubblico e poi purtroppo dovrò lasciarvi perché oggi è una giornata per me e per la facoltà piuttosto complessa. Sono comunque molto contento di portare i saluti della facoltà a questo convegno e a nome della facoltà mi congratulo con gli organizzatori ed in particolare con la collega e amica Gabriella Di Paolo, che è uno dei componenti più attivi e capaci della nostra comunità di giuristi tridentini, e la realizzazione di questo convegno lo dimostra ampiamente. Credo non ci fosse luogo migliore dove svolgere un incontro di questo tipo, perché sappiamo tutti bene quanto nella nostra facoltà ci sia ormai da decenni un'attenzione fortissima al diritto transnazionale, al diritto comparato, al diritto sovranazionale. Il tutto naturalmente sempre con un forte radicamento nel diritto interno. Diciamo, si parte dal diritto interno per poter affrontare appunto altri ordinamenti. Ci dà in sostanza il nostro ordinamento ci dà una base solida per poi guardare lontano, altrimenti non avremmo il termine comparazioni, se il tutto sarebbe complicato. E devo dire che il programma di questo convegno, nella sua articolazione in sessioni, conferma molto bene, a mio avviso, questa impostazione, che è un'impostazione comune alla facoltà. Detto questo, dirò due parole sul tema. Naturalmente, forse per qualcuno di voi la barriera linguistica mi protegge, nel senso che io non sono, ahimè, un processual penalista, pur avendo forti interessi per tutte le materie processuali, perché lo dico non per captatio benevolenza, ma io ho un po' l'idea che il diritto, tutto il diritto, sia soprattutto diritto processuale, anche il diritto costituzionale, che è la materia che io cerco, diciamo, nel mio piccolo di coltivare. Quindi intervengo, diciamo, dirò due cose veloci e diciamo leggere da costituzionalista. E mi pare, se posso, si possa, diciamo, ricostruire la tematica di questo convegno un po' alla luce del passaggio nella integrazione europea dal livello intergovernativo al livello sovranazionale, o almeno l'aspirazione a questo passaggio. Io, come credo si veda benissimo, ho qualche anno e ricordo quando ero più giovane che sembrava che il passaggio in questa direzione fosse cosa fatta. Poi sono successe varie cose, diciamo così, forse le magnifiche sorti progressive hanno stentato, erano forse meno magnifiche, meno progressive, hanno stentato un po' a realizzarsi rispetto a quello che si pensava quando ero un giovane dottorando. Però in quest'ambito si respira, io ho trovato molto stimolante, perché si respira questo passaggio dal livello intergovernativo a quello sovranazionale, forse conseguenza anche del venir meno dei confini intraunionali, Schengen, il venir meno delle frontiere. Indubbiamente si porta dietro, immagino, anche appunto ve lo dico dall'altro angolo visuale, naturalmente, la criminalità transnazionale all'interno dell'Unione e l'esigenza di comunque realizzare nell'Unione uno spazio di libertà, sicurezza, giustizia senza frontiere interne, come dice l'articolo 3 del trattato. E da questo punto di vista gli istituti che verranno esaminati oggi sono sicuramente, a mio avviso, una manifestazione di questo passaggio verso un'integrazione realmente sovranazionale. In fondo, rogatori e estradizioni sono espressione, direi, lo dico con cautela naturalmente, della collaborazione intergovernativa e si portano dietro tutto ciò che implica, banalmente, io lo vedo in ambiti che mi sono più vicini, il dato della votazione politica, che è sempre presente ovviamente laddove si ha la collaborazione intergovernativa, anche vicende relativamente recenti nel nostro paese lo diciamo attestano in maniera direi inequivocabile. Invece la sostituzione, diciamo così, all'estradizione del mandato d'arresto europeo e alla rogatoria dell'ordine di indagine europeo e l'istituzione del 17 e poi l'operatività nel 21 della Procura europea sono tutti segnali di una integrazione sovranazionale. Il tutto naturalmente trova fondamento in quello che oggi si chiama Trattato sul funzionamento dell'Unione Europea. Tutto questo, diciamo, è da giudicare positivamente. Certo, se, mi pare che voi lo facciate benissimo, se sempre da costituzionalista si cambia l'angolo visuale, indubbiamente qualche profilo critico ci può essere. Sapete, come si diceva tanto tempo fa, se si guarda il tutto ex parte principis, siamo tutti contenti perché almeno si va verso questo tipo di integrazione. Se però si passa dall'altro angolo visuale, che naturalmente è quello ex parte populi, forse ci vuole qualche cautela. Mi pare che queste cautele voi le abbiate presenti molto bene, perché comunque c'è l'obiettivo della tutela dei diritti fondamentali. Quindi credo di capire e condivido peraltro che diciamo lo sforzo anche di riflessione scientifica sia quello di evitare che forme di cooperazione giudiziaria a livello sovranazionale più intense e motivate anche da esigenze condivisibili, per carità, esigenze di efficienza, di rapidità, non finiscano per conculcare i diritti fondamentali e la loro tutela. E forse anche questo è proprio il posto del giurista, no? Il ruolo del giurista nella tutela dei diritti. Bene, con questo vi risparmio ulteriori riflessioni su un campo che non oso arare ulteriormente per non dire cose troppo improprie, e vi ringrazio in della facoltà per essere qui a Trento e ringrazio naturalmente ancora la collega. Grazie.
I give the floor to Roberto Bertuol, criminal lawyer and president of the Criminal Bar Association of the Trento Province. The Italian wording is Camera Penale di Trento, Michele Pompermeier. Thank you very much.
Grazie mille, Gabriella. Grazie a tutti loro per essere qui. Benvenuti. Il saluto che porto quest'oggi a nome di tutti gli avvocati penalisti della nostra provincia, della Camera Penale di Trento, è un saluto non formale, ma è un saluto assolutamente convinto dell'importanza degli argomenti che saranno trattati oggi. On behalf of Camera Penale di Trento Criminal Bar Association of Trento, I'm very honored to welcome you and to bring our greetings to you all to this Congress. Pensiamo davvero che la prospettiva europea, che ormai da tempo dovrebbe occupare anche le nostre scrivanie, abbia ancora molta strada da percorrere. Il giurista è più propenso allo studio e all'approfondimento. L'avvocato è dominato ovviamente, così come il magistrato, da aspetti pratici del suo lavoro. E in ogni caso l'avvocato europeo dovrebbe sempre di più pensare di mettere quella toga, cioè quella toga europea che ci porta a ragionare in termini più ampi, poiché la difesa degli assistiti e dei diritti degli assistiti a volte sfonda in maniera molto chiara i confini, i vecchi confini nazionali, per avere una prospettiva non solo di casi che possono essere trattati nello specifico, ma anche di conoscenza di questa collaborazione e cooperazione europea. A maggior ragione gli avvocati devono essere consapevoli che le loro organizzazioni si devono strutturare meglio per essere adeguate al fatto che comunque la giustizia in Europa è una giustizia sempre più strutturata dal punto di vista della prospettiva della magistratura. Quindi gli avvocati rischiano in questa situazione di evoluzione di trovarsi in una posizione di arretramento, e il primo passo per migliorare questa condizione è la conoscenza, l'informazione, lo studio. Quindi io sono convinto che gli avvocati che sono qui, e comunque anche quelli che non sono qui e che potranno poi approfittare dei lavori di questo convegno, saranno felici, appunto, e anche sarà per loro un compito assolutamente degno della loro posizione, quello dell'approfondimento di questi argomenti. Quindi auguro davvero un buon lavoro a tutti e buona giornata. Grazie.
Thank you. Good morning, everybody. Let's start the first section of the conference. Please pardon my English, but it's still morning. I need some warming up going on. I'd like to thank, first of all, I would like to thank Gabriele Di Paolo for organizing this conference and inviting me to chair the session. I feel really honored to chair such distinguished scholars. The session will focus on the evolving framework of criminal justice and international cooperation within the European Union, offering insights on both current challenges and the potential developments. The key issues, as we all know, will be the European arrest warrant, understanding its impact on the speeding up of extradition procedures, as well as on fundamental rights protection. The cross-border exchange of evidence, examining legal mechanisms that facilitate the exchanges of evidence and their potential drawbacks. Electronic evidence and digital tools, evaluating how they are reshaping criminal investigation and court admissibility of evidence. I must notice that there will be a switch between Lorena Bachmeier and Michele Panzavolta. So the theme of the electronic evidence will be before the other one. I don't speak so much apart from my bad English, but this morning we have a very busy agenda. So I will not take up time from the presentation. And I recommend that the speakers keep their presentation within 20-25 minutes or so. I believe I was looking at Gabriella. 25-30? Okay, 25-30. The first speaker is John Vervale. John Vervale, besides being an old friend, doesn't need introduction. But for those who don't know him, I will mention that he's emeritus professor of law at Utrecht University, where he served as vice dean and director of research at the law school. He is the former president of International Association of Penal Law and has been visiting professor at several universities in Europe, in America, in the United States, and I particularly would like to mention that he's been visiting professor even in Trento and at Lewis University in Rome. I give the floor to John Vervale. It is yours.
Grazie Giulio per l'introduzione tanto gentile.
I didn't add that John Vervale speaks I don't know how many languages, including Italian.
Don't worry, I will give my my contribution in English as programmed. First of all, thanks to of course, to the law school and particularly to Gabriela for the kind invitation. It's a pleasure to be back. I'm still visiting here at the law school in Trento, but I will be back in November. I would say also congratulations for the very impressive program today. So I think we will learn a lot. I have a keynote without a title. That's a joint responsibility of Gabriela and myself. So I have to explain you what I'm aiming to do. I would like to assess the criminal justice dimension under the Lisbon treaties. So let's say from 2009 on until today. And of course, there are many topics that we'll dealt with more in detail. So I try to do that from a bird view, a helicopter view, and trying to highlight some points and trying to give you, let's say, an overarching view, at least from my perspective. That's a lot in a half an hour, but I just want to... I first of all would like to start with the treaties themselves, because they are the legal basis for criminal justice integration. So without the treaties, we are, of course, not walking at all. In my opinion, the treaties of 2009, when it comes to EU criminal justice, contain some big achievements. Of course, you will see later on in my contribution that I will getting more critical and critical, but I start with the positive points. I think the first one is that the integration of the criminal justice system into the European integration process has been a very difficult topic. And if you go back to the history, you go back to the Schengen treaties of 1985, 1991, the pillar construction under the Maastricht Treaty and the Amsterdam Treaty shows very, very clearly, because the Schengen treaties were not even community law, they were intergovernmental cooperation. We all know that the third pillar, which embedded also the EU criminal justice at the beginning, was nearly intergovernmental, although it was part of the EU construction. So this has, the member states were not very willing to transfer sovereignty, competence to the supranational building of the EU construction. So this, I think what is very important in the treaty that, and this comes from the draft constitutional treaty, don't forget that. The whole design of the Lisbon Treaty when it comes to the area of freedom, security, and justice, and the hardcore articles, articles 82, 89 of the Treaty on the Functioning of the European Union, is copy-pasted, nearly 100% of the draft constitutional treaty. I stress that because the draft constitutional treaty was an exceptional treaty, not made by governments, but made by a broader set of actors in a convention. So that means it was certainly the most democratic treaty that failed by democracy because there were referenda that rejected it. So that's also a big contradiction. But the content, at least for our area, did survive. Why do I stress this? Because from the Lisbon Treaty, we have applied to the criminal justice area, so substantive law, procedural law, etc., we have what I always call the community method. So the way of making of legislation based on the classic methodology in community law. That was, of course, in the treaties from the very beginning, from the 1950s. So that means the Commission is a big legislative player. It makes the proposals. Here in this area also, of course, it's co-shared with groups of member states. It's a co-decision with the European Parliament. It's largely based on qualified majority, etc., etc. And all the principles that have been developed as general principles of union law by the Court of Justice, supremacy, direct effect, all those things do apply. The community method is also applicable to criminal justice. That was before Schengen, Maastricht, and Amsterdam, certainly not the case. With this comes a series of consequences. If you accept that, that means that member states have to share sovereignty in the criminal justice area. And it's, of course, this area is of shared competence in the treaty. That means sharing sovereignty and transferring competence to the European Union is not only in a horizontal setting, it also has a vertical setting. as I said, supremacy of EU law or primacy of EU law does apply. So there is a horizontal element and there's a strong vertical element. Second, this will certainly come back in some of the contributions today. This shared sovereignty is used in what I call a functional territoriality. And of course, I'm referring here to the common territory of the member states within the area of freedom, security, and justice. So it's not only about the application of EU law and the domestic legal order, it's in a shared space, which is of common interest to all the member states, and of course also to the EU institutions. That brings, of course, with it a strong, at least it should bring with it, a strong transnational dimension of EU criminal justice. Not only, it has also a strong domestic dimension, but also a strong transnational dimension. So the common interest should be reflected in a common policy for a transnational approach in a common area. It brings also with them, and that's, I think, the second strength of the treaties of Lisbon, a common core of values. Of course, the adoption of the Charter of Fundamental Rights of the European Union as a binding instrument is very important. We still are not there that we can say the EU has access to the European Convention of Human Rights. This is still an ongoing process, as you know. But you see, also thanks, of course, to the case law of the European Court of Justice, what I would call a strong process of EU constitutionalization all over, and certainly also in the criminal justice area, with up and downs, and of course things that we can criticize, that's for obvious. The third thing I would like to underline as a big achievement is I think that the Lisbon Treaty strengthens this integration and institutionalization and regulatory process, not only top-down, so from the EU institutions to the domestic legal orders, but also bottom-up. That means that the national actors, not only the legislator, also not only, let's say, the parliaments, but of course the executive bodies, and certainly the, let's say, the actors in criminal justice, going from the police authorities, the judicial authorities, the judges, etc., their role as not only as a national actor, but as an EU actor has certainly been strengthened. And you see that, of course, in a lot of networks, not only in the legislative process, but you see that in a lot of networks, also enforcement networks. You see that in what the political scientist calls multi-level governance, etc., etc. So this interaction has become a living body. Are the Lisbon treaties perfect? No, for sure not. So I already start to criticize. I'm looking still at the treaties. Because you see in the design of the area of freedom, security, and justice, of course, you see some reminiscences of the old third pillar. So it's the classic method of the community method, but there are still some particularities that come from the past. Not all member states do participate. Some of them have opting outs. There is an emergency break, etc., etc., etc. A second thing that is a little bit astonishing is that the whole criminal justice policy from Article 82 to Article 89 is brought under the umbrella of judicial cooperation. If you look at the content of 82-89, I come back to that, this is of course very strange. It's of course easy to, I would say, to legitimize that we need to harmonize substantive criminal law in order to assist and to strengthen judicial cooperation. But this is, of course, it's a discourse. So the title, the umbrella, is strange for me, and certainly not what it should be. Third, area of freedom, security, and justice. These three concepts and the relationship between freedom, security, and justice, at least in the treaty design, is very unclear. And it was also an astonishing combination at the beginning as a new concept. And fourth, I think, and I will come back to that, in the design of the treaties, there is a very strong split or demarcation line between criminal law enforcement based on or in the area, and punitive administrative enforcement. Now think about the financial markets, etc., 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 the protection of the environment in the internal market. So you have in the internal market harmonization of punitive administrative enforcement, and you have in the area harmonization of, let's say, the criminal law enforcement, and the same for the instruments of cooperation, etc. It seems that from the treaty design, these are two complete separate worlds. In practice, of course, this is not the case. My second point, this area of freedom, security, and justice that could have been, which was a completely new political legal concept, did not remain a vague political concept in the treaties. From the very beginning, the member states and the EU institutions gave, I would say, body and content to this concept by elaborating, and that's quite astonishing, a criminal policy program for the Union and its member states, adopted by all authorities. That means Commission, Council, European Parliament, and also supported by the member states. Not only supported, also triggered by the member states. Executed by action plans, the level of the Commission, scoreboards that were extremely concrete, etc. And of course, I'm here referring to, let's say, 15 years of criminal policy under the Tampere program, the Hague program, and the Stockholm programs. If you look at these programs, you read through them, and you look at the action plans and the scoreboards, it's incredible what they have been doing there. Not everything has been, of course, implemented and executed, but they had a design, and they could agree on it. And of course, some things were very problematic, but that's something else. At least they had a policy. If you look at this policy, they were very ambitious. It's strange because, as I said before, they didn't want to transfer competence to the EU, but once they have the frame, they were very ambitious. Mutual recognition without harmonization. That's extremely ambitious. Free movement of evidence in the area. There's a lot of evidence in the program. Free movement of criminal evidence, as such, without harmonization. I call that very ambitious, maybe also stupid and naive, but that's something else. You also see, when you read through the three programs, I would say a learning curve. They did learn along the road that some of their presumptions or assumptions were naive and stupid. Already from the Hague program on, you see that member states started to recognize that mutual recognition without any harmonization in the area of criminal procedure and procedural safeguards was leading to the opposite of trust. So that there was a need to harmonize at least certain procedural safeguards to have equivalent standards. I call that part of the learning curve. And second, you also see that they have invested on not only on harmonization, but also a lot on the operational dimension in the area. And the exchange of law enforcement information. You see that in the programs come up at a certain moment what they call the principle of availability of law enforcement information. So you see new dimensions there. I stress this period of 15 years of criminal policy programs because you might know that today, under the actual frame of the Lisbon Treaty, we don't have such a policy program anymore. It seems that the EU institutions could not agree and the member states were not interested in it. So it's very strange. You see, as we will see, a very big achievement in the treaty, but from the Lisbon Treaty, but when it comes to the execution of criminal policy, they're not at home anymore. We have guidelines, which of course is not the same, and they're coming from one actor, if I remember well, I think it's the Council. And in fact, there is one concept in the guidelines, consolidation of what we have, and that's it. So that's the opposite of a lot of ambition. Let me zoom in on a couple of, I would say, main axes of this criminal justice area, and point out a couple of things. Let me start with the harmonization of substantive criminal law. So I'm referring here, of course, to Article 83, 1 and 2. What we see is, of course, if you look at the activity in this and the use of these articles, you see certainly Article 83.1. So in the field of the Euro offences, you see an impressive acquis. A lot of instruments have been adopted. Some coherence is not always easy, because you could say, listen, we have elaborated the European arrest warrant. In the European arrest warrant, there is a reference to a list of, I remember well, 32 types of behavior, of criminal behavior. You could say, okay, that should be harmonized, because this seems to be an area where we don't need a check on double criminality, etc. If you check the list of directives that have been adopted, and you check the list of the 32, they don't correspond. Some are in, some are out. Strange. So I call that lack of coherence. Of course, you could criticize certain instruments. Let it put under the umbrella of over-criminalization. In two senses, or that the EU has used competence. No, they have adopted instruments or want to adopt instruments beyond their competence. So doubts about the competence. I think the classic example, should the EU legislate on gender violence in criminal law? Is that hardcore EU criminal justice integration? Question mark. And a second dimension is that certain instruments, of course, are very far going in criminalization. I think a good example is, of course, the directive on terrorism, and with the criminalization of a lot of behavior that is certainly not corresponding to the hardcore criminal law, traveling to Syria and things like that, apology, etc., etc. Nevertheless, I think the list is impressive of harmonization of substantive criminal law under Article 83.1. And very important, I stress that, it's not only about transnational cases, it's also about domestic harmonization. So the harmonization of substantive criminal law is not limited to judicial cooperation and transnational cases, it's for everything. Article 83.2 is much more complicated. You know, that's the newcomer, it's harmonization. It's a use of criminal law for areas of policy areas that have been harmonized in the internal market. If you look, so there we don't have a list of Euro offenses. The Commission came up with a document, a policy document in 2011. So that's quite some years ago, indicating clearly the priority areas. What we can see there is quite a clear, the opposite of Article 83.1. It's, I would say, under-criminalization. There has been very, very few proposals based on Article 83.2 coming from the Commission or coming from groups of member states. The most urgent things that were flagged by the Commission has been adopted. I'm referring to counterfeiting of the currency, of the euro. I'm referring to the market abuse and insider trading, so in the financial markets, things like that. But there was a whole list of other areas of priority that were flagged by the Commission, for which there has been no initiative, legislative initiative at all. Not by the Commission and not by the member states. So this link between policies in the internal market and criminal enforcement has been very, very weak. The only exception is the very recent directive that have been adopted on the criminal law protection of the environment, which is, of course, a very important instrument with a very important content. I come back to that also in my conclusion. The second dimension is, of course, the harmonization of criminal procedure, which is a complete newcomer in the treaty. We didn't have that before, although there were some initiatives before, like the framework decision on protection of the victims in criminal proceedings, etc., etc. We can give a conference on the harmonization of criminal procedures, but what you see, and the treaty, of course, has also the wording is not extremely clear, because the treaty is, Article 82, is clearly referring, of course, to harmonization of procedural safeguards, both for suspects and victims and third parties, etc., etc. It is not referring, astonishingly, to harmonization of investigative measures. Think about interrogation, search, interception, all these things. There's no reference to that. Quite astonishing. If you need harmonization of criminal procedure, you would think also about the harmonization of the investigative measure as such. Nothing. Nevertheless, in my opinion, it comes back through a reference to, and that also will come back in the conferences today, admissibility of criminal evidence in proceedings. If you want to regulate, you have a legal basis for admissibility of criminal evidence. Of course, the evidence does not come out of the blue. It has been produced by investigative measures. So there is a strong link, and this link is not visible in the treaty. I'm thinking about my time. I go to the horizontal cooperation, judicial cooperation in criminal matters. To the third, of course, the third important axe. I think there are a lot of things that can be said here beside the classic instrument of mutual recognition for the judicial authorities. Because there are very different layers here. We could look at the police cooperation. There are many instruments, horizontal and of course vertical, but then we come to the agency and with Europol. But there are a lot of instruments also which are related to the horizontal cooperation, means police authorities of the member states. There are quite some instruments which are less visible, at least for the general criminal lawyer. I'm referring here to cooperation between the AROS, asset recovery agencies, the cooperation in the money laundering area, FIUs, and the financial intelligence units, etc., etc. So there are very different fields, of course, of cooperation that you can tackle here. But of course, the big hardcore, also very present in the program, is of course the renewal of judicial cooperation in criminal matters. So replacement of the old instruments, being the instruments of the Council of Europe, but also proper instruments of the EU that had been or that were developed under the third pillar of Maastricht and Amsterdam by this mutual recognition instruments. We have also there a very impressive acquis. If you look at all these mutual recognition instruments, there are quite a lot. And you could say they tackle all the phases of the criminal procedure or of the criminal justice as such, pre-trial, trial, and post-trial. So that's very impressive. But also there we have quite some problems. I would say the first, the coherence between these instruments. There are still today a lot of these instruments have been developed not under the Lisbon Treaty, but before. So that means framework decisions, for instance. So before the Lisbon treaties, and we are still discussing today in 2025, the Lisbonization. So the conversion of the older instruments into new instruments under the Lisbon Treaty. This is still very problematic. How the hell is that possible? Second, if you compare these instruments, of course, every instrument has been negotiated by the parties, by the member states, ad hoc. And then, of course, there are some common schemes, but there are also quite some differences when it comes to the approach. The authorities are not always the same. The refusal grounds or the ground for non-recognition are not always the same, etc., etc., etc. So if we speak about consolidation of the existing acquis, that's really a field where there's work to do. But it seems also very difficult to get there. Another criticism, and that's of course is directly, or that's directed to the member states, is that a lot of these instruments have been badly or not implemented by the member states. It is of course not the case for the European arrest warrant. It has been implemented, not always very well, but some of the instruments are nearly implemented. So that's of course also very astonishing. If this would happen in the internal market, the Commission would and does go to the Court of Justice after warnings, administrative warnings. Have you seen many infringement procedures by the Commission at the Court of Justice on bad implementation or non-implementation of these instruments? No. And it has been prepared. There are documents in the Commission that are listing the instruments that have failures of implementations, and the member states have been flagged, but no political action. This is a decision, of course, at the highest level of the Commission, not to provoke the member states. But the result, of course, is that they are not implemented or badly implemented. I'm looking at my time, Chair. I still have two axes that I want to tackle before I go to the conclusions. The agencies, the agencyfication. I will be brief on that because we have a whole panel on the EPO, of course. So I will say nothing about the EPO. But of course, a couple of points. First of all, we have a lot of agencies, meanwhile, in the area of freedom, security, and justice. If you look, speaking here of Europol, Eurojust, EPO, and others, of course, which are not part of the area but play a role, like Olaf. They're not part of the area, but of course they play a role in connection with this criminal justice dimension. Let's say their interaction is not always very clear. And I think this will certainly also come back when it comes to the evaluation, for instance, of the EPO in relation to Olaf. Their real powers, with exception, but even there, of the EPO, of course, remain weak, certainly when you compare it to the ambition of certain of these agencies. I still remember that when Europol was established, the aim of some member states, certainly Germany at the time, was to elaborate an operational federal police force. If you look at the text of Europol today, and of course its capacity, yeah, that's certainly not the case. It's an intelligence police unit. The same for Eurojust. The powers remain very modest, even if you compare it to the legal basis in the treaty to 85. Legal bases that have not fully been used fully by the legislator in the new Eurojust regulation. So I think lack of interaction or clarity of functions between the agencies, and for a couple of agencies, lack of real investigative powers. The second dimension, I would say, is that also astonishing, there is quite a problem with the embedment, if I may say it like that, the embedment of these agencies in the domestic level. Still today, there are member states that, if you go to their national legislation, these EU actors are not existing. How the hell is that possible? How is it possible that actors as Eurojust and Europol and even the EPO are not reflected in the domestic law? Still today, we have states like that. Third, so I'm just pointing out problems. Third, we have newcomers. Also there, and of course, I'm referring to the MLA, the Money Laundering Authority, because of course, theoretically is in the preventive side, but of course we all know that this borderline is not so clear. And the EU is also working on a new EU customs agency. As it stands, they say that it will not be an enforcement authority, an enforcement agency, but I don't believe it. We have seen the same with the discourse on the MLA. MLA, money laundering, customs, said that means these are agencies which are very much related to the internal market. And that brings me to my last point, under the agencies, the relationship between EU regulators and administrative enforcement and agencies in the area is also very unclear. They're also split. The external dimension, my last axe, then I go to the conclusion very briefly. I think this is maybe for the criminal lawyers the most unknown area. When I say external dimension, it's a dimension of the EU in relation to criminal justice and related values outside of the European Union, not in the area and in the internal market. Meanwhile, we have a lot of treaties between the EU and third states that are directly related to our criminal justice dimension. Of course, I'm referring here to treaties on exchange of law enforcement information. Very difficult story, because the values are not always the same. Think about data protection in the US and data protection in the European Union. We have treaties on extradition between the EU and third states, at least some third states. We have treaties on obtaining evidence, gathering evidence abroad, etc., etc. Of course, there is also a whole set of operational agreements between third states and our agencies. I think we are liaison officers at Eurojust, Europol, etc., etc. Very interesting area. It's also there, you can tackle a couple of questions. I just take one to be a little bit provocative. We go to the area of extradition. I can understand, of course, that the EU is saying, okay, we elaborate extradition treaties with the US, although this is not so evident. We elaborate, I don't know, extradition treaty with Canada or Japan. But what about China? If I look at the domestic level, it's quite astonishing. Some member states don't have bilateral extradition treaties with China, but others do. And some member states, I have here Spain, are extraditing massively Chinese citizens from Spain to China. Others don't want to have an extradition treaty. And we also have case law of the Court of Human Rights on extradition to China. I see here fully absence of the EU. And also, I don't see policy. Just, I flag this. Second point of the external dimension. It's not directly EU criminal law, but I think it's related to a certain extent. The EU wants to act in certain areas as a global actor. Political scientists calls it the Brussels effect. They want to export values, EU values, as global standard setters, as global values. I think the data protection regulation is a very clear example. We want to be at least the EU wants to be the standard setter for the world. And I think they have the same ambition with the artificial IA regulation of the EU. They want to export that. I don't know if this is functioning, of course, because there are conflicts on that, other values. But of course, this would also this has a certain relation, of course, with the criminal justice area, data protection and criminal justice, AI, of course, and regulation and what is forbidden and what is not forbidden, etc., etc. A third and last thing I want to mention under the external dimension is much more linked, I would say, to the internal market, but also to, again, to human rights. The internal market, of course, a lot of policies are market-driven. That's obvious. And they have to do also when it comes to external dimension with exportation and importation and quality of control, etc., etc. So we see more and more instruments of the EU that I would say come under the umbrella of market-driven policies and sustainable development and human rights accountability for corporations. I'm referring here to the timber regulation. I'm referring to illegal, unreported, and irregular fishing, EU. I'm referring to the dual-use technology. I'm referring to the recent directive on diligence for human rights diligence for corporations, etc., etc. So what you see is the EU is trying to elaborate responsibilities and liabilities related to the control chain of goods. And of course, with illicit acts that can also come under punitive administrative law or criminal enforcement. So I think that's also an important line of development. A couple of words on the conclusion, and I think more or less I'm in time. So first of all, I think that despite the big achievements that I have mentioned by the adoption of the Lisbon Treaties as such, I think there is quite a standstill on the use of this treaty. Several legal bases have not been used. Possibility of evidence, no proposal. Conflict of jurisdictions, no proposal. Article 83(2), very little activity. So standstill by non-use or little use, and also quite some problems with implementation at the domestic level. Second, the European Commission has tried by a new methodology to trigger, to activate some activity or to develop a certain policy for the coming years by establishing high-level groups. There has been several ones. There has been one on criminal justice, and some of you have participated in that. I did not, so I'm only voicing here what I hear. But I'm not so sure that what I have heard is really realizing even that consolidation. Take again the European arrest warrant. You should say, okay, there is some work to do, seen all the case law, etc., etc. Consolidate that. Even that seems a bridge too far. So very little ambition when it comes, at least what I hear, when it comes to the outcome of this high-level group. This is in quite some contrast with other high-level groups. And the high-level groups are not related to DG Justice, which should be the main motor of legislative activity, of course, when it comes to criminal justice. I'm referring here to a couple of documents. You see the Commission comes up with reports on an effective and genuine security union. I'm referring to a document of DG Home, which is, of course, dealing with internal affairs, on the title, A European Internal Security Strategy. I underline every time the word security. So it's not, at least in the title, it's not about justice, it's about security. But on the content, there's another story. And also I want to say some words on a recommendation, just to compare, of another high-level group on access to data for effective law enforcement. If I take the second document that I have mentioned, which is very recent, it's from April 2025, the Commission document, A European Internal Security Strategy. If you go through that document, and I cannot go into detail, but you see that everything that I have mentioned, harmonization of substantive law, agencies like the Customs Authority and MLA, access to data, to law enforcement data, operational cooperation, revision of powers of Eurojust. It's all in. So my conclusion is very clear. What should be in an agenda of DG Justice is hidden in a security agenda of DG Home. Let me put it in other words. The DG Justice agenda has been hijacked by security. When I go to this high-level group on access to data for effective law enforcement, which is a very technical group. So it's looking at, of course, at service providers, but also at communication service providers, the CSPs, at streaming platforms, the OTTs, etc., etc. They're dealing with data retention, with decryption, with exception to metadata, transfer of metadata. They're looking at cases like Encrochat and Sky ECC, and the title says it. Access to data for effective law enforcement. Hardcore of our area. If you look at, they propose a legislative agenda. With regard to legislative measures, the high-level group recommends. You cannot believe what you read there. It's a very far-going legislative agenda dealing with harmonization of substantive law, liability, responsibility, dealing with measures of criminal procedure. And I just quote one, because it's quite long, and quote this one, adopting minimum rules at EU level allowing for the mutual admissibility between member states of evidence obtained from lawful interception measures against non-cooperative providers, and providing for the admissibility also in case of the use of intrusive measures to the extent necessary to facilitate mutual recognition of judgments, judicial decisions, and police and judicial cooperation in criminal matters. That's also very astonishing. So the high-level group of justice, of criminal justice, has no ambition, but the ambition is elsewhere. If it will be realized, that's something else. My last conclusion is that what I have mentioned as the split, the full split between the area of freedom, security, and justice and criminal law enforcement, and the development of regulators and punitive administrative enforcement in the internal market, is not solved. And you see that at different levels. You see that at the levels of the cooperation between the agencies, but you see it also at the classic legislative achievements. I finish with that. If you look at the recent directive on the criminal law protection of the environment, it contains a lot, of course, of harmonization, obviously, of offenses and crimes. What about, and certainly in the environment, the harmonization of administrative irregularities and administrative sanctions, which are all over in the member states? Have you seen a text? No. Have you seen a proposal? No. Not from the member states, and not. That is not possible, not from the Commission. The Commission should take the initiative. Is this astonishing? Yes, because for the financial markets, we have a regulation and a directive. Regulation of the internal market, a directive of the area. For PIF, the protection of the financial interest, we have both instruments. For the protection of the environment, only criminal law. So you see there, the split remains a problem. Thank you so much. Grazie mille.
Thank you, John, for your comprehensive introduction. It's rather pessimistic. I believe we are gone to a deadlock, especially as regards criminal procedure, because it's much easier to introduce new crimes and new sanctions than harmonizing criminal procedure. Because, in my opinion, the states are much more jealous of their laws in criminal procedure than in other fields. It's easy to harmonize the connection of a cell phone. It's not so easy to harmonize admissibility of evidence, in my opinion. I will cut immediately. And there is another change because Lorena will speak as the first speaker on digital evidence and electronic devices. But this is very interesting, in my opinion, because it refers to the admissibility of evidence and investigative measures on this subject. Please, Lorena. Sorry, I didn't present. But Lorena Bachmeier is a special friend. I don't know how long we have been known. I don't know. I don't remember.
Since last century. Since last century.
Yes, of course. She's a professor at Complutense University of Madrid. She also, I didn't know, I saw in the internet, apart from a PhD in law, even a degree on political science. She is, of course, as a very known scholar. She has been visiting everywhere in the world. Is always traveling.
Essenzialmente non è tenuto.
Sorry?
Go on. Un fantasma.
And is also an international expert for the European Union in such position as chair the Special Committee on Transnational Organized Crime. That's all. The floor is yours, Lorena. Thank you.
Thank you very much, Julio. Thank you very much for the organizers to having me here. And thank you for the other speakers for being so generous. I mean, the ghost was already, when you mentioned, she has been visiting all over the world. Someone just was connecting to confirm it, no? So I hope they don't intervene again and ghosting me. And thank you for having me in this panel, because it's just a pleasure, not only a pleasure and honor. And I would say I feel the imposter syndrome. So everything I will say after this wonderful, comprehensive, deep presentation might be of feeling myself as a fraud because I don't have much else to contribute. So as much as I love you, John, I also hate you this morning, because there's no space for me anymore to just spark attention of this audience. So again, thank you, this university, for having me here. I have been visiting here, and I can confirm it's a wonderful, amazing university, and this absolutely stunning environment. I would start, I mean, I will be very short, and I'm sorry, just to change the order of the program. I have to make this e-world, e-connections that don't allow us just to be away for some time, but this, I couldn't say no. So at 11, I have to be leaving. I don't interpret it as being rude, sorry, but I will be as soon as possible back, because I'm very much interested also in the discussions and listening to your presentation. I would say before starting with electronic evidence and admissibility of evidence, I will say I share, I would say 100% of what John has just presented. If John did not introduce criticism, it wouldn't be Professor Verbali. So we already expected some criticism. But on the other side, I think we have to be realistic. No one expects an EU law to be a systematic, clear, comprehensive, and coherent legal system, because it's just the way it is produced. It cannot be systematic. We can strive to get some coherence, but believe me, those who have been experienced and been present in this high-level forum meetings, what we have witnessed also with regard to electronic evidence and this criminal policy John was describing just before me, I would say we found rather reluctance, resistance, opposition, distrust, and the question of against any kind of progress, at least in this area, towards more harmonization or more establishment of EU instruments, always kind of finding obstacles like what is the added value, what is we have procedural autonomy, and where is the subsidiarity of a European Union law, which I think these are very, very good and very sensitive objections to more advancing and progressing of a European Union law, but they need to be substantiated. Then there is need that the member states really get involved and really understand what is the procedural autonomy, what is the subsidiarity, and when I would say 100% of the academia is trying to present added value and empirical studies and a lot of reports the European Union is paying with taxpayers' money. I think the member states should at least be reading them to enter into a constructive criticism, constructive discussion. But our experience has been that there is none. There is none. So the signal, I wouldn't say pessimistic, because ever since I've been working in this area, it has been, no, European Union law does not exist. And we see that it has been it has been presented right now, an immense acquis, and it keeps on slowly, but advancing. What is important to convey the message when we talk about here criminal evidence, electronic evidence, and the area of freedom, security, and justice, is that it's not a kind of a side area. Of course, and we would be absolutely naive and stupid and if we would understand the European Union as something that is not essentially a common market. I mean, the economic value and the economic face of the European Union is what sticks together, what brings us all together to be kind of an, to survive as an international player at the geopolitical arena. But what is important to make understand the member states is that this market won't work without rule of law. And for the rule of law, it needs to be supported by a coherent justice system, precisely criminal justice system and administrative punitive measures and mechanism. So it's not a kind of saying we are the European Union is trying to steal more sovereignty from the member states in traditional sovereign areas like criminal law. No, it's that the criminal justice system, if we are not fighting correctly against transnational organized crime, and we are not fighting correctly against corruption, and we are not defending the judicial independence in a coherent, common way, there will be no rule of law and there will be no market, because there won't be any trust for investments and development in our economy. So, and this is what we are saying. It might sound naive that we are talking today about tiny issues on the development of Article 82 and Article 83, now that we are seeing that Europe is losing its key role in a defense area. I mean, the bombarding of in Iran or the war in Ukraine has put us into the arena that as a geopolitical actor, we don't have a say. And we don't have a say because first, we are not united. And second, our economies, as well as the legal framework development, you call it, John, as a still stand. I had written down the word of stagnation. Stagnation, or let's say slowly development. Before I start with the presentation, which I say, I mean, most of you know, but I would like to introduce the discussion and the debate, because I'm still myself trying to figure out if this makes sense. I'm convinced that it yes, but I want to make me understand why there is so much resistance in trying to move forward in a more harmonization, which seems to be coherent because it provides stability and certainty. And these two words are crucial for the economic investment and development. So being this said, I will move on to my presentation. I will make it short now that I count on the generosity of the both Michele and Michele Panzavolta to jump and change the order of the presentations. I was asked by Professor Di Paolo, by Gabriela, to talk about the electronic evidence and admissibility of electronic evidence. When we talk about electronic evidence, I'm not entering into the deep discussions of what is electronic evidence, if it's data, if it's information, if it's the tool, if it's the storage device, if it's whatever it is. I think the most reasonable approach is to say digital evidence, any kind of digital information is subject to become evidence at a criminal procedure. And why we are talking about digital evidence? Not because the principles are very much different than the other evidence, not because the rules of admissibility might be so different as the others, but because first, there are two salient issues. Because first, it is the evidence, as confessio was the regina prova in the past, digital evidence appears in 90% of the cases in some way or the other. And second, because the digital evidence, electronic evidence, is by nature, by definition, in most cases, cross-border evidence. So it has specific features that might interfere or affect the rules on admissibility of evidence. Being said this, I mean, when we need, my approach here is that we need common standards. common standards on admissibility of evidence. And as John put it, there is still the development of Article 82 in harmonizing rules on admissibility of evidence. Why hasn't this been done? You give me the answer, please, because I'm completely lost here. The objections are, this is a very complicated area. Okay, this is why we have been a lot of people studying this for several years and exchanging a lot of discussions because it's not so easy. But once we say it's very complicated, now let's get to this next step and how to overcome these complexities. Oh no, the pre-trial evidence in some countries, it's not admissible. In other countries, it's admissible. We already have an overarching principle set out by the European Court of Human Rights. We don't need this. No, this would interfere into the assessing of evidence. So putting it short, clear misunderstanding of the concept or the scope of harmonization on admissibility of evidence. There has been a traditional resistance by the member states in introducing any kind of legislation above their own territorial traditional sovereignty. What we have to understand is that the concept of sovereignty is not anymore what was understood when Jean Baudin wrote about sovereignty linked to a territory and to a population and certain cultural features. When we are talking right now, we are talking not only an area of freedom, security, and justice, we're talking also a common area of data. So digital electronic data flow without any kind of borders. And this has to be taken into account also when regulating. And the same, and territoriality in the past attached to a population, we would say as long as we have a European Union citizenship, yes, with different passports and yes, but we move around freely, more or less freely. This idea that we still have to stick to traditional concepts of sovereignty has to be kind of removed if we really want to create a common area of freedom, security, and justice. And we might be reluctant to create it because we still stick to the ancient ancien regime concept of sovereignty. And this is hampering an efficient fight against transnational crime, against cybercrime, against environmental crime, and you name it. So being said this, I mean, you know that this need of common standards and because of the increasing role of, as I already mentioned, of digital evidence, cross-border criminal evidence, and of course, the new dimensions, which will be addressed later by Michele on the obtention of digital electronic data from internet service providers, which changes also the level and the scenario of judicial cooperation, because the judicial cooperation will have to interact directly with private actors. So what we thought in the past that was a law enforcement, let's say, almost absolute monopoly in gathering evidence, this is something of the past. The main evidence is right now in the hands of private companies, private super tech companies, and they are able to handle it, and they have more mechanisms, more tools, more instruments, more means to process those data, filter those data, and apply artificial intelligence in filtering the data that the law enforcement really requires. But I'm not entering into that, Michele. I'm not jumping into your topic. I keep it very, very short right now. At the present moment, what we have is that we have different standards on admissibility. This brings obviously disadvantages to prosecution, especially in cross-border criminal proceedings. The EPPO proceedings and the EPPO people tell us all the time that there is high uncertainty. And what we have been seeing in the EncroChat case, you might say, yes, at the end, all the EncroChat encrypted and conversations, communications that were gathered by the joint investigation team, Dutch and French in France under French law, at the end has been widely admitted in all courts around Europe. But I tell you, the uncertainty was huge. And then let's say the standards of admissibility of that evidence is still under very much questionable parameters, if the defense rights have been complied with or not, and whether there has been really an effective possibility to challenge that evidence. I tell you that looking around the case law of different member states, there has been obviously a wishful approach to admitting that evidence, either by undertaking a balancing test or just by saying, if the European Court of Justice doesn't have anything to say against, why should we national courts? When we think of if we would think in terms of balancing tests and admissibility of evidence, I would say we should speak for it. I mean, putting into setting free 3,000 people that were detained in organized crime and drug trafficking would have been absolutely, to my mind, disproportionate according to the infringement that has been committed in intercepting or admitting evidence on EncroChat. But the rules are not there. The rules are not there. And what we know from the case law of the European Court of Human Rights, it's not only that infringement of human rights can be committed by disproportionate intrusions, interferences, and so forth, but also the very lack of legal provision. And if there is no legal foreseeability, this is one of the standards to provide for the European Court of Human Rights an infringement of the convention, and we don't have that. And so what we say, I'm talking very quickly because again, I tend to speak too much, and I'm not doing this morning. So, and someone is ghosting me again, so to to keep it short. To make it short, my position, as you know, is we need those common standards. There is first related to data retention cases, and then when we came up to the EncroChat case, already directly linked to criminal evidence. And when you see there, where those persons, are not in a position to effectively comment on the information, digital information and evidence, which originated in a field beyond the jurisdiction of the courts and which may significantly influence the assessment of the facts. These, I go on with the paragraph 44 of the judgment in the Advisev's case, this shall be excluded. And this is repeated again in the HK case of 2021. We are talking around 4 years ago. We already have this exclusionary rules of evidence when it says that this evidence shall be excluded when there hasn't been any possibility to effectively comment on this digital data and beyond the jurisdiction of the court or beyond the knowledge of the court. The use of such information needs to be excluded. How? By determining this is unlawful evidence, not using it, or directly causing it to be barred. Again, we find here the same provision as with regard to data retention. If the parties are not defense, is not in a position to comment effectively. And now everything relates about comment effectively. So this is the challenge at the European Union level right now, to provide not only for the mutual recognition, not only for the free circulation, movement of evidence, but that this is done with the possibilities for the defense lawyers to comment effectively on evidence, again, pertaining to a field of which the judges have no knowledge. So let's say all the algorithms, all the electronic files that come over, and they really don't know how this was obtained, how it was filtered, or if there is integrity, authenticity of that evidence. I'm skipping very, very quickly on what we propose on electronic evidence. As you see, don't start freaking out because I jumped almost most of the slides. And what we propose in this proposal of the directive, I had the honor to lead this study and to propose to make this proposal. Of course, it's not a legal proposal; it's a report, but with the form of a legal proposal to be presented. This is what we did. European Union Commission and discuss it with them. And I had the chance to gather a lot of friends and marvelous partners and academics and practitioners. So it's not just a whimsical idea we had one day and came up with this. Common standard, first of all, apply in transnational evidence the principle of lex loci. So at least we know that if lex loci has been complied, it should be admitted. Second, this should be applying also for punitive administrative proceedings. And the general rules is if the evidence obtained where it was executed, it should not be used. It should not be used in another country just because we cross borders. If it's illegal, it's illegal. And the legality, we should measure it upon the rules on the execution country. Problem is, where is the execution country when we come to digital evidence? And so we came up with the idea after a lot of discussion, the digital, we don't have a place where the digital information data is stored. So we cannot just apply the lex loci upon the principle where it is located. But so we linked it, lex loci, to the place of extracting the data, where the execution is done. So where these data are extracted from a computer or any other storage system, or where they are gathered through a remote device. This might be very, very unimportant, but it's important in practice to say, to introduce certainty in the lex loci principle. And since what is the problem and John mentioned it, there is no harmonization in investigative measures, so we have to apply the principle of mutual recognition. Principle of mutual recognition upon or without harmonization creates distrust. But this is not the case in digital evidence because this is new for every country. There is a long-standing traditional constitutional tradition over centuries how to provide and produce electronic evidence. And what we found out in the very interesting project of Bologna University and the device project is that they all apply the same standards, ISO standards, general protocol, forensic protocols, following Interpol protocols and Europol protocols on digital evidence. So why not establish those rules at the European Union level? I'm finishing here, and this is what we provided. That access to IT experts should be granted also for the defense parties, that there should be rules on a detailed procedure on the acquisition of electronic evidence, that it should be done as much as possible in front of the defendant, and obviously something that exists already at the national level in order to rely on the electronic evidence. This has to comply the principles of authenticity, integrity, and provide clear rules on the chain of custody. So I stop here. Thank you again for listening to me. Thank you again for inviting, and thank you again for jumping the queue. Thanks.
Thank you, Lorena. That's a real new perspective. In my opinion, it's not only on the technical rules for admissibility of electronic evidence, but we have also a change in our view of the criminal process and the admissibility of evidence. It's all changed now because what is evidence relating to electronic evidence, how much we can control authenticity, integrity, and chain of custody. Maybe we must reset our science of criminal procedure, if a criminal procedure is a science. Well, thank you. Now, the next speaker is Michael Luchtmann. We talk about the European arrest warrant not only in the perspective of speeding up the extradition procedure, but also, and most, I believe, in respect of the protection of human rights. Michael Luchtmann is a professor of economic and European criminal law and chairs the Wilhelm Pompe Institute for Criminal Law and Criminology at Utrecht University. And he is also co-founder of the Jean Monnet Network on Enforcement of EU law. I'd like to mention that in 2009, as a young scholar, he was awarded the Syracuse Prize for his book, European Cooperation Between Financial Supervisor Authorities, Tax Authorities, and Judicial Authorities. So he, as well as something to do with Italy and the Italian scholars. The floor is yours. Thank you.
Thank you very much, Chair. Good morning, everybody. Thanks for inviting me here, particularly to Gabriela, Luca, and the organizers. It is my first time in Trento, so I can already tell I would definitely like to come back. I want to give a presentation on the oldest instrument on mutual recognition, one of the oldest, at least, European arrest warrant, and also talk about the human rights dimension of it, which has become incredibly complicated. It took 12 years to get there, but once we arrived 2016, we see many courts struggling with this. I have some experience myself as a former member of the Amsterdam court, which deals with the surrender cases in the Netherlands, and now also in the Court of Appeal of Arnhem-Leeuwarden, where they deal with the transfer of prisoners. So and time again, you see how difficult it is for those institutions to deal with what the requirements are based on EU law. I want to start a bit with highlighting some of the differences between the traditional extradition laws and the new surrender law, but also other proceedings of mutual recognition. And then give my first appraisal, which in itself, as regards the approach towards human rights, is in principle positive. But what happens if you start studying again on the judgments that you have to present now? All of a sudden, everything becomes unclear again. So I will give you some of my doubts and also some of my concerns about the current approach of the Court of Justice, starting from in principle, a positive appraisal. And then I would like to conclude also with some points for the future. If we look at where we are now, I think if you look at the text of the framework decision of the European arrest warrant, at least it very much reminds of the traditional extradition treaties. Some things left the text, but others certainly stayed, not necessarily in line also with the principle of mutual recognition. You can see the development, I think, hugely impacted by the developing case law of the Court of Justice, where you see that there are now clearly moving away from traditional extradition law. And this was also highlighted in this Alchester case, the first one. There's a second one on the row, where the Court of Justice also highlights the differences between the intra-EU system and the system compared, for instance, to the United Kingdom. Within the EU, where we are now, is we have a clear rule of mutual trust, and the court always starts by highlighting this point. So, and it has indicated that on the basis of this principle, EU instruments basically implement two rules, you could say. The first is a mandatory recognition of equivalent standards. So even though we have our differences, we should always accept the standards of other countries as equivalent to ours. So that is a very fundamental rule that underlies mutual trust and also the rule of mutual recognition. Secondly, of course, there is in the EU instruments on mutual recognition implement what is called a rule of non-inquiry, meaning that you are not allowed as a executing judge, executing authority, to assess the lawfulness of whatever happened in the other state. Save, and that is critical, of course, for exceptional circumstances. John already talked about can we have mutual trust without approximation, and it was a mistake, I would say. Mutual recognition started off in 1999, but it was also recognized very quickly that there was a need to also introduce minimum rules, for instance, in the area of procedural safeguards, and it is always also what we see what has happened. So we have now the famous 6 directives. To the best of my knowledge, there are no new ambitions in this field at this time. But I think it is also important to say is that there was another semi-legislator active here, and that is the huge impact that the Court of Justice itself has made in the harmonization or approximation of criminal justice systems. And this is what you see particularly in the area of the European arrest warrant, because it is the Court of Justice that has been introducing rules on, for instance, the proportionality assessment in the issuing state. And this is what you don't see, of course, in extradition law. It is by introducing concepts like judicial authority and connecting it to judicial independence and proportionality assessment, including also the right to an effective legal protection. On the issuing side is where you see is that, in my view, the Court of Justice has made a major improvement to any system of transnational cooperation. And it has done so basically without a clear mandate. I mean, they use the concept of autonomous, a concept of autonomous EU law, and that is where they started to take away some of the major concerns, of course, of the European arrest warrant, particularly the proportionality of arrest warrants in a number of cases. By doing so, I think what the court has also done much more than in extradition law is highlighting the need for judicial dialogues between judicial authorities, not always courts. Some argue that it should be only courts. Also, prosecutors are engaged in this dialogue. And by doing so, there you also see a clear deviation from international law. And by doing so, they also put highlight or emphasis on the judicial function in transnational procedures. So they want the courts, the independent authorities to be able to give their own, for instance, proportionality assessment in a specific case. And there you see, for instance, the experience in the Netherlands, where we had quite some rigid legislation implementing, for instance, optional refusal grounds into mandatory ones, where we now see is that this is no longer allowed by the Court of Justice. So there you see they really want this emphasis on judges being able to do what they do, make an assessment, a righteous assessment in the specific circumstances of the case. Proportionality is one thing. Reintegration of the offender, for instance, is another very important one, which has been put on the agenda not by the member states, but by the Court of Justice on the basis of this principle of judicial dialogue. And then, of course, the really obvious question is when will the first points on human rights be on the agenda of the Court of Justice? As I said, it took quite some years, so it's quite interesting to ask what happened before. But ultimately, in 2016, the first case reached the court, as we all know, and it was the case of Araniosi and Calderaru, where we had to deal, or the court had to deal with degrading detention circumstances, particularly prison overcrowding, and the question whether you can surrender a person to a jurisdiction where we have this problem. The focus was originally on Hungary and Romania, and now we know it's all over Europe. So all countries have these issues, and that is also why it becomes quite confusing sometimes to deal with these questions as a judge, because you are constantly asking for specific guarantees, specific safeguards on whether this person will receive a fair treatment, which is to a certain extent very strange, of course, because it's sort of a coincidence that this person is to be surrendered, but all the others who are already sitting there in those systems don't have these guarantees or safeguards. But it is a system of European cooperation that has made this visible, and I think that is one of the, perhaps you could say, achievements if there is follow-up measures, of course. And since then, we now know we have a two-step mandatory test, which we have to do always. So there is no way of revoking the order or leaving one of the steps aside. In every human rights defense case, at least under the European arrest warrant, there is this mandatory test. And the first step of the test then reveals that there should be systemic issues. That is the best way of describing it. And the Court of Justice has, in the first cases, dealt with the situation when there were indeed systemic issues, like detention conditions all over the country, in Hungary, for instance. But later on, I can already reveal, is that the issue got a bit shifted away from that question. But under the first systemic issues cases, the court argued that we need this first step not to bypass the powers of the Council. We have the Article 7 Treaty EU system, where they can sort of more or less kick out some member states if they do not live up to the rule of law standards, basic rule of law standards of the EU. And the court said right from the start, we don't want this system to get bypassed by general refusals to surrender by courts. That is not their job. And of course, we should not forget is that these instruments are mainly instruments also to help prevent impunity. So as soon as you accept a general recognition, exception to the rule of recognition, the whole system would collapse. Later, we see is that the court more or less shifted more towards another reason, and that is we don't want, save for exceptional circumstances, that the rule of non-inquiry is bypassed. And there you see another argument rising, basically indicating that if a issuing state can no longer repair its own dysfunctionalities in the administration of justice, only then is the executing state allowed to refuse surrender, because then there will be no effective remedy. At least it is reasonable to assume there will be no effective remedy in the issuing state. But this was a third reason that came up gradually. So it was not already there in the first cases, but it came up particularly in rule of law, fair trial related issues. So always a first step, you have to take it. You cannot go right away to the second. But if you do reach the second step, then you have to make a specific assessment for the individual in the specific case. So there you really need to assess whether the systemic issues also have consequences in the specific case of this person claimed, for taking account, for instance, of his personal situation or the offense, the nature of the offense in question, or the factual context. And if you do have doubts, there it is where the executing authorities are required to enter into a dialogue, which is sometimes more easy than in other cases. You can ask for guarantees, for instance, regarding prison conditions, but of course it's much more difficult to ask for the same guarantees for instance, judicial independence issues, because what is the value of those guarantees then? What we have seen in the recent years is a expansion from absolute to non-absolute rights. We started with detention conditions. I think you can say that systemic attacks on the judiciary are to some extent also a very fundamental problem, although perhaps not an absolute right, but still affecting the very core of the area of freedom, security, and justice. But gradually, and you could, of course, wait for this, we saw the development for other pleas and arguments to enter the scene as well. For instance, the readiness to undergo detention, which is a quite different situation than systemic issues, of course. The right to private life and children, the GN case, as we all know, And now we have in the Alchester case, we also have questions on the retroactive changes in the systems of early release or early release conditional probation. If you look at these at the development, I think in general, I would be inclined to give a positive appraisal of what the Court of Justice has done. First of all, because I think it is to be kept in mind is that the European arrest warrant is also an instrument to prevent impunity. That's its core thing. So you need to be very sure to take away that effect if you have questions or concerns about fundamental rights issues. Secondly, I think what it's also to be appreciated is that the fact is that particularly in the Polish cases, so systemic attacks on the judicial independence of Polish judges, is that they were very reluctant to exclude Polish judges from the community of European courts. So, and I think that is one of the, perhaps judicial statesmanship types of arguments by indicating or by recognizing the dangers that the Polish judicial system was in, but at the same time is make very clear is that those who have powers to break that system open again should be kept into the system of European dialogues. And that is why they wanted to, they were very reluctant to exclude the Polish courts from the system by, for instance, recognizing systemic attacks on the judicial independence as a ground for recusal. It may be a bit too early, but also what we see in if you compare this system to the system of international cooperation, this system highlights, because of its intensity and the frequency of the cases that we deal, much more loopholes in legal systems in other countries than would have been the case under international law. Issues with regard to detention conditions were there already for a long time in all systems, but it really came to the agenda, I think, mainly also because of the European arrest warrant. And then, of course, the question is, so we now have it on the agenda, who is to take the next step? And that is where the legislator should come in, the high-level forum, it was already mentioned, but also that topic was on the agenda there, and you see the reluctance by particularly member states not to engage in binding rules on detention conditions, for instance. So in general, there is, I think, some appreciation for the Court of Justice, but of course there's also questions, criticisms on whether or not they are not being too rigid at the moment. And I have a number of issues there because the court's argument for a mandatory two-step approach is basically that those two steps do different things. So they assess different criteria. And I'm not quite sure if that is correct, but let's see, and we can discuss that later. Secondly, there is criticism possible because I think the argument that only systemic issues can be exceptional circumstances allowing for an exception to the rule of non-inquiry is too rigid in my view. We have an example of that later on. And thirdly, what we see is that there is a huge activity by executing authorities to try to get information on what happens in another country. And then ultimately, a person is still surrendered. And basically that is because it is almost impossible to make a really good and comprehensive assessment of the situation in another country while you are, for instance, in Amsterdam or wherever. Sometimes you get the answers and then they're not complete. You have to ask again. So all of this takes a lot of scrutiny and also patience by the executing authorities to do what they should do. And then ultimately the case is still surrendered. So that's a bit of a frustration by many judges, I can tell you that. So the fourth point of criticism is there is this huge shift of burden of work from issuing authorities towards executing authorities. And some people have called this the tendency from mutual recognition towards mutual supervision. I think is what André Klipp has called. And I think there is some attractiveness in that qualification. So we should go back a bit and focus once more on mutual recognition, not only scrutinizing each other. But then, of course, you need instruments that help you do that. Are the two steps really different? I think to a certain extent, yes, as long as you refer to exogenous factors. So there is some elements in the system that do affect a criminal justice system, for instance, general attacks on the independence, but they don't necessarily have an impact on the particular case. And for those circumstances, or detention conditions, the same, of course. And for those circumstances, I would say, well, yes, indeed, there is a different test. So what is this? The first level test, is there a systemic issue? And then secondly, will the person claimed be affected by this, yes or no? That there is a systemic issue will not necessarily mean is that this person will also be affected by it. There is a category, of course, where you see that this is not so clear and that there is overlap, in my view. And this is what you see in the second part of the slide, because systemic issues are sometimes also defined as certain groups of people. Could be the Roma in some countries, or people with a handicap, or people of a certain sexual nature. All of this clearly affects not all of us, but only a limited group of people. And there, I think it is not so easy to say that this is a systemic issue, or at least not is that there is also a second step necessary. And there I would argue is that in those conditions, perhaps you should take away or take out the second step. If you have a criminal justice system that is clearly targeting specific groups of people, why do you still, in the second step, need to assess, also based on the evidence adduced by the person claimed, that he or she will actually get this risk? So that is not clear to me, and I'm not sure if this is also in line with the Strasbourg approach, where you see this particularly in Article 3 cases. Sometimes, if an issue is so systemic and targeting such a specific group of people, you no longer need to demonstrate your individualized risk, because it is assumed, and then it is up to the authorities of the the issuing state to take away the risk, for instance, by giving guarantees or whatever. So in my view, there are certainly cases where there is this overlap between the two steps, and I think it should be recognized more than it is done now in the case law of the court. Secondly, what we have seen, and I said this already before, is gradually, I think the Court of Justice made a silent shift in approach, because the first cases on human rights were very much systemic issues. Detention conditions all over the country, systemic attacks on the judiciary all over the country. Those are really systemic issues, but gradually it has made the arguments on which it based the mandatory first step, so the systemic issue arguments, a mandatory requirement for all human rights cases. And there I'm not so convinced that this is a good approach. We have seen this already in the first case, the EDL case, where there was a person unfit to undergo detention, where you clearly see is that this detention situation is not a systemic issue, but it is clearly linked to the specific person. And there also the court accepted an exception to the mandatory two steps, you can say. The most prominent example of why I'm a bit unhappy with this very rigid approach is the case of GN, which I assume you know better than I do here in Italy. Of course, detention for a mother who has been convicted in Belgium for human trafficking for a sentence of up to 5 years with a young child and born in Italy, Italian citizen, and a second baby on the way. And basically the question there was, well, we are now not only surrendering a person who has been convicted of a criminal offense, but also her children who need care, for which we have constitutional safeguards. So to what extent should we surrender this person? The facts of the case are not very clear, so I'm not aware of whether this mother lived in Italy for long enough for a period. I think she already lived here, but I'm not sure if it met all the criteria. But what you see in this quite clear question was that the Court of Justice rephrased it into a systemic issue. And then it said, only if there are systemic issues in the conditions of detention of mothers of young children and all other categories mentioned in the quotation, then we have a situation, and then we should pass to the second step. And basically, I think this is totally besides the point, because even if the Belgian system in this case would be perfectly aligned, which it probably is, with all requirements taking for young children and mothers in detention, still you would have the option of a young child being forced to leave its home country to undergo detention of the mother in another jurisdiction. So I think the whole frame here of mutual recognition, this was the Belgian authority. We don't know whether all legal remedies were exhausted in Belgium, so that is a bit unclear to me. But it seems to me is that there should have been much more coordination, consultation in this system instead of framing it in terms of mutual recognition issue, where mutual recognition is the main rule and all other issues should be put aside. I think it's a totally wrong approach for cases like this. And there's, of course, there will be new issues here as well. But in this particular case, it was also clearly about the interest of a third party in this, the children of the convicted person. So not sure why only systemic issues. Should we not be able to refuse in other situations as well? Of course, accompanied also by mechanisms to deal with coordination, for instance, transfer the prison sanction of the mother to Italy. That would have also perhaps been an option. I don't have enough details on the case in this situation. So issues with the first step, also with the second one. And there you see is the Court of Justice does require all courts to be very vigilant, it says in one of the cases mentioned in the slide. They should be vigilant if there's arguments, claimable arguments of systemic issues, and then particular for the person claimed. But how do you do this? And this is what I mentioned already, because just from a practical reasons, courts hardly ever have time to make this assessment. It is quite comprehensive, but still they should be able, or they should do this. And then in most of the cases, this leads to unsatisfactory results, particularly in the Polish situation. Because even if you do pass the first step, which the Amsterdam court accepted, which was quite, I think, revolutionary already in October 2018. But later on, they made this the main rule. So the whole first step is by definition passed under the old Polish government at the least. But then the problems come back on the second level. Because here, and I think that is very rigid as well, the court asks for the person claimed to demonstrate the risk. Now, there may be some circumstances where you are able to do that, but particularly attacks on the independent judiciary, clearly you are not, because those are situations that exist out of the sight of the people. So to the best of my knowledge, at this stage, we had thousands of arguments like this in the Polish cases at the very least, and only 2 refusals. One in the Netherlands, because there was a document by some of the Polish officials basically confirming all the accusations against the Polish system. So a bias in this particular case against the person claimed. And there was a German case. But all other situations, I mean, basically the only thing you can do on the basis of this case law is reject the argument and say, well, there may be issues, but we don't find them substantiated enough to refuse extradition or surrender to, in this case, Poland. So if this is the case, you can ask yourself, why do courts have to be vigilant if it will almost never lead, in particular defenses at the least, to a refusal ground? So I come back to my, I come to my conclusions. I think in general, I think the EU system does merit a more stringent system of accepting grounds for refusal in surrender cases, if you compare it to, for instance, the international law system. And this has to do with all the efforts that have been done, particularly also on the issuing side, of strengthening it by including the proportionality test and all of that. So there is, in general, I think a good reason to keep this approach, particularly for exogenous reasons, as I call them. So not necessarily for endogenous reasons. However, I also think exceptional circumstances should be much more than only systemic issues. They can certainly be individualized issues as well, depending on the facts of the case. And again, the question is, what is the added value of the second hurdle if it is ever met, never met, I should say. So here we come back to a point that has been made a number of times this morning already. This is not a problem I think courts can solve. We are now in a system of mutual supervision. It is a added value of this system that it has highlighted deficiencies in all European systems almost, but now they should be repaired. So we should steer away again as much as possible from this judicial dialogue and improve the quality of the system. And for this, you need legislative interventions as well. And there you see that the EU legislator at this point is totally void of ambition, I could say. This goes for detention conditions. So why only improving detention for surrender cases and not for everybody else in a particular state? I think that's almost a question that doesn't have to be asked, but still there is no initiatives there. And you can, of course, give many other examples where you should see the same development here. So the system in itself has added value, but now it is time for others, I would argue, to take over and help improve it. And that is where we are now in a sort of a catch-22. And I hope that we will have some improvements in the next years, but I'm very doubtful that we will really have that improvement. Thank you very much.
Thank you, Michael. I just was wondering whether we can reach really system mutual recognition, and if we in Europe really share the same values. In Italy, for instance, we have a huge problem of prison overcrowding, which can put, I don't know, our system outside of the common European standards. That's the problem is strictly connected with what I mentioned before, the difficulty to reach harmonization in the field of criminal justice, and in particular in the freedom in the field of personal freedom. Anyway, thank you very much. It was very very interesting, your presentation. Now the last speaker of this session.
Can I also move so that the
Of course, yes. Of course you can.
I'm getting older and you're getting older. It's becoming more difficult for me to see from a distance.
Let me present Michele Panzavolta. Introduce, present. Wow, that's my English. It's always Well, Michele Perzavolta is a professor of criminal law at the Leuven Institute of Criminology. As we know, he has promoted several research projects in European and international criminal law and in comparative studies. And I remember that he was also a Marie Curie Fellow for the project Criminal Intelligence in the European Union, sorry. I must add that I'm pretty proud to say that he's an alumnus of the University of Bologna, Alma Mater Studiorum, where he graduated in law with a thesis in criminal procedure. Michele, the floor is yours.
Thank you, Chair. Thank you, Giulio. And of course, a very heartfelt thank you goes to Gabriella. I can't see her now, but I'm sure you're all witnesses here to the fact that I am very thankful for this invitation, of course, to Luca as well for the wonderful organization. You two make a wonderful team, and this is a great event. Thanks again. The good thing of coming last is that you're all very tired, and so this means that probably you will hopefully overlook many of the silly things I might say, and you hopefully will retain the joke that every speaker is supposed to make just before coffee break, that I stand between you and coffee break, and of course I will try not to spoil that coffee break, although I have quite some slides, so I'll try to do my best to stick within the time, or the keeping track of time. I should be done already. Jokes aside. All right, so I have to talk about cross-border exchange of evidence, and the title I was given moves from, speaks specifically of two instruments, the European Investigation Order and the European Production and Preservation Order. I will mostly speak of European, when I speak of European Production and Preservation Order, I will mostly refer to the European Production Order. And also I want to say from the very beginning that I will call it EPOC, because if I call it EPO, I have the impression that then people might understand EPPO and there might be confusion. So I don't know, it's about me, but I will use this final C, which of course stands for certificate. So European Production Order Certificate. But I think as acronym, it's nicer. And well, so as you see, the topics on my talk are quite, quite a few. I want to introduce this talk, and then, which I'm doing now, by the way, then I would like to go through the channels for exchanging evidence. Given the time, I'll probably go through that part very quickly. Then I want to say a few words on mutual recognition and evidence, and mutual recognition of evidence as opposed to mutual legal assistance, and what that is really so much better. Then a short appraisal of the European Investigation Order and the European Production Order, again, and Preservation, of course, EPOC, the differences and what they mean, some reflections for the future, which will, of course, include the big, I call it the harmonization elephant that we have in the room, which was mentioned already multiple times today. And which, of course, also should include the discussion on whether or not to exclude foreign evidence. And then I will have some brief concluding remarks. So there are, in fact, if we speak of circulation of evidence, and it was mentioned, this was a very ambitious plan at the beginning of the expansion of this area of freedom, security, and justice, pre-Lisbon. There are multiple channels, and they have already been at least here and there mentioned. I would make a major difference or distinction between the spontaneous exchanges where authorities have some information and they decide to share it with other counterparts from other countries. And these spontaneous exchanges, I also call sometimes are more informal exchanges. And the word informal might be misleading. I've tried to argue why I use the word informal in one of my recent articles. And I think the real reason behind it is that the rules for the sharing are very limited, in fact. And in most of these cases, they're mostly meant to protect sovereignty above all, and confidentiality, the confidentiality of evidence that maybe is relevant for the sharing country in particular. I will not go through this many channels. Of course, there are a number of formal rules and channels as well, and they are within the European continent, also instruments of the Council of Europe, because the Council of Europe was for many years the front runner. Of course, to start with the Mother Convention, the 1959 Convention, which then, of course, was, you know, the reason also for the European Union to step in and adopt in 2000 the EU Brussels Convention. To this day, I think 25 years later, a lot of the things we talk about are still contained in some form in that initial convention, and then they have been put sometimes in framework decision. Joint investigative teams, for instance, they were already in the convention, they were put there. They're also another way to share or collect evidence jointly. But of course, today's talk will in particular focus on these two: Directive 2014/41, EIO, the European Investigation Order, and the EPOC, the Regulation 23/1543. Now, what do they have in common? Why are we talking about them specifically instead of talking about all the other channels that I just mentioned? I think the reason we're talking about them so much, or the reason why they trigger our interest so much, is that they both are instruments of mutual recognition. Now, to be honest, we could start a discussion here as to whether the regulation EPOC is really an instrument of mutual recognition. I think I'm not going into that. If we have time for discussion, maybe we can. The proposal was very adamant. It calls it instrument of mutual recognition. In the end, there are refusal grounds. If you look at it, I think refusal grounds are maybe the most indicative element that we are in front of an instrument of mutual recognition here. Now, what is mutual recognition of evidence? And I'm saying here things that are very generic to some extent, and I apologize with you for this, but sometimes it's good to refresh the basis. And by the way, also a small further disclaimer, I have specifically decided not to go into the technicalities and intricacies of the two instruments. That would have taken me much more than the time that was allocated to me. So I hope you will forgive me, of course, if I'm going through a sort of a more general overview. So what is mutual recognition of evidence? Of course, it means that a mutual recognition, that mutual recognition is a request, or for some, an order really, that comes from an issuing state or also requesting state. And it is directed to a requested or executing state, to a requested in an executing phase, to recognize and execute a procedural decision taken in the first state. What it isn't, well, it isn't a means of mutual admissibility of evidence. I'm saying this because everybody understands that, but mutual recognition is intended as a faster and swifter mechanism for cooperation. But it doesn't mean that member states are accepting necessarily evidence coming from abroad. They are deciding to set their differences aside, yes, but not necessarily to set their exclusionary rules aside. Now, is mutual recognition so much better than classic mutual legal assistance? Now, this is a difficult topic in a way, because in extradition law, this is by far the case, I would say. If we look at how mutual recognition has improved upon the classic rules of extradition, we can say now there are direct contacts between judicial authorities. There is no more political scrutiny. There are no more bars related to political offenses. The control on double criminality have been relaxed. Very good. But in the field of mutual legal assistance, this had already been the case. I mean, the 1959 Mother Convention had already done that in so many ways. There were already direct, and even the protocols going in that direction. So what does mutual recognition in the area of evidence, what does it really do? I think this is really, when I was asking myself this question, this is really a tricky one in the end, because there is no change in the overall structure really from the mutual legal assistance regime. Maybe the only thing I can say is we now have a clearer indication, a sharpening of refusal grounds. They're kind of more clearly, more exhaustively listed than it was before. Before, you might recall, we have more general exceptions. For instance, the ordre public exception that we've done away with. So this is probably the kind of improvement that mutual recognition has brought about, as opposed to mutual legal assistance. But I wouldn't call it a seismic change or anything similar. At the same time, the second advancement maybe is the streamlining of cooperation procedures. This has been done also by means of very practical things like annexes, the forms. I know that everybody complains about the EIO form, and I've read the report on the 10th round of mutual evaluations on the European investigation order, but nonetheless, those forms have a very practical value. They allow countries to work together on the basis of a common blueprint. So this being said, and so having identified the fact that mutual recognition in the area of evidence is not that huge a change compared to the earlier rules. And in fact, I'm not going into the fact that to some extent, this was observed many years ago already. Some of the rules, for instance, of the European investigation order, they resurrect double criminality to some extent, which in large part had been removed in the Mother Convention, apart, of course, from the reservations the countries there could have made. Now, this being said, by means of a more general introduction, so what do we know now what the EIO and the EPO and the EPOC they're supposed to do? They're supposed to allow the mutual recognition of evidence. What are the differences between these two instruments? And they come almost 10 years apart. And there are significant differences. The first one is, of course, the legal basis. That's the most evident one, right? One is a directive, the other one is a regulation. Well, it is accompanied by a directive on the identification of designated establishments and appointment of legal representatives. Everybody knows in this room that, of course, one of the reasons for adopting the EPOC was not just to streamline the mutual recognition of electronic evidence or digital evidence, but also to overcome some of the territoriality issues that I think were partly mentioned also in the keynote of this morning, and the territoriality issues in particular with regard to ISPs, of course, and the possession of data by internet service providers. We know, of course, that internet service providers, they work in different countries. They're often multinationals. And so there is a problem there of localization of data and localization of ISPs and localization of procedural activities in consequence of this. So, of course, the EPOC is supposed to help in this respect. And it follows up, by the way, on the earlier Article 18 of the Budapest Cybercrime Convention, with which I'm sure you're all familiar. They have a different scope, these two instruments. The EIO concerns all evidence. It's an all-encompassing instrument, one could say. EPOC is a specialized instrument. It's only digital evidence. By the way, I keep thinking, but I believe you all would agree with me, that electronic evidence, digital evidence, or e-evidence regulation is misleading. This is not what it is. Electronic evidence is so much more than telecommunications data. And this is what we're talking about here, is telecommunications data. And I think it is important to say this because when we are speaking with categories, and I'll go back to this later on, the first problem of harmonization is harmonization of categories. So we have to be careful, even when giving titles in the end, that we do not overstep the boundaries of a proper categorization of different measures. Then there are different addressees, of course. The EIO concerns judicial authorities, and we all know what the concept of judicial authority here is, and it is certainly different from the EAW. The Court of Justice has made this clear in the Austrian case, Staatsanwaltschaft Graz. So it also includes the public prosecutor here. The EPOC concerns instead private companies, and in specific, we're talking about internet service provider. Now, allow me here to add one brief word on this. I have read in several places, and I've heard a lot of colleagues arguing that this is part of a more or a larger private enforcement trend, a trend whereby there is a partnership between public enforcement of private enforcement, or where there is a tendency of public enforcement to force or coerce private companies to help in the enforcement of criminal law. I have no doubt that this trend exists. But the EPOC is, I believe, the wrong example. And why is it, for me, the wrong example? Because in this case, the authority takes the initiative and makes very clear what the object of the request is. The authority is requesting specific amount of data. There isn't much discretion. There isn't much analysis that the private company is supposed to do. Compare that, for instance, with the policing duties in the Digital Services Act. Compare that with the general policing duties, even proactive duties that we have in that act and in other areas of European law. And there I find a lot of discretion that is given to private companies for prevention. I mean, of course, here there is an involvement of private companies, but by the way, the reason why in the epoch we have the involvement of private companies is also to avoid what would be an intrusion in the company itself, carrying out a seizure of the company or of the entire server of the company in order to get some relevant data. It's much easier if the company itself can produce the data. So I beg to differ on this point. I think this is not, of course, there is an involvement of private companies, but this is not as such a situation where private companies become involved and responsible to some extent of private enforcement as such. But of course, I welcome different views on this. Then there are structural differences on mutual recognition. In the European investigation order, a formal recognition is needed. There is still a form of exequatur that has to take place. And by the way, that's very clear from the very beginning, because the judicial receiving authority is even supposed to send out an Annex B stating I have received the request, which means now I'm ready to recognize this. In the epoch, instead, recognition can remain implicit. So there is an order that is directed to a company. Some have talked about an automatic form of recognition. Now, the ISP here receives the foreign order, also internal order, by the way, could be, but of course the internal order poses somewhat fewer problems than the cross-border order. So the ISP receives the foreign order directly and has to execute the order unless it decides to challenge the order. For more intrusive cases, of course, there is a possibility which was also introduced in consequence of the negotiations with the Parliament. There is a provision whereby the foreign competent judicial authority is also to be notified. In particular, we're speaking of traffic data, not only for identification for purposes of identification and for content data. And in this case, there is a possibility of an ex officio control. Nonetheless, this ex officio control doesn't necessarily have to materialize in a decision. The judicial authority can simply find no problem with it and can simply let it pass. Finally, there is a different logic here. The EIO is a comprehensive channel, and the idea of the EIO, this is of course also connected to the scope, but there is something more than just the larger scope. The idea of the EIO was, let's do away with the fragmentation that we had before the EIO, which was there. You might recall we have a framework decision on the freezing of evidence, we have a framework decision on the European evidence warrant, and so on. The idea of the EIO was, let's put all this into one instrument. Now, the epoch is again going in counter direction. It's saying this is a specific channel for the collection of telecommunication data. Now, I want to pick up on this because I think this is an important point. What are the advantages and what are the disadvantages of a general instrument as opposed to a specific instrument? Because this is the main difference in my eyes between these two. Now, the advantages of a generalized instrument, like the EIO, of course, flexibility. You can apply it to all situations, to all measures. One framework for all, right? You have that one annex, it's Form A, you send it out, and you're okay. It's really easy for practitioners to have one instrument. And now, when I participate in these high-level conferences, international conferences, or national conferences of very high level, I meet judges and prosecutors of incredible quality. And those judges and prosecutors, and I see here Gaetano De Amicis, who is one of the highest experts of judicial cooperation in Italy, they know judicial cooperation, the ins and outs of judicial cooperation, incredibly well. And they can master 10, 20, 30, 40 different instruments, no problem. And of course, when I see them, I admire them because I myself get lost at times instead in the intricacy of having multiple channels and multiple instruments. However, I happen also to conduct research speaking with some stakeholders who are not always specialized or as specialized as some of these judges and prosecutors. And they are not, I mean, it's sometimes difficult for them to manage the complexity and the plurality of channels, to having to use one instrument in one case and another instrument in another case. It is difficult. We need to consider this. We need to take stock of this. And this is not true only for evidence. This will be true also for the area of personal liberty. If we look at the Lisbonization of third pillar measures, which, and I also was, I'm also involved in the assessment that the Commission was running. And I interviewed practitioners on that front about the different instruments, you know, the transferring of sentences, the probation order, the supervision order. Some of them don't even know about these orders. They are not aware of them. There are too many. So multiple instruments can be really problematic from a practical point of view. And I know that high-level, highly qualified lawyers, such as, and I apologize, Gaetano, I keep coming up with you as the example, but of course, very few excellent people can master complexity, but they're not the average. And I think we need to take stock of the fact that we need to work with average lawyers like myself. I get lost very easily in this plethora of instruments, in this panoply of instruments. What are then the advantages of a specialized instrument? Well, the advantages of a specialized instrument are somehow visible, even if you can be critical of the instrument, but they're somehow visible in the epoch. The rules are tailored to the specific situation at hand. The rules can go more in depth when it comes to the issuing authority. The epoch makes a difference between what the public prosecutor can do and what the judge can do. You can also have rules that go as far as to set conditions for adopting evidence-gathering measures. You can say, look, for this type of production order, you must be conducting an inquiry for an offense, an investigation for an offense that is punished with at least 3 years, with a maximum at least 3 years imprisonment. I mean, you can be more specific here. Some harmonization is possible. Some harmonization is inevitable because the mere fact that we have chosen a specific instrument requires that we define the scope. And this has happened with epoch. We have some harmonization as to what, well, not electronic evidence, which is too big a word, but what telecommunications data means. We now have a clear-cut definition of subscriber data. We have a clear-cut definition of traffic data with the definition between traffic data and traffic data for identifying individuals, content data. This is a form of harmonization of categories, which is very, very important. Now, as to the point of implicit versus explicit recognition, what are the advantages of explicit recognition, EIO? Well, the judicial authorities, they must always positively assess the existence of the condition in all cases. Now, I come from a study where I must be honest with you, we have kind of realized that the control that execution authorities run is not really that strict. Personally speaking, we've had a big debate here. And for instance, my dear colleague and friend, Marcello Daniele, and we did the study together, he holds a different view. He believes that authorities should run a very strict scrutiny, even at the stage of recognition. I am in favor of a lighter approach. I think it wouldn't be a big issue if there was a sort of more, again, a lighter control on that front. What we hear from the practitioners is that oftentimes the control is fairly light, with few exceptions, of course. And so this is, of course, what happens in practice, but in principle, even if it is a light control, they must always assess positively all the conditions, and in particular, the fact that there are no refusal grounds. Also, they are confronted with the difference between legal frameworks. We know here in circulation of evidence, there is always the big issue. Is it Lex Loci or is it Lex Fori? The Lex Loci is the one you use for collecting the evidence in one country, but then you have to use that evidence in the country that has requested the evidence, the Lex Fori. The conditions can be different. The conditions for admissibility of the evidence can be different. Now, the assessment of the extent to which the two frameworks are compatible is done by judicial authorities. Private companies are not involved in this. Also, very important, if it's the explicit recognition allows for possible deviation from the Lex Loci framework, because then the issuing authority can request that a deviation be made at the moment of gathering evidence. In the epoch, this wouldn't be possible. Now, of course, we're speaking of collecting digital data from ISPs, so there isn't really much need to add additional safeguards. But I cannot entirely exclude that we could consider, for instance, a specific request of one country adding one additional safeguard. We don't have that, to my knowledge. Now we don't have the deviations from the Lex Loci framework, which again instead is a possibility, and a possibility that many consider a great advancement in the EIO, and which was also included in the earlier framework of the Brussels Convention. If I think of the advantages of implicit recognition, to be honest, I can't find many apart from the fact that it's very quick. There is no rubber stamping. It goes quick. It goes very quickly. We don't know. There is no recognition. We don't know if it's okay, really, but we suppose it is okay. there is no rubber stamping. This is one argument that is made also on the basis of the assessment that on a practical level, often there is some form, some say, of rubber stamping. And as I said, sometimes it's a lighter control. So people say, well, if it is a lighter control, then let's just make it implicit. You know, if you really have an objection with this as a judicial authority from the requested country, you will come up with it, and otherwise we'll let it go. So what is the future of mutual recognition among these two different options? Should we go for a generalized instrument or a specialized instrument, implicit or explicit recognition? And I'll be very honest. I think that there are limits as to what implicit recognition can do for us. It's difficult to generalize implicit recognition beyond the area, or much significantly beyond the area of telecommunications data. I think it would be difficult. Maybe it can work, or it could work more in general for pre-existing evidence like documents, for instance, but certainly not for any situation in which the content of the information collected is affected by the way it is gathered. For instance, think of testimonies, right? You cannot think of, at least at the level of integration in Europe that we have now, I cannot think of a judicial authority sending out a request to interview a suspect, and then the police of another country, they go and interview without any judicial control. I think this is simply impossible, not least so because you want to make sure there is a form of judicial supervision also on the interview itself. So I think if we need to change something, the things we really need to work on, that's the EIO. I think that's the generalized instrument, which offers ease of use, of course, although we all know what the problem there is. It lacks on the side of harmonization, unless it is accompanied, of course, by some rules for some specific measures. And here I go, and I don't have much time left, so it's just a couple more slides. Here I go into the big harmonization elephant in the room. Everyone knows mutual recognition does not require harmonization. It was actually introduced upon suggestion of the British delegation at the time, because in order to avoid harmonization. Though, of course, the absence of harmonization was mentioned is a problem. By the way, the absence of harmonization is a problem for fundamental rights, not for efficiency of cooperation. If we look at the EIO works beautifully in terms of efficiency. Yeah, okay, there are still some situations where authorities are late and slow in responding. Yes, there are still some situations where authorities do not understand each other. But we have had these situations even with the old derogatory letters, and I think everybody would agree that the situation has by far increased with the European investigation. However, a very swift recognition can be a problem if there is no control for fundamental rights. So sometimes the fact that we don't have a lot of refusals in the EIO, we don't have a lot of cases of exclusion of evidence, this is not necessarily a positive thing. This doesn't show, as a lot of stakeholders told me during my interviews, oh, this shows that the instrument works well. We don't have problems. Yeah, but maybe we should have problems. Sometimes not having problems is the problem when it comes to fundamental rights. And so mutual recognition, I say this because this is, of course, the problem of harmonization in the end. And I don't think mutual recognition instruments are incompatible with harmonization. By the way, if we look at Chapter 4 of the EIO, there was there, for the specific measures, a small attempt to a small, very cautious harmonization. So, of course, in the epoch, harmonization is much more significant, but again, very limited to one specific area. And here I go back, of course, to the problem. Harmonization remains the big challenge. And the challenges, and I go back to this, they lie not only in the fact that it's difficult to set conditions for the taking of investigative measures. The first and biggest challenge lies in agreeing upon common categories. I mean, it is not a case that in the latest judgment of the European Court of Justice on Sky ECC, the court has to talk about what the concept of interception is, and whether it does or it does not include the hacking. I mean, that is a sign that that's the biggest issue. The biggest elephant in the room is that we like our categories, even more so than the conditions protecting our rights. And we have a panoply of national concepts. And there is another problem with harmonization, that there are some black hole categories. And again, I go back to the decisions of the European Court of Justice in the English cases. Evidence already in possession of the requested state. That's another black hole category, because that category supersedes the fact that that evidence has been collected by using other measures. And the court there gives an answer, which I don't know if it was the only answer possible. It says you don't have to control how that evidence has gotten into the possession of the state. But of course, that's a big problem. If we harmonize, but then we leave some bypassing categories on the side, well, then our harmonization efforts will be idle. So, can we harmonize if we harmonize exclusionary rules? I think we should harmonize categories. If possible, we should harmonize conditions. I am more skeptical about the harmonization of exclusionary rules, or at least I haven't really entirely made up my mind about it. Of course, I respect the effort of Lorena. Her project, by the way, goes not only in the direction of harmonizing exclusionary rules, but also in the direction of harmonizing categories and standards. But should we harmonize those? I think we have a very different approach between countries. We have countries that have a very strict approach. For instance, in Belgium, the Belgian authorities in principle should control the foreign authorities that they have applied their national law correctly. So the Belgian judge should, or prosecutor, depending on who starts to make the assessment, normally the judge, of course, but for some investigative measures, it could be the prosecutor, but they have to assess whether, for instance, the Spanish authorities, they have complied with Spanish law. Of course, this is very problematic, but it's very strict. On the other hand, we have more principled approach where countries say, well, or more relaxed approach, we're going to check foreign evidence and the legality of foreign evidence only insofar as this is compatible with our general principle, the general principles of our country, or, as it was said by the Hogerad, with the general principles of the European Court of Justice, or the European Court of Human Rights, I think, by referring to the case Stoichkov there. But there is, in the end, after we've said all of this, there is a general tendency, of course, to refrain from excluding foreign evidence. And I think I've taken here the Hogerad example on the Encrochat case, because I think there the court was very outspoken in some points, even though in the end reached somewhat milder conclusion whereby some form of exclusion can still be granted because, of course, fairness has to be controlled. But the court said, well, it kind of moved from a presumption of legality of the evidence coming from abroad, because we have to trust each other. And here I go back to the point. That's not mutual recognition. Mutual recognition is not mutual recognition of decisions to admit evidence. It's mutual recognition of decision to collect evidence or to share evidence. But even if we agree on an approach, even if an harmonization was possible, and again, I'm still doubtful, because maybe instead of a top-down approach, we codify the exclusionary rules, maybe a bottom-up approach, which is the one that is already surfacing. The Court of Justice, the European Court of Justice, or the European Court of Human Rights, they setting standards for exclusion of evidence. Maybe that could be an approach as well. I'm not against judicial discretion, as most of you know. But there is a fundamental problem here. And the problem is, you can assess evidence, and even more so foreign evidence, only if you know how it was collected. You need to know something about it. And the truth is that today, we don't. And we don't because if you look at the EIO, look at the rules for the transmission of the evidence on the EIO, and you tell me whether there is a standardized way for sending out the results, for sending out the evidence. We have a standardized way for asking, but we don't have a standardized way for giving. And the fact that we don't have this means that the issuing authority receives the evidence, and oftentimes they don't know what has been done in the executing state. And the defense, they cannot challenge. How can they challenge if they don't know? So those who can afford to talk with lawyers from abroad and maybe find out whether there was a problem with the file, what are the rules in that country, maybe sometimes they can raise a challenge, but otherwise it's almost impossible. And it's difficult to have controls. By the way, I could start here a whole new discussion on this, and I won't. But knowledge is a problem. Now, we have proposed in our project, and I think this is a proposal I want to put forward here again before I conclude, that there should be more transparency on this. And so there should be a list of forms where the authorities are required to, the executing authorities are required to clarify what they have done on some minimum indications to the extent that this gives transparency and it allows for some control on the legality of the evidence on the receiving end. So, to conclude, I think the mutual recognition of evidence is still in flux. And we have conflicting philosophies even, because of course we have a new instrument which doesn't entirely follow the earlier instrument. I think, though, that I would rather like to treat the epoch as the exception. It goes well for telecommunications data. Let's leave it there. I wouldn't generalize that. I would consider more tweaking or restructuring the European investigation order and the framework of mutual recognition that we have there. Of course, tackling the elephant, the harmonization elephant in the room. We need to restructure the EIO, moving towards an EIO 2.0, where we have a clear sequence of controls. I haven't talked about this, but recognition of EIOs is often done outside of an adversarial setting. The defense, they don't know, nobody knows. Sometimes it's fully confidential because investigations are secret. This can also be problematic. I know this is not the case in Italy, but this is the case in other countries. So clear sequence of controls and a clear identification of who is tasked with what. Some more harmonization on the categorization of investigative measures would be necessary, and this is also the conclusion of the 10th round of mutual evaluation, which the Council on the European investigation order, which the Council has just concluded. Some more harmonization, of course, on the conditions for some of those measures. Here we can take inspiration from the epoch and maybe from the case law of the European Court of Justice on data retention. And of course, more transparency in the communication of what has happened in the requested member state. Because evidence is not just information. Evidence is a legal product which embeds fundamental rights. If we look at evidence as only information, I'm sorry, but we're not protecting fair trial rights. Thanks a lot.
Let me compliment Michele for his presentation, brilliant and thorough presentation. And what I can say that his presentation made clear in my mind what I had inside it without knowing. The difference between specific instrument or general instrument is fundamental in my opinion. Because the law of evidence is a specific treatment by the law of specific instruments of piece of evidence. So if you need to generalize every information you said is good for the process, for the trial, it's not even a trial. Thank you very much. Thank you, and thank you to Gabriella. I would like to compliment even Gabriella. Just 1 minute.
Go on.
No, I just wanted the audience already said that I would like to compliment for the high level of this session, at least of the conference in general, because it sticks with the foundation of University of Trento since the time of Rodolfo Sacco, which I had the privilege to meet many years ago.
So good morning. The foreign guests have maybe left the room in partly, but I agree. Yes, there's John Vervale for all of them. Thank you. Thank you, first of all, to Prof.ssa Di Paolo and the Law School of Trento. And I will speak in Italian, you know, in this part of our conference, because the Italian perspective is at issue. And this session is especially dedicated, devoted in memory of Professoressa Maria Riccarda Marchetti. So I think it's better to speak in Italian. First of all, for remembering Maria Riccarda, lo faccio in italiano appunto, volevo ringraziare, stavo continuando in inglese, ma ho capito che non era conseguente rispetto a quello che ho detto appena prima. E devo dei ringraziamenti per il patrocinio innanzitutto dell'EDP, lo faccio a nome mio personale, del presidente del gruppo italiano, e perché in questa sessione in particolare il patrocinio dell'EDP è significativo, vista la partecipazione della professoressa Marchetti da sempre alle attività dell'associazione stessa, ma devo anche ringraziare per il patrocinio dato dall'Osservatorio alle misure di prevenzione della Fondazione Gulotta e, non ultimo, certo, la Camera Penale di Trento, Michele Pompermeier, attraverso l'avvocato Bertuol, che ringrazio, era già intervenuto all'inizio, ma voglio segnalare che è stato dato il patrocinio proprio a segnalare l'importanza, a mio avviso, non così formale, ma sostanziale, decisamente sostanziale di questo incontro. Questo incontro, un incontro di alto livello, l'abbiamo già visto attraverso gli interventi della prima sessione, di alto livello non solo per il rango dei partecipanti, ma per quello che hanno detto. E in questa seconda sessione decliniamo un po' nella prospettiva italiana i temi che sono già stati, come dire, delineati nella prima. E però proprio qui cade il ricordo della professoressa Maria Riccarda Marchetti, che è stata un importante protagonista della vita scientifica italiana e della divulgazione scientifica italiana in questo settore, oltre che importante trade union con le istituzioni internazionali. Da sempre, che io ricordi, membro dell'Associazione Internazionale del Diritto Penale del Gruppo Italiano, ci siamo incontrati in tante occasioni nei convegni, nei congressi internazionali, a partire quantomeno da quello di Istanbul del 2009, per quanto mi riguarda, ma lei partecipava già da prima. E la professoressa Marchetti va ricordata in questa sede perché, insomma, lei era consapevole e rappresentava al meglio anche la condizione di chi di chi studiava questi temi nel panorama italiano, eh, almeno fino a non molto tempo fa, e cioè la condizione di far parte di un gruppo di happy few. Happy few perché la crema, perché l'elite, perché il meglio, ma nello stesso tempo anche pochi happy few, quelli che probabilmente perderanno la battaglia o che comunque sono in forze molto molto ridotte. E perché la condizione di questa disciplina era esattamente questa. Necessitava uno sguardo ampio, cultura non solo strettamente tecnica, tantomeno tecnico-giuridica, ma poi serviva anche la competenza specifica tecnico-giuridica di un livello non primario, perché sono concetti sofisticati, quelli della cooperazione giudiziaria internazionale, ma nello stesso tempo anche la sofferenza per vivere una condizione di poca considerazione nel campo scientifico, accademico, delle singole discipline, sicuramente dei contesti nazionali, perché appunto questo contesto diventava estraneo. E c'era quindi lungimiranza nel coltivare, dedicandosi a questo da parte della professoressa Marchetti, esattamente guardando questi temi, c'era molta lungimiranza rispetto a quello che sarebbe poi accaduto. Oggi questi temi non c'è studioso giovane che guardi al proprio futuro e al futuro, alle prospettive della materia, soprattutto processualistica, che andrà a coltivare, che non consideri in modo primario questo tipo di argomenti. Certo declinati poi rispetto a prospettive specifiche e specifici problemi, ma lo sguardo è certamente più ampio. Inutile dire quali sono le ragioni, anzi io ho il dovere di essere molto molto conciso. Sappiamo l'evoluzione delle cose, qual è apparso già dalla prima sessione, sta nei presupposti delle nostre conoscenze e nel contesto che noi viviamo ogni giorno. Vorrei soltanto ricordare alcuni momenti essenziali della attività, della carriera della professoressa Marchetti, che era sempre, se dovessi parlare ancora in inglese, direi invisible but available, era sempre in secondo, mai protagonista formale, ma sempre presente, sempre punto di riferimento importante. Una delle occasioni che ha visto non solo me, ma anche alcuni colleghi presenti qui in aula, insieme vivere dei momenti importanti di collaborazione con la professoressa Marchetti, è stato quello dell'esperienza della commissione ministeriale che ha avuto il compito di attuare la delega in materia di attuazione appunto dell'OIE, dell'Ordine Europeo di Indagine, ma anche di riformare il libro 11 del Codice di Procedura Penale. E sappiamo che era presente Michele Caianiello, è intervenuto dopo anche Andrea Benegoni a un certo punto. Di quella commissione, in quel momento il capo del gabinetto al Ministero era Giovanni Melillo, quindi possiamo dire che c'era attenzione su questi temi. Ma la professoressa Marchetti allora era già esperta da tempo, non a caso lei presiedeva la commissione di cui venimmo a far parte. E fin diciamo, dai suoi esordi lei si era sempre occupata di questi temi. È inutile qui ricordare, o comunque è superfluo ricordare le sue monografie, sia quella sull'estradizione, sia quella successiva sull'assistenza giudiziaria, le sue collettanee, soprattutto quella insieme alla Greca, mi pare del 2003, sulla cooperazione giudiziaria, in un momento particolarmente importante per le rogatorie, in particolare sulla legge italiana di quei giorni. Ma ancora prima la sua carriera era stata scandita da una monografia sul terrorismo, sulla cooperazione giudiziaria e terrorismo penale, terrorismo internazionale. Pensate, in un momento in cui invece il terrorismo era quello propriamente internazionale, era ancora, parliamo degli anni '80, era ancora lì da venire. C'è oggi presente anche un allievo della professoressa Marchetti, il professor Barrocco, a simboleggiare anche la presenza sua e del suo magistero per quanto riguarda la nostra formazione e la nostra esperienza. Io mi fermo qui perché ho già parlato troppo e quindi ribadisco con quanta stima e affetto retrospettivo noi guardiamo alla professoressa Marchetti, e a cui meritoriamente questa sessione del convegno è dedicata. Andiamo adesso al programma. La prima relazione è sull'ordine europeo di indagine nella giurisprudenza della Corte di Cassazione. Nomen omen, in un certo senso, perché il consigliere presidente, anzi direi presidente della sesta sezione della Corte di Cassazione, è uno dei massimi esperti, è stato accennato anche prima, della cooperazione giudiziaria internazionale nel nostro ordinamento, ma non solo perché fa parte di una sezione che si è sempre occupata di questa materia per competenza, ma anche perché lui stesso è cultore, attraverso come testimoniano diversi lavori scientifici, è cultore di questa disciplina, nonché parte importante di una svolta, diciamo, significativa della nostra giurisprudenza a sezioni unite, perché sono partite dalla sesta sessione, da sua ordinanza di rimessione alle sezioni unite, appunto, le vicende, le questioni che poi hanno dato luogo alle sentenze cosiddette incrociate. Quindi, con grande piacere, passo la parola al Presidente De Amicis per la sua relazione. L'invito naturalmente a tutti è di attenersi ai limiti che sono di tempo, perché siamo leggermente in ritardo. Io ho contribuito pure, mi rendo conto, ma mi scuserete. Però io, come presidente di questa sessione, nonostante abbia razzolato male, devo predicare bene. Quindi prego, Gaetano, a te la parola.
Grazie al professor Raparaci per le parole che ha detto, grazie alla professoressa Di Paolo per l'organizzazione di questo importantissimo convegno che ci dà modo di riflettere su tematiche di grande rilievo e che ci affaticano ormai da tempo. Mi unisco anch'io con commozione al ricordo della professoressa Marchetti che poco fa ha fatto il professor Rafaraci, sentimenti di affettuosa, di ricordo affettuoso mi legano a lei, di amicizia. A lei si deve tra l'altro un contributo fondamentale per l'attuazione nel nostro ordinamento della direttiva sull'ordine europeo di indagine. In tanti convegni abbiamo avuto occasione di confrontarci e il ricordo della sua figura ci accompagna sempre. Il problema dell'ordine europeo di indagine è un problema che ci mostra in pieno l'attuazione della direttiva dell'ordine europeo di indagine, ci dà in pieno il senso di uno scollamento tra esigenze di tutela dei diritti fondamentali e esigenze di efficienza dell'investigazione ai fini della raccolta transnazionale delle prove. È una manifestazione concreta questo strumento del principio del mutuo riconoscimento nel settore dell'acquisizione transnazionale delle prove ed è uno strumento di cooperazione nuovo, di nuova generazione, che ha consentito di superare il sistema rogatoriale, presupponendo un dialogo diretto tra le autorità giudiziarie nel rispetto, così si dice nelle premesse della direttiva, del diritto dei diritti fondamentali, alla luce del principio di proporzionalità che governa come fondamento invisibile di questo nuovo strumento di cooperazione le modalità di raccolta della prova all'estero. La giurisprudenza italiana su questo tema si è sviluppata con una certa lentezza. L'attuazione dello strumento ha visto una serie di pronunce con qualche contrasto sul tema della opposizione, ad esempio, ai decreti di riconoscimento di ordini di perquisizione e sequestro che giungevano dall'estero e sulle possibilità di impugnazione nel nostro sistema legate a queste forme di cooperazione. Si è potuto registrare nella prima fase di attuazione di questo strumento una certa difficoltà nei pratici del diritto, quindi avvocati, magistrati, una difficoltà legata alla comprensione di questo strumento nuovo e anche al coordinamento di questo strumento con tante altre misure, con la Convenzione europea di assistenza giudiziaria, con le decisioni quadro, poi direttive sugli ordini di congelamento e sequestro di elementi di prova raccolti all'estero, con gli ordini di confisca e così via. Non è facile comporre le tessere di questo mosaico che riguardano l'acquisizione della prova all'estero nelle sue varie declinazioni. L'ordine di investigazione europeo certamente è stato un volano potente, un elemento importante di rinnovamento, pur con i suoi limiti, come vedremo. E una delle vicende che ha consentito di testare appieno le difficoltà legate all'attuazione di questo strumento è quella che ha riguardato le attività istruttorie sui cosiddetti criptofonini e sulle piattaforme criptate operanti all'estero. Abbiamo visto, in un caso importante, il caso Encrochat e Sky ECC, come le attività istruttorie invasive, tecniche di investigazione particolarmente intrusive, si siano articolate nella pratica con la copertura del segreto di Stato e abbiano consentito di intercettare, acquisire, decodificare una mole enorme di comunicazioni che poi sono state convogliate su queste piattaforme criptate, consentendo di decifrare milioni di messaggi riferibili a decine di migliaia di utenti dislocati un po' in tutto il mondo. Per captare questa messaggistica sono stati infiltrati server e criptofonini attraverso 4 diverse chiavi di cifratura. Le autorità di contrasto francesi, che hanno operato in una squadra investigativa comune, assieme alle forze di polizia olandese e belga, hanno acquisito questi dati, che poi sono stati trasmessi ai vari Stati membri interessati attraverso proprio lo strumento dell'ordine europeo d'indagine. Ho descritto in estrema sintesi ciò che è accaduto, non me ne vorrete, le questioni sono estremamente più complesse, ma la linea di sviluppo è questa. Sta di fatto che la raccolta di dati di così enormi dimensioni ha sollevato enormi interrogativi in tema di tutela della privacy, di validità delle prove digitali, di compatibilità dello strumento operato con le regole del giusto processo e soprattutto con il diritto della difesa e del contraddittorio. Questa infiltrazione operata dalle autorità francesi è stata ritenuta legittima in Francia. Questo è un dato di partenza inequivocabile. Questa modalità di infiltrazione è stata ritenuta legittima fino, nonostante varie contestazioni e eccezioni, è arrivata fino alla Corte di Cassazione francese che l'ha ritenuta compatibile con il proprio ordinamento. La trasmissione di questi dati e l'acquisizione di questi dati nel nostro ordinamento ha creato problemi, perché occorreva verificarne la compatibilità con le regole del nostro sistema. Fino a che punto modalità di infiltrazione in server e anche in criptofonini riconducibili a queste piattaforme poteva ritenersi legittima nel nostro ordinamento. Problema che ha investito non solo il nostro sistema, ma il sistema olandese, il sistema belga e il sistema tedesco, che ha rimesso una questione importante alla Corte di Giustizia che si è pronunciata, come sapete, nel 30 aprile del 2024, con una sentenza rilevante che poi esamineremo. Sta di fatto che indagini come queste hanno creato gravi implicazioni in tema di diritti fondamentali e quindi vanno regolate con opportune procedure e garanzie. Nel nostro sistema si è creato un contrasto all'indomani di queste operazioni investigative, contrasto rilevante, estremamente vivace, che è giunto fino alla Corte di Cassazione. Erano in estrema sintesi 3 le possibilità che si creavano nel nostro ordinamento. Interpretare questa raccolta di dati nella visuale dell'articolo 254 bis del Codice di Diritto, cioè interpretarle come sequestri di dati informatici, interpretarle come risultati di intercettazioni e quindi acquisirle con lo strumento dei verbali di intercettazioni provenienti da un altro procedimento. Per gli studiosi italiani il riferimento è il 270 e il 271 del Codice di Rito, oppure semplicemente considerarle come acquisizione di dati informatici conservati all'estero e farli rientrare nel canale dell'articolo 234 bis. Si è creato un contrasto su queste possibilità. Ognuna di queste possibilità consentiva, aveva dei pro e dei contra, ma nessuna di queste vie di acquisizione si è rivelata in realtà soddisfacente in relazione alle caratteristiche del nostro ordinamento. Le sezioni unite hanno risolto questo contrasto a proposito dello strumento processuale interno da porre a parametro per l'importazione della messaggistica criptata su piattaforma Sky ECC e acquisita mediante ordine europeo di indagine da un'autorità estera, nel nostro caso la francese, che ne aveva eseguito la decriptazione. Quale il senso della decisione delle sezioni unite nel risolvere italiane nel risolvere questo contrasto? Almeno 3, riassumo in sintesi i punti fondamentali. L'acquisizione dei risultati di intercettazioni disposte da un'autorità estera in un procedimento penale pendente davanti ad essa è assoggettata nel nostro ordinamento alla disciplina prevista dall'articolo 270, cioè dalle verbali di intercettazioni raccolte in un altro procedimento e acquisite nel procedimento ad quem. Le prove che sono in possesso delle autorità competenti dello Stato membro di esecuzione, quindi nel nostro caso la Francia, perché l'Italia agiva come Stato di emissione dell'ordine europeo d'indagine, possono essere richieste legittimamente e acquisite dal pubblico ministero, senza la necessità di un'autorizzazione preventiva del giudice. L'emissione di questo ordine europeo d'indagine volto ad ottenere i risultati di intercettazioni acquisite in un altro ordinamento sono ammissibili consentono di acquisire una prova che è ammissibile nel nostro ordinamento. Perché? Perché riguarda esiti investigativi che in quell'ordinamento, cioè nel francese, non sono stati ritenuti compatibili con le caratteristiche dell'ordinamento di esecuzione. E non devono essere precedute da autorizzazioni del giudice italiano. Però questa utilizzabilità dei risultati di intercettazioni acquisite all'estero non è senza limiti, è sottoposta a un controllo giurisdizionale ex post. Quindi questo controllo giurisdizionale, pur non preventivo, può essere realizzato in una fase successiva e non è escluso, purché il giudice del procedimento nel quale, interno italiano, nel quale queste intercettazioni vengono acquisite, escluda ogni profilo di compatibilità con il diritto interno. La parte interessata, a sua volta, ha l'onere di allegare e provare i fatti da cui deriva questa eccepita inutilizzabilità. Sta di fatto che, e lo dicono le sezioni unite, l'impossibilità per la difesa di accedere all'algoritmo utilizzato all'interno di un sistema di comunicazioni per criptare il testo di quelle comunicazioni non produce una violazione dei diritti fondamentali. Deve escludersi, secondo le sezioni unite, salvo che vi siano specifiche allegazioni di prove contrarie, di elementi di prova contrarie, qualsiasi violazione. Perché il contenuto, questo si dice, il contenuto di ogni messaggio criptato è inscindibilmente abbinato alla sua chiave di cifratura, sicché una chiave errata non avrebbe alcuna possibilità di decriptarlo anche solo parzialmente. Quest'ultimo passaggio non mi trova molto in linea con le affermazioni delle Nazioni Unite, perché si fonda su un'affermazione non dimostrata, un'affermazione che avrebbe meritato probabilmente un approfondimento di tipo scientifico ben più rilevante. Certamente quello che le sezioni unite hanno affermato è importante perché è un primo punto di equilibrio, tuttora suscettibile di ulteriori approfondimenti, ampliamenti, perché la vicenda non è affatto chiusa, punto di equilibrio rilevante nel nostro ordinamento. Ma non chiude, uso un termine molto banale, la partita. Perché? Perché l'arresto nomofilattico delle sezioni unite va interpretato alla luce della evoluzione successiva che vi è stata con la sentenza incrociata della Corte di Giustizia. Le sezioni unite si sono pronunciate a febbraio su sollecitazione delle sezioni semplici della Corte di Cassazione, ma non hanno potuto tener conto di quello che ha detto la Corte di Giustizia, né hanno potuto tener conto di quello che dirà ovviamente la Corte europea, anch'essa sollecitata, la Corte europea dei diritti dell'uomo, da varie autorità europee. Quali sono i limiti di questa impostazione? Il principio di equivalenza su cui hanno fatto leva le sezioni unite, che va declinato in relazione ad una clausola, cioè il caso interno analogo, non si basa sul meccanismo di formazione della prova all'estero, ma sulla sua circolazione. Quindi si basa su una vicenda successiva. Va parametrato, secondo le sezioni unite, non in rapporto alla disciplina della formazione della prova, ma alla disciplina della circolazione. Questo ha consentito di recuperare quelle prove ritenute legittime dall'autorità estera, cioè dalla Francia, all'interno del nostro ordinamento, sia pure all'interno dell'archetipo rappresentato dall'articolo 270. Cosa significa l'articolo 270? Che i verbali di intercettazioni raccolti in un altro procedimento possono essere acquisiti in un altro procedimento anche su richiesta del pubblico ministero e non necessariamente su ordine preventivo di un giudice, soggiacendo però a determinati meccanismi che sono quelli della utilizzabilità. Quella prova deve essere stata raccolta non solo in relazione a reati che consentono lo strumento delle intercettazioni, ma anche in relazione a attività che non siano lesive dei diritti fondamentali. Come questo possa accadere, le sezioni unite non lo hanno chiarito, né lo hanno chiarito la Corte di Giustizia con la sentenza del 30 aprile del 2024. La sentenza della Corte di Giustizia meritoriamente insiste su alcuni profili che attengono al contraddittorio nella formazione della prova. Fa giustamente leva su uno strumento importante previsto dalla direttiva sull'ordine europeo di indagine, l'articolo 31, cioè la necessità di notificare l'intervento estero l'intervento diciamo, volto ad acquisire la prova attraverso lo strumento di intercettazione allo stato dove quella prova viene raccolta. Ma sappiamo bene che l'articolo 31 è uno strumento che può essere, la notifica può essere aggirato, e infatti lo è stato. Non c'è stato in questo caso. Le prove sono state acquisite attraverso un meccanismo di infiltrazione su massa, su un dato massivo. È possibile questo nel nostro sistema? Io ho qualche dubbio. Un dubbio che è stato superato dalle sezioni unite, ma il dubbio rimane, perché non abbiamo noi una disciplina, parlo del nostro sistema, che consenta l'acquisizione massiva di dati su server. Almeno in questa forma. Certo, poi le singole acquisizioni di prova sono state filtrate selettivamente, sono state selezionate. Dal dato grezzo si è passato a un dato più semplificato, più specifico. Questo dato è certamente stato messo a disposizione dell'interessato, quindi della difesa, ma rimane il fatto che la catena di passaggio dei vari meccanismi di acquisizione della prova, compreso l'algoritmo, non necessariamente sono stati messi a disposizione delle difese. E qui si radica un dubbio che la stessa Corte di Giustizia non ha sciolto e che potrebbe sciogliere la Corte Europea dei diritti dell'uomo. La Corte Europea dei diritti dell'uomo finora si è pronunciata su un caso importante, una sentenza del 2023, settembre 2023, caso Yüksel-Yalchinskaya, dove si è soffermata su una vicenda analoga, ovviamente non sovrapponibile, ma analoga, che riguardava la messaggistica cosiddetta bylock. In quel caso la Corte Europea dei diritti dell'uomo ha affermato una serie di principi importanti. La Grande Camera della Corte Edu lo ha fatto. Importanti, che però dovrebbero essere poi calati all'interno del sistema, dei sistemi nazionali, e anche all'interno del sistema europeo basato sull'ordine europeo di indagine, che qui siamo al di fuori della vicenda Encrochat. La Corte qui ha ribadito però alcuni principi, muovendo dalla sua giurisprudenza, e ha detto che anche se il diritto alla conoscenza delle prove non è un diritto assoluto e può essere compresso, può subire delle limitazioni in nome di interessi superiori, ad esempio la segretezza dei dati, la sicurezza nazionale. Queste restrizioni devono essere però circoscritte, giustificate con provvedimenti autorizzativi mirati e soprattutto devono essere proporzionate, necessitate e proporzionate in relazione all'uso che se ne fa. Le caratteristiche delle prove digitali, cioè, non possono giustificare una deroga ai principi fondamentali del processo penale. Anzi, la natura intrinseca di queste prove e il loro peculiare iter di formazione, quindi la raccolta, la conservazione, l'analisi dei dati e la condivisione, rendono estremamente urgente l'esigenza di un rigoroso controllo giurisdizionale. Dunque, anche se vi sono esigenze di riservatezza, di protezione, di profili legati alla sicurezza nazionale, la violazione del giusto processo può sussistere non tanto in relazione alla qualità delle prove elettroniche utilizzate nei confronti, in quel caso, del ricorrente Yüksel, ma con riguardo alla violazione del principio del contraddittorio. Questo è il profilo che la Corte Edu ha riconosciuto rilevante. Può non rilevare la violazione della privacy, la violazione dell'articolo 8, ma può rilevare in concreto la violazione del giusto processo sotto un duplice profilo: la mancata adozione di adeguate garanzie processuali volte a consentire al ricorrente di contestare in maniera efficace le prove elettroniche prodotte nei suoi confronti e consistite in quel caso nei soli rapporti bylock e non anche nei dati grezzi che riguardavano il contenuto delle conversazioni intercorse. E, secondo profilo, l'omesso esame delle richieste e delle censure del ricorrente in relazione alla integrità dei dati probatori, in quel caso elettronici, che sono stati trasmessi. Quindi la Corte europea ha posto l'accento sul diniego di accesso a quei dati grezzi che non è stato controbilanciato da adeguate garanzie processuali. Questi profili dovranno essere calati in un contesto che è completamente diverso, che è quello Encrochat, che è quello dell'ordine europeo di indagine. Quindi contraddittorio nell'esercizio della prova. Contraddittorio nell'esercizio della prova e possibilità di contestare la prova quando quella prova abbia avuto un'influenza preponderante è l'altro profilo che considera anche la Corte di Giustizia nella sentenza del 30 aprile 2024 e che ha considerato anche la Corte di Cassazione a sezioni unite. Nessuna di queste autorità però dice come in concreto può accadere, che cosa in concreto la difesa può fare per contestare la genuinità, l'affidabilità della prova se non gli si mette a disposizione, se non le si mette a disposizione il dato grezzo e l'algoritmo. O comunque, anche se l'algoritmo non viene messo a disposizione, consentire attraverso la catena della formazione digitale della prova i vari passaggi che sono stati seguiti nella raccolta, nell'analisi, nella selezione dei dati. Mi avvio alla conclusione. Certamente la giurisprudenza italiana, così come quella di altre corti supreme, penso ora dovrà pronunciarsi, se non si è già pronunciata, la corte tedesca, ma anche la corte olandese e altre corti supreme, hanno aperto numerosi interrogativi in ordine alla mancata conoscenza dei dati e alla impossibilità delle difese di contrastare gli esiti investigativi e anche in relazione alle modalità del controllo giurisdizionale ex post rispetto ai vulnera che possono essere legati alla difesa. Si tratta di primi punti di equilibrio. Le questioni, a mio avviso, sono tuttora aperte e vanno declinate in relazione alla tutela del contraddittorio e all'affidabilità della prova che deve essere spesa nei confronti delle persone interessate. Se il dato grezzo che deve essere depositato unitamente a tutti i metadati viene criptato, dovrebbe essere necessario, intuibile, mettere a disposizione delle parti la chiave per decifrarlo o comunque per ricostruire i passaggi della decifrazione. L'importanza della sentenza della Corte di Giustizia è l'aver insistito su una regola di esclusione della prova, cioè la inutilizzabilità patologica che si crea nell'ipotesi in cui l'interessato non sia messo in condizione di contestare la qualità e l'affidabilità della prova determinante nei suoi confronti. Questo è un principio importante, che però le stesse sezioni unite hanno scolpito, sia pure con dei distinguo. E allora cosa fare? Il nostro ordinamento, a mio avviso, presenta dei ritardi strutturali in diverse aree, non solo in quella dell'acquisizione digitale delle prove. Sono numerosi gli strumenti invasivi. Non possiamo limitarci soltanto a guardare questa vicenda, ce ne sono tante altre, probabilmente ne verranno a conoscenza nei prossimi mesi. La criminalità viaggia a velocità che le autorità giudiziarie e le difese non conoscono. Abbiamo video riprese con riconoscimenti facciali, sorveglianze online, tracciamenti mediante GPS, un utilizzo di intelligenza artificiale a fini investigativi e probatori, sistemi che ledono palesemente i diritti fondamentali della persona e che non vengono regolati. Cosa fare? Se noi andiamo appresso, e lo dico con estrema semplicità e in estrema sintesi, se noi andiamo appresso al dato digitale non ne usciamo. Non riusciremo mai a regolare il singolo elemento tecnologico che la scienza mette a disposizione e che viene utilizzato liberamente dalla criminalità organizzata. Avremo sempre lacune gravi. Oggi la prova regina non è più la prova dichiarativa. La prova regina oggi è la prova tecnologica, la prova digitale, quindi dobbiamo prenderne atto. Se così è, e non possiamo rimanere al passo e inseguire l'evoluzione tecnologica. Dobbiamo regolarla non attraverso una sistemazione dettagliata e casistica delle varie ipotesi. Riprendo delle sollecitazioni che venivano già stamattina dagli interventi dei professori Panzavolta, Lorena Bachmeier e il professor Luchtmann anche sul mandato dell'est europeo, perché i profili sono strettamente interconnessi. Dobbiamo sopperire probabilmente con l'individuazione di principi generali che consentano poi alle autorità giudiziarie e alle difese di poter vagliare caso per caso se quel sistema di acquisizione della prova risponde a quel principio. Parlo di necessità, di proporzionalità, di riserve di giurisdizione e di legge, di compatibilità tra sistemi di sicurezza nazionale e invasività dello strumento utilizzato anche in relazione alla copertura di segreti di Stato che dovrebbero essere rimossi quando vi è in gioco un diritto fondamentale della persona. Riprendo una recente elaborazione del professor Daniele, che mi trova d'accordo su un profilo importante. La giurisprudenza della Corte europea dei diritti dell'uomo e della Corte di giustizia ci dà, filtrata nella sua analisi complessiva, degli indici di violazione sistemica dei diritti di difesa e dell'equità processuale. Ci dà cioè dei elementi che noi possiamo ricostruire e sulla cui base avviare un discorso nuovo. Questi elementi non possono che essere quello che dice intanto la Corte di Giustizia, l'influenza preponderante della prova come limite di controllo e di interesse anche a contestare la consistenza, il peso specifico della prova nella vicenda interessata. Il valore che è protetto dall'omessa discovery occorre cioè giustificare in concreto perché deve esserci una segretezza e perché quella segretezza deve essere superata. La secretazione degli algoritmi di decriptazione deve perseguire un interesse meritevole di tutela. Se questo interesse meritevole di tutela non c'è, e comunque va spiegato, che vada rimosso. La necessità, il controllo del giudice, non solo sui dati di traffico, così come dice la Corte di Giustizia, ma su qualsiasi elemento di prova che attiene alla relazione di quella prova col diritto fondamentale della persona, e soprattutto misure che consentano di controbilanciare l'intrusività di un intervento importante nella sfera dell'interessato alla luce di una valutazione equitativa complessiva. Cioè, se c'è una restrizione, che sia adeguatamente controbilanciata da un interesse meritevole di tutela. E poi queste prove digitali, anche se decriptate e messe a disposizione, hanno una reale affidabilità? Cioè devono poter essere oggetto di un controllo che escluda qualsiasi possibilità di alterazione. Se pericolo di alterazione vi è, questo pericolo di alterazione deve essere controbilanciato da altri elementi probatori di contorno, di riscontro, perché se c'è solo quella prova e quella prova reca un dubbio in sé, o comunque questo dubbio viene allegato alla difesa, quella prova non venga utilizzata. La giurisprudenza successiva alle sezioni unite è sintomatica. Vi è stata sostanzialmente una posizione uniforme di rigetto. Si era in una fase cautelare. Vi era una massa di procedimenti che erano stati sospesi in attesa delle sezioni unite. Parlo ovviamente del nostro ordinamento. Questi ricorsi presentati in materia di libertate sono stati respinti, perché ovviamente le difese non erano in grado in quella fase di dimostrare che una violazione vi fosse stata nell'ordinamento francese che tra l'altro aveva ritenuto legittimo quell'intervento, e nel nostro ordinamento non erano in grado in quella fase di poter dimostrare che vi fosse stata una concreta violazione del diritto fondamentale della persona interessata, nonostante vi fossero state delle eccezioni riguardo alla coincidenza dei testi delle conversazioni decriptate. Quindi le prime pronunce della Cassazione sono state di segno contrario, ma si sono soffermate su eccezioni che hanno riguardato la fase delibertate. L'evoluzione del processo e quindi l'evoluzione delle attività investigative e delle attività processuali potrebbe consentire una messa a punto migliore di queste eccezioni e quindi una articolazione maggiore di contestazioni in relazione alla qualità della prova nel prosieguo del procedimento e in futuri altri procedimenti. Sta di fatto che il nostro ordinamento oggi sconta dei deficit di tutela che la messa a punto provvisoria di un primo equilibrio non consente, a mio avviso, di scongiurare per il futuro. Libertà morale, principio di legalità processuale, principio di proporzionalità vanno inseriti all'interno di un quadro istituzionale che che impone comunque, a mio avviso, un provvedimento motivato del giudice, non solo sui dati di traffico, ma su tutto ciò che riguarda l'acquisizione della prova all'estero, perché solo un giudice, da una posizione terza, può consentire di valutare se quella prova abbia un minimo di affidamento nel contraddittorio delle parti. Grazie, spero di non essere stato troppo lungo.
Grazie Gaetano, è stato un intervento prezioso perché mette in luce le difficoltà e fa apprezzare, pur con i loro limiti, lo sforzo delle sezioni unite nel cercare di fronteggiare le difficoltà assai rilevanti, soprattutto mettendo dei paletti e smentendo alcune ricostruzioni o interventi piuttosto grossolane sul mezzo di prova disponibile nell'ordinamento interno. E certo, il futuro non è pregiudicato per nulla, ma bisogna tanto lavorarci perché i punti fermi sono davvero pochi. Tanto più nella materia, come dire, dell'assistenza probatoria, dove la cooperazione è veramente tutta da costruire. Davvero ci aspettiamo evoluzioni importanti. Adesso passerei la parola e ci spostiamo sul tema del mandato del resto europeo, prassi e strategie difensive all'avvocato Nicola Canestrini. L'avvocato Nicola Canestrini, molti di voi conosceranno, è avvocato specializzato in surrender proceedings, quindi procedure di consegna, estradizione, è membro del European Criminal Bar Association, oltre che membro di Fair Trial Rights, un'altra associazione che si occupa appunto di fair trial. Bene, a lui la parola e grazie.
Grazie Presidente. Corre l'obbligo di iniziare naturalmente nel dare atto più che ringraziare l'Università di Trento, la professoressa De Paolo, Luca Pressacco, dell'attenzione costante che hanno avuto e che hanno sempre nei confronti della difesa, perché la difesa non è spettatore di ciò che avviene in aula, ma ne è, suo malgrado, protagonista. E la misura, il livello di compressione dei diritti della difesa a favore delle ragioni, a favore dell'accusa, in nome di un'efficienza, di combattere l'impunità, di altre formule che conosciamo bene, per essere state ripetute e straripetute, segna anche il limite dello Stato di diritto. Quindi grazie all'Università di Trento per portare sempre anche la voce le ragioni della difesa in consessi come questi, in cui si cerca di andare oltre l'esistente, oltre la compilazione delle sentenze, dei principi che conosciamo bene. As Professor Luchtmann has already pointed out, the European arrest warrant proceedings, where there was a shift in April 2016 from the Aragnosi Calderaro decision. The European Court of Justice shifted the focus on rights and the importance of fundamental rights. He already laid out the most important principles and decisions, so take my presentation as a footnote to his one. Intanto, quando ci si chiede quali siano le interazioni fra diritti e esigenze di cooperazione internazionale, non possono iniziare, lo faccio tutte le volte, con questo obiter che riguardava anche in questo caso una procedura estradizionale della nostra Corte Costituzionale, in cui nella sentenza 280 del 1985 veniva chiaramente fatto una relazione fra questi due importanti principi. E la Corte Costituzionale conclude, come potete leggere, che il fatto di dovere, i pacta sunt servanda, il fatto di dovere lottare contro la criminalità sovranazionale non consente affatto una deroga a quei valori che la nostra Costituzione dichiara inviolabili. E invece, mentre nessuno ascolta, ogni tanto lo fanno, ne vedremo qualche esempio. Se quindi ci dovesse essere una tensione fra diritti fondamentali e cooperazione giudiziaria penale europea, la Corte Costituzionale insegna la preferenza dovrebbe andare senz'altro, la primazia, chiamiamola così, dovrebbe andare senz'altro alla tutela dei diritti fondamentali. Del resto, non tanto il mercato segna la base comune, il punto di partenza per questa nostra la costruzione di questa nostra Unione Europea un po' ridotta in macerie, me lo si lasci dire, con quella tristezza che ci prende quando vediamo la patria di quello che pensavamo essere la culla della tutela dei diritti, abbracciare ragioni di realpolitik che speravamo essere bandite per sempre, fatemelo dire così. E l'Unione Europea nasce e vive sul diritti, libertà e principi sanciti nella Carta dei diritti fondamentali dell'Unione Europea, perché i diritti fondamentali, sempre articolo 1 del Trattato sull'Unione Europea, garantiti dalla CED, risultanti dalla tradizione costituzionale comuni, fanno parte del diritto dell'Unione in quanto principi generali. Ma se andiamo a verificare quali siano le cause di rifiuto per entrare in media res del mandato d'arresto europeo, ne troviamo obbligatorie e facoltative, una decisione quadro 584, che prevede all'articolo 1/2 che gli Stati danno esecuzione a ogni mandato d'arresto europeo. Quindi un indicativo presente. Non abbiamo una causa di rifiuto del mandato d'arresto europeo a causa di violazione dei diritti fondamentali o meno, che siano, il che rispetto a quello che ci siamo detti fino adesso può stupire. Stupisce? No, ce lo spiega la sentenza Corte di Giustizia GN dicembre del 2023, ne abbiamo già sentito parlare questa mattina, perché c'è chiaramente una presunzione che era assoluta, diciamolo così, in maniera un tantino approssimativa, ma per la quale tutti gli Stati membri rispettano il diritto dell'Unione e in particolare i diritti fondamentali riconosciuti da quest'ultimo. Se il diritto dell'Unione si basa sui diritti, non c'è possibilità che l'attuazione del diritto, decisione quadro 584, mandato d'arresto europeo, possa andare a ledere i diritti fondamentali. Un ragionamento perfetto in apparenza, come vedremo fra un momento. Perché vi è pur sempre quel grande regalo che il legislatore europeo ci ha fatto, l'articolo 1/3, decisione quadro, per la quale l'obbligo di rispettare i diritti fondamentali non può essere modificato per effetto della decisione quadro 584 del 2002. Questa in realtà è poi apro e chiudo una delle parentesi nell'ambito del tempo che mi è stato assegnato, e negli altri strumenti di cooperazione penale dell'Unione Europea ci sono formule analoghe, ve la risparmio, ma questa si trova praticamente in tutte le decisioni quadro e anche nel regolamento EPPO, anche se leggermente declinato in maniera leggermente differente. N'è eccezione, a proposito di learn by doing, come ci ha ricordato il professor Vervele questa mattina, con l'ordine di indagine europeo, e questa presunzione assoluta, diciamo così, di rispetto ai diritti fondamentali è diventata relativa, conoscendo European Investigation Order, un motivo di rifiuto espresso per violazione dei diritti, e ho avuto un caso una volta di una tale applicazione. Si trattava di un processo per diffamazione in provincia di Bolzano, in cui un istituto che si occupa di tutela dell'ambiente aveva fatto un articolo e un grande poster in cui veniva detto che Südtirol braucht saubere Luft, quindi il Sud Tirolo ha bisogno di aria pulita, criticando l'eccessivo uso dei pesticidi. Il vicepresidente della provincia autonoma di Bolzano, 1387 contadini fanno querela per diffamazione, viene messo un ordine di indagine europeo e l'autorità giudiziaria tedesca risponde: ci dispiace tanto, ma noi dobbiamo opporre il motivo di rifiuto per il quale questa vostra richiesta di trasmettere i dati di accesso al server per sapere chi avesse caricato questi articoli in rete non ve li possiamo dare perché contrasta con la libertà di espressione. In ogni caso, che i diritti siano il punto centrale della cooperazione giudiziaria penale anche europea, o soprattutto europea, è evidente laddove si parla di reciproco riconoscimento che si basa sulla fiducia reciproca, e non c'è fiducia se non ci sono diritti. Ma nell'approccio iniziale la Corte di Giustizia non aveva dato molta soddisfazione ai fanatici dei diritti. Ricorderete le sentenze Radu e Melloni 2013, in cui, come dire, l'approccio era efficiency based, cioè si pensava che l'importante fosse far funzionare gli strumenti, non cogliendo forse quegli spunti che già allora c'erano, per i quali non ci poteva essere mutual trust senza consapevolezza della pari tutela dei diritti fondamentali su tutto il territorio dell'Unione Europea. E allora, con le condizioni di detenzione, si è inaugurato quel filone prolifico in cui posso dire con un certo orgoglio l'Italia si è distinta nel sollevare questioni pregiudiziali, perché due delle 4 cause di rifiuto del mandato dell'arresto europeo provengono da pregiudiziali sollevate da giudici italiani, a conferma della vivacità del dialogo che c'è nelle aule di giustizia italiane. La prima appunto sulle condizioni di detenzione. Inutile racconti a questa platea come si sia arrivata, ma i pacta che erano servanda qui erano due. Da una parte la necessità di rispettare il divieto di cui articolo 3 della Convenzione Europea dei diritti dell'uomo, il nocciolo duro della Convenzione, divieto di tortura, trattamenti inumani degradanti. Dall'altra avevamo invece l'obbligo di esecuzione del MAE, così che abbiamo visto prima, l'indicativo presente anche in quel caso. L'Advocate General Yves Bott che aveva concluso che le condizioni di detenzione negli stati di emissione non potevano portare ad un rifiuto MAE perché sussisteva, ad opinione dell'Avvocato Generale, il rischio chiaro ed evidente che il reato restasse impunito e che il suo autore risultasse recidivo e quindi compromettesse la sicurezza anche degli altri concittadini. È storia il fatto che la Corte di Giustizia, con la sentenza davvero landmark del 2016, del 5 aprile del 2016, invece ha chiesto un obbligo di verifica del rispetto dei diritti fondamentali per quel che riguarda in questo caso le condizioni di detenzione, secondo quella two steps approach che ci è già stato illustrato e che mi consente di essere un po' più veloce, anche per non far arrabbiare il nostro Presidente. E qui però una piccola nota la voglio mettere. Vedremo la questione del two steps approach e quali sono le critiche che da un punto di vista della difesa viene mossa a questa impostazione. Tutto questo però si riduce a una circolarità di carte. Avete forse sentito della favola di Biancaneve, in cui la matrigna cattiva porge questo dono, la mela avvelenata, che sembra essere un dono innocuo, ma nasconde in sé un potere mortale. Nel rapporto di cooperazione internazionale, questo dono mortale si chiama informazioni supplementari. Nel diritto internazionale classico si chiamano rassicurazioni diplomatiche. Nei nostri strumenti si chiamano informazioni supplementari. Ogni tanto faccio l'esempio di un marito fedifrago che promettesse alla moglie eterna fedeltà avendola tradita già innumerevoli volte. La moglie evidentemente non crederebbe all'ennesima promessa e farebbe probabilmente bene a non crederci. Possiamo pensare, per fare un esempio meno impattante, alle bugie che raccontano i bambini. Continuano a raccontare le bugie. Ma sì, li ho fatti i compiti, li ho fatti i compiti, li ho fatti i compiti. Hanno mentito 99 volte. E la 100ª volta, siccome lo mettono per iscritto, questo basta per sollevare, per evitare che noi abbiamo dei dubbi che qualcosa poi non andrà come questi stati che da decenni violano i più fondamentali di tutti i diritti, non continueranno a violarli? E qui, non vi bastasse, ci aggiungo qualche piccolo elemento. Nessuno controlla il rispetto di queste rassicurazioni. Nessuno! Non c'è autorità giudiziaria italiana che abbia il potere di verificare, perché il fascicolo è chiuso. Spetterebbe a chi? Al Ministero degli Esteri, ma il Ministero degli Esteri ha difficoltà a intervenire. Non lo fanno nel procedimento estradizionale, in cui il potere politico ha diciamo un suo ruolo molto ben definito e determinante. Nei procedimenti MAE è quasi impossibile. In ogni caso, la persona è stata consegnata e buonanotte al secchio, per usare una terminologia tecnica. Il secondo problema, naturalmente, il fatto che si è lasciato interamente allo stato di emissione la scelta del penitenziario dove metterlo, potrebbe essere un buon inizio, perché si potrebbe dire, vabbè, l'Italia, che non brilla di certo per le condizioni di detenzione, e anzi il numero di suicidi, lo sappiamo, è drammatico in questo paese, nella indifferenza di tutti, legislatori in primis. Noi sappiamo anche che non è richiesta dalla giurisprudenza della Corte di Giustizia che lo stato di emissione mantenga questa promessa di collocare il consegnato o la consegnata in un determinato carcere dove gli standard paiono essere rispettati sulla base di questa carta che viene scambiata con un copia e incolla, perché chi lavora in questo ambito vede che sono sempre quelle, cambiano i nomi, ogni volta cambia formulazioni, ma altro che individual assessment, è una bugia, sono dei copia e incolla fatti ogni tanto anche male. Ma soprattutto alcuni stati, la Moldavia, hanno capito come funziona il sistema, hanno una prigione dove effettivamente c'è una sezione che è perfettamente rispondente ai criteri di cui l'articolo 4 della carta, promettono di metterlo lì o di metterla lì, la mettono o lo mettono lì e dopo una settimana lo trasferiscono in carceri che continuano a violare i diritti fondamentali. Altro che mela avvelenata, quindi, per dirla gentilmente, come già l'Assemblea parlamentare disse nel 2006, quindi mi nascondo dietro l'Assemblea parlamentare del Consiglio d'Europa, relying on the principle of trust and assurances given by undemocratic states known not to respect human rights is simply cowardly and hypocritical. Codardo e ipocrita. Questo è l'atteggiamento di chi pensa che con un tratto di penna possono essere nascosti decenni di violazione dei diritti fondamentali. La seconda causa, macro causa di rifiuto di mandati di arresto europei è naturalmente il diritto a un processo fair trial, processo equo, da un punto di vista della indipendenza del potere giudiziario, il caso polacco, Selmer 2018, in cui ho una piccola, diciamo così, aggiunta. Noi con Irene Iannelli ce l'avevamo fatta trovare non solo le diciamo le problemi sistemici, ma trovare anche come ha inciso sulla situazione del singolo. Ve lo racconto. La giudice che aveva emesso il mandato d'arresto processuale era stata trasferita proprio in base a quelle leggi che avevano fondato il giudizio di un problema sistemico di indipendenza, e quindi ci eravamo detti con l'avvocato Iannelli, ce l'abbiamo fatta, l'abbiamo trovata. La sesta sezione ci ha dato torto e quindi non è bastato questo, e siamo sicuri che però riusciremo a trovarne degli altri. Il terzo caso, questo è un caso italiano, Corte d'Appello di Milano, un caso in realtà di doppia pregiudiziale, EDL, diritto alla salute, persona psichiatrica in una condizione di patologia irreversibile in cui la Corte d'Appello di Milano fa una perizia psichiatrica che accerta l'irreversibilità, la gravità e il pericolo suicidiario. Scelgono, rispetto a quanto sollecitato dalla difesa, di non fare direttamente la pregiudiziale alla Corte di Giustizia, ma di fare in questione di legittimità costituzionale alla Corte Costituzionale. Il professor Viganò manda alla Corte di Giustizia, che con sentenza del 18 aprile 2023 introduce questo nuovo motivo di rifiuto, appunto in una situazione in cui l'autorità giudiziaria di esecuzione abbia, e questo lo vorrei sottolineare da una prospettiva difensiva, alla luce degli elementi oggettivi a sua disposizione, motivi seri comprovati, ritenere che la consegna alla persona ricercata, gravemente ammalata, le esporrebbe a un rischio reale di riduzione significativa dell'aspettativa di vita e di deterioramento rapido, significativo e irrimediabile dello stato di salute, detta autorità è tenuta, in conformità all'articolo 4, a esercitare la facoltà e quindi sospendere la consegna. E nel paragrafo 50, interessante, la Corte di Giustizia, la sentenza IDL dice: alla luce delle informazioni fornite dall'autorità giudiziaria emittente, nonché di qualsiasi altra informazione di cui l'autorità giudiziaria dell'esecuzione disponga, aprendo forse un po' la porta a relativizzare quel principio che prima ho stigmatizzato, per il quale, ricevute le informazioni supplementari, e l'autorità giudiziaria dello stato di esecuzione non possa, che si costruisce la casa comune, ma insistendo nel valorizzare elementi comuni, La riformulazione dell'articolo 2 ci regala un grande strumento nella Human Rights Defense o Fundamental Rights Defense nel mandato d'arresto europeo, e per cui l'esecuzione del mandato d'arresto europeo non può in alcun caso comportare violazione dei principi supremi dell'ordine costituzionale dello Stato, diritti inalienabili della persona, diritti fondamentali e fondamentali principi giuridici sanciti dall'articolo 6 Trattato sull'Unione Europea. Non siamo su questo un'eccezione, perché sia UK che la Germania conoscono clausole simili, se non addirittura più ampie rispetto a motivi di possibile mancata consegna. Qualche tema ancora rimarrebbe da esplorare, cioè la problematica della libertà di circolazione, dottrina Petruchin, su cui credo ancora qualcosa si possa fare da un punto di vista della difesa, perché non sono del tutto convinto che un cittadino di uno Stato membro che nega l'estradizione dei propri cittadini non si possa portare dietro questo suo status quando esercita un diritto fondamentale come quello della libera circolazione. Sappiamo naturalmente che la Corte di Giustizia da Petrucci in poi ha adottato una, diciamo così, una soluzione intermedia, anche perché le conseguenze di una radicale impostazione come quella che vi sto proponendo avrebbe determinato riscrivere le politiche di cooperazione giudiziaria penale in tutto il mondo, ma se dovesse servire ad ampliare la tutela dei diritti, ben venga. Rimangono temi caldi, la proporzionalità nello stato di esecuzione, il vero elefante allora nella stanza, oltre all'armonizzazione di cui è già stato parlato, e problematiche sul valore dei precedenti rigetti mai, in cui sembra la fiducia reciproca non valere più, vale solo su ragioni che come dire, aiutano la prosecution. L'articolo 8, grande battaglia di molte difese, sinora con poche risposte da parte dell'autorità giudiziaria italiana, mentre all'estero l'articolo 8, il diritto alla vita privata familiare, è naturalmente tenuto in altissima considerazione, basti pensare alla questione Assange. E poi questa spina nel fianco che è la diritti alla difesa, errore mio, non è una sentenza ma un'ordinanza che rende tutto ancora più drammatico, su cui sapete l'Italia consegna ed esegue pene inflitte in contumacia che sarebbero perfettamente note, salvo essere messe in stati Belgio e Francia in cui il contumace non è rappresentato dal difensore, il che davvero mi fa soffrire, ma spero che presto qualcuno somministri una buona medicina. Allora, se devo fare una conclusione al volo, mi vado a prendermi in prestito il titolo della Fundamental Rights Agency dell'Unione Europea, in cui quando parla nel suo rapporto del stato dell'arte del mandato d'arresto europeo dice room for improvement to guarantee rights in practice. Sì, c'è room for improvement laddove il nostro faro devono essere naturalmente diritti concreti ed effettivi e non teorici ed illusori. Vi ringrazio molto.
Grazie, Avvocato Canestrini, per questo ricco panorama di problemi, ma nel MAE li abbiamo i problemi, abbiamo più corposità, l'assistenza probatoria, la cooperazione in materia probatoria è ancora più sfumata. Qui abbiamo molta carne al fuoco e quindi molte questioni che riusciamo ad analizzare diciamo, con strumenti sufficienti, e lei ha portato davvero un quadro e un panorama di questioni molto molto ampio, splendori e miserie del MAE, potremmo intitolare la sua relazione. Adesso però passerei ad altro, cioè ad altro fino a un certo punto, perché il tema è del tutto analogo. Il tema della relazione del professor Giovanni Barrocu e la difesa nei procedimenti transnazionali. Il professor Barroco è qui non solo, ma anche per essere allievo della professoressa Marchetti. La professoressa Marchetti si laureò a Camerino, poi fu cercatrice a Trieste, ma poi fu chiamata come associata e poi come ordinaria a Sassari, dove è rimasta tanti anni fino al pensionamento, lasciando appunto degli allievi. Uno di questi è il professor Barroco e io gli do la parola con molto piacere. Prego.
Grazie Presidente. Devo fare dei ringraziamenti che non sono di rito. Questa volta soprattutto a Gabriella Di Paolo, tutta l'Università di Trieste, ma sì, di Trento, e lapsus freudiano di Trento, visto che si parlava appunto delle origini della professoressa Marchetti appunto presso l'Università di Trieste. Non solo per aver voluto dedicare questa sessione alla professoressa Marchetti, la quale molti di voi conoscevano e forse sapranno quanto cercava di rifuggire da queste lodi pubbliche, ma quanto avrebbe apprezzato invece tanta attenzione e sensibilità per questi temi. In particolar modo credo che davvero nel sentire trattare con questa anche verve che abbiamo sentito, con questa passione, permettetemi uno scivolone poco tecnico, credo che sarebbe stata come un bambino nel negozio delle caramelle, sarebbe stata veramente, veramente felicissima, e per questo, Gabriella, ti ringrazio davvero e anche per avermi coinvolto. Credo che avrebbe sorriso anche lei, che mi imputava di essere una specie di automa, nell'essere riuscita invece con questa sua prematura di partita a farmi emozionare come sono in questo momento, perché ricordarla oggi davanti a voi è una cosa che mi viene molto, molto complicata. Nel ricordarla però cercherò di non essere troppo lungo. Sono contrario ai trattamenti disumani e degradanti, e dopo il discorso di ieri sul pranzo trentino a mezzogiorno mi rendo conto che all'1:30 posso risultare particolarmente fastidioso. Siamo in orari sardi qua, però cercherò comunque di adattarmi alla sede in cui mi trovo. Voglio partire però in questa breve ricostruzione ricordando per l'appunto, a proposito delle opere della professoressa Marchetti, quel libro curato insieme ad altro esperto che credo vada ricordato, che è il dottor Eugenio Selvaggi, sulla nuova cooperazione giudiziaria, che presentammo, io ho avuto la fortuna, forse il merito eccessivo di coordinare, presentammo a Verona nel 2019. E siccome l'avvocato Canestrini ha parlato di fiabe, anche a me piace ricordare una fiaba. In quell'occasione la collega presente, Paola Spagnolo, nel riconoscere appunto questa svolta, il dottor Di sicuramente si ricorderà, ho visto c'è anche il dottor Venegoni che era presente, molti di noi erano presenti in quell'occasione, aveva ricordato questa svolta finalmente, dopo tanta sofferenza anche umana che io ho visto nella professoressa Marchetti, nel lustro che iniziava ad assumere la trattazione delle tematiche della cooperazione giudiziaria internazionale, la definì la Cenerentola, che finalmente era diventata principessa. Io che sono una persona che ama l'ironia, quando parlai risposi: cara Paola, devo dirti che se questa è la situazione attuale, a seguito di quella famosa commissione e lo stravolgimento, devo anche dire, per restituire anche un po' di dignità al lavoro di quella commissione che avvenne nel passaggio all'ufficio legislativo, le risposi che Cenerentola non avrebbe mai più ritrovato la scarpetta se questo era il modo in cui si procedeva. Ho cambiato idea diverse volte stamattina sentendo parlare, ho sentito parlare il professore Illuminati di resistenza e di gelosia come difficoltà verso l'armonizzazione che era tanto richiesta. E sì, sono d'accordo, ma da un certo punto di vista credo anche che finché noi non avremo l'ambizione, pur utopica, di pensare che il sistema perlomeno europeo dovrebbe essere un sistema che oltre a condurre ad una forma di efficienza repressiva, dovrebbe portare semplicemente al miglior processo penale possibile, soprattutto sotto il profilo della tutela delle garanzie. E credo che sotto questo aspetto siamo piuttosto in ritardo. Il tema specifico di cui voglio parlare in questo contesto, che ho segnato parlando con Gabriella, che devo dire mi ha lasciato grandissima libertà, non è tanto la difesa in genere nei procedimenti transnazionali, che sarebbe un tema infinito, potrei dividerla in due parti, una che riguarda tutti gli aspetti cedevoli dei vari strumenti, penso all'ordine europeo di indagine, sotto numerosi aspetti, difetti comunicativi di cui ci ha parlato anche l'avvocato Canestrini, che si riverberano poi su una sorta di gravami sostanzialmente muti, dove non è possibile conoscere le ragioni, ma questo è un aspetto che richiederebbe una conferenza a parte, ma noi aspettiamo che Gabriella la organizzi, così eventualmente torniamo in questa splendida ospitalità che abbiamo avuto. Ma voglio parlare dello specifico profilo che è rimasto un po' nell'ombra dopo una primissima pronuncia e tante piccoli assestamenti, che è quello delle investigazioni difensive all'estero. Ho scelto questo tema perché era un tema, per l'appunto, che era molto caro alla professoressa Marchetti, che riteneva che non fosse stato possibile, per difetto di delega, per numerose difficoltà operative, affrontare in sede di recepimento dell'ordine europeo di indagine, cosa però per la quale effettivamente invece a me sembrava potesse essere l'occasione adatta per tendere verso questo miglioramento, addirittura un miglioramento che poteva andare ben oltre alcuni limiti interni che noi abbiamo all'interno del sistema delle investigazioni difensive. Voglio dire subito, senza come dire, fascinazioni esterofile né pregiudizi autarchici, che a un rapido sguardo comparativo il nostro sistema, quello statuto, diciamo, delle investigazioni difensive, è qualcosa che nella gran parte dei paesi esteri non c'è. Per cui è già un passo per il quale noi forse potevamo farci latori di una volontà riformista intesa a sanare un grandissimo vulnus. Sappiamo tutti come sono nate le investigazioni difensive in Italia, quel primo articolo 38 delle disposizioni di attuazione, cosa è successo dopo, non a caso, immediatamente dopo la riforma della legge costituzionale numero 2 del 99, proprio perché le investigazioni difensive, è stato detto da tanti, non serve forse che lo ripeta, io lo faccio a beneficio magari di una platea che meno si è occupata di questi temi. Le investigazioni difensive in realtà, lungi dal costituire un mero tassello nell'ottica dei diritti individuali dell'imputato o delle altre parti private, credo vada vista in un'ottica un pochino più generale, come un pezzo di un puzzle in mancanza, all'interno del quale, in mancanza anche di un solo pezzetto, anche fosse l'angolino che non troviamo più mentre stiamo costruendo il puzzle, fa cadere in realtà tutto il procedimento. Questo segmento, che sarebbe la ricerca della prova all'interno poi della dialettica processuale, della richiesta, dell'assunzione, rende le fasi successive sostanzialmente disutili nel momento in cui io non ho avuto l'opportunità di ricercare quegli elementi, di instaurare quella dialettica processuale che si deve basare su elementi che ho potuto scoprire. Non voglio, ovviamente questo andrebbe visto non in un'ottica difensiva. Ci siamo accorti che tutte le volte in cui proviamo a isolare un singolo principio senza provare ad astrarre con un ragionamento inverso, induttivo, lo stesso, suona come una pretesa individuale, come una prerogativa che si può porre anche come ostacolo all'accertamento. Proviamo a rovesciarlo. Proviamo a immaginare che invece l'esistenza e la tutela di questi principi in realtà sono gli stessi che tutelano i principi generali che ci portano ad avere semplicemente un accertamento processuale migliore. Se manca il contraddittorio, ma contraddittorio inteso delle due parti in condizione di parità delle armi, qui rischiamo di avere insomma, la bomba nucleare contro le spade fatte di bastoni. Se manca questa parità, l'accertamento sarà necessariamente peggiore, perché il sistema processuale che abbiamo importato, che abbiamo deciso di seguire, si basa fondamentalmente su questo. Alcuni abbagli, purtroppo, bisogna dire, come l'articolo 358, soprattutto, che imporrebbe, io dico imporrebbe perché io ho la sensazione che tutte le regole processuali non dotate di sanzione si traducano in meri inviti, qualcuno ogni tanto parla di norme pedagogiche, ma di fatto si traducono in nulla. In realtà in questo caso danneggi più di quanto risolva, proprio in relazione anche all'aspetto della cooperazione, perché l'ideale utopistico che il pubblico ministero comunque interverrà anche per raccogliere gli elementi a favore della persona sottoposta a indagine, in realtà diventa un salvacondotto per sanare quello che manca, cioè l'opportunità del difensore di attivarsi opportunamente per raccogliere questi elementi. A peggio, in un procedimento connotato da transnazionalità, per sua stessa natura difficoltoso per la difesa. Voi per questa sorta di difese, non parlerò dell'EPPO, stamattina ho visto che viene definito in inglese IPPO, che mi ricorda, avendo una bambina, lei Pippo, questo è un dato simpatico, perché lì la situazione è ancora più complicata per questa possibilità di difese nomadi in giro per l'Europa, per la circolazione della prova, la cosa diventa molto complessa. Se vediamo allora nell'ottica dell'accertamento migliore possibile, però, le indagini difensive, con tutte le carenze che conosciamo benissimo, sappiamo quali furono i tentativi, addirittura ricordo che ci fu una proposta di introdurre le investigazioni difensive canalizzandole verso la polizia giudiziaria, che doveva avere un divieto di comunicare col pubblico ministero, una sorta di follia naturalmente che non è mai stata seguita. Il problema però è sempre stato la canalizzazione. Però nel sistema italiano l'abbiamo almeno in parte arginato, solo in parte, nel senso che tutto ciò che non richiede il superamento del consenso privato, diciamo che possiamo tenerlo riservato. Ma tenerlo riservato significa, prima di tutto, passatemi l'imprecisione di questa definizione, tutelare un altro principio, che sarebbe il nemo tenetur sed et egere. Il fatto che il difensore possa scegliere quali elementi depositare attiene direttamente ad una prospettiva per la quale il difensore, nel momento in cui svela cosa vuol fare, perde la possibilità di scegliere che cosa depositare. E allora questo sistema di obbligatoria canalizzazione, se visto nella prospettiva transnazionale, va a toccare un altro principio, che è quello della terzietà del giudice. È una questione di metodo. Se richiediamo necessariamente il passaggio attraverso la rogatoria internazionale, arriverò adesso immediatamente, molto brevemente, a quella che è stata la pronuncia giurisprudenziale, diciamo, di riferimento, necessariamente impone, almeno in una determinata fase, al pubblico ministero o al giudice di attivarsi in sua vece. Se lui lo fa, in qualche misura, tra l'altro, necessariamente si sta schierando. È un intervento supplente fondamentale, ma perché noi dobbiamo prevedere a monte un intervento supplente? Per non operare invece attraverso, prima in via interpretativa, poi in via normativa, per riconoscere un diritto che è fondamentale. E qui torno a quello che si è detto a proposito dell'armonizzazione, perché qui volevo arrivare. Nel momento in cui si continuano a vedere delle falle rispetto al sistema processuale interno, che comportano una diminuzione di garanzie anziché un surplus, proprio perché l'Europa ci avrebbe abituato in altre materie a portare dei miglioramenti nella qualità della vita, nella gestione, penso alle quote latte, mi viene in mente tutta una serie di questioni che hanno sicuramente aiutato la politica monetaria, non lo so, su questo non sono abbastanza esperto per dirlo. Certamente nel processo penale il sospetto è che tutte le volte in cui in un procedimento si instilli il connotato della transnazionalità, qualcosa viene perso. È sempre forse un po' stato così sin dagli albori, con la lettera del 431 sul discorso dell'acquisizione degli elementi raccolti con rogatoria, spuntano sempre qua e là alcune piccole deviazioni. Allora, in questo sistema, dicevo, l'arresto giurisprudenziale principale del 2007 ci ha detto no, non si possono utilizzare le investigazioni difensive all'estero. Per quale motivo? Devo dire in premessa, non voglio essere particolarmente ingiusto, ma questa credo nei 20-22 anni di angusta carriera sia una delle sentenze peggiori che io abbia mai letto quanto a tecnica di scrittura, lo dico sinceramente, perché parla senza esprimere niente, semplicemente di principi generali del codice. Io faccio fatica a immaginare i principi generali, sarebbe tutto un problema, una discussione da fare in merito alla gerarchia delle fonti, però la norma parla di principi generali, la giurisprudenza, senza esplicitare quali questi principi siano. Per poi dirci che il codice è stato strutturato in modo tale per il quale la cooperazione giudiziaria e quindi l'acquisizione della prova all'estero deve essere veicolata sempre necessariamente attraverso rogatoria internazionale. Questo è un'abitudine, non è la prima volta che capita, che è una norma che ha un'origine storica, e i filosofi del diritto ci insegnano che l'interpretazione storica delle norme è fondamentale, che ha un'origine storica di natura prettamente garantistica, per tutelare in qualche misura da possibili abusi, eccessi, deviazioni dal sistema ordinario, violazioni del contraddittorio, si trasforma in una spada di Damocle nei confronti dell'imputato. Il 729 non nasceva per questa motivazione, certamente, per vietare alcunché, né mi pare ci sia nessun'altra norma che lo fa. Però c'è una cosa interessante in questa norma, lascio perdere una chiara svista che è contenuta in questa sentenza, nella quale si dice, beh, d'altronde noi non dobbiamo concedere tutti gli strumenti probatori alla difesa dell'imputato, perché neppure il codice lo fa, non lo fa per esempio in materia di accertamenti tecnici non ripetibili, per il quale il difensore è obbligato a richiederli al pubblico ministero. A me pareva che in realtà la nostra normativa fosse completamente diversa. Voglio, come dire, provare a interpretare bonariamente questa definizione, pensando che si riferisse all'ipotesi di opposizione del pubblico ministero non superabile da parte della difesa, come al contrario di quanto previsto nel 360. Sia come sia, questo c'è scritto comunque all'interno del passaggio motivazionale della sentenza. Soluzioni: qual è il ricorso? Si può ipotizzare, questo in realtà è un primo aspetto, in realtà, se vogliamo anche positivo. Le rogatorie internazionali, per definizione codicistica, non possono essere richiesti dalle parti private, però la norma riconosceva, anche attraverso quel passaggio del 391 bis, commi 10 e 11, l'opportunità di, in questo caso, come se esistesse sempre una forma di rifiuto del soggetto privato. Parlo in particolare dell'intervista difensiva. Mi sono appuntato qui, mentre parlava il dottor De Amicis, di come il diritto insegue la tecnologia, la giurisprudenza dovrebbe aiutare, ma parliamo così tanto della possibilità di investigazioni difensive, sono già state superate dal fatto che dovremmo pensare ad uno strumento di investigazione difensiva per tutelarci dalla prova effettivamente informatica, chiamiamola così. Arriviamo sempre in ritardo, ma credo che sia il destino, il fatal destino dei giuristi. Da questo punto di vista possiamo dire che perlomeno è stato riconosciuto una possibilità di richiesta. Poi arrivo subito, così vado velocemente verso la fine. Qual è il problema? Innanzitutto crea canalizzazione dove non era necessaria. Io, magari per miei limiti mentali, non riesco a capire in che modo si violerebbe o si creerebbe un rischio di rapporti fra stati nel incaricare, diciamo, ipotizzare che quell'ausiliario di cui parla il 391 bis possa essere un collega straniero. D'altronde, scusatemi se faccio una battuta, abbiamo assistito per anni all'iscrizione nell'albo avvocati degli avvocati stabilizzati, perché dovevamo prevedere il riconoscimento dei titoli in tutti i paesi europei, ma non possiamo incaricare un collega all'interno dell'Unione Europea per lo svolgimento di un atto semplicissimo, qual è l'intervista difensiva su consenso della persona. Peraltro non risolve tutto, perché in caso di richiesta al pubblico ministero o al giudice di incidente probatorio, manca tutto l'aspetto che è molto molto rilevante, soprattutto nei procedimenti transnazionali, della possibilità di sentire gli imputati in procedimenti connessi o collegati, per cui non è che poi in realtà le due cose possano totalmente sovrapporsi. E inoltre, diciamoci la verità, questo forse ce l'avrebbe potuto dire l'avvocato Canestrini. Io ricordo che la prima volta che sono entrato in uno studio legale, era il 2003, le investigazioni difensive erano appena nate, sono entrato con l'entusiasmo alla Perry Mason, pensando che avremmo fatto investigazioni difensive stanzialmente per tutti i procedimenti, e l'avvocato del tempo mi ha detto: fermati immediatamente, le investigazioni difensive sono costose, sono pericolose, soprattutto non le faremo mai nel momento in cui non siamo sicuri di sapere che cosa ci verrà detto. Allora, se io posso provare a esplorare, anche informalmente, cosa mi viene detto, per poi eventualmente registrare, naturalmente il problema si risolve. All'avvocato del tempo mancava qualche elemento di natura processuale. Ma come si fa a farlo in una prospettiva transnazionale così complessa? Io dovrei avere l'ardire di invocare l'intervento dell'autorità giudiziaria, non sapendo che cosa mi verrà risposto, perché non ho neppure sondato se quel soggetto volontariamente avrebbe risposto alle mie domande, la qual cosa in genere, sappiamo tutti, depone in un certo qual modo a favore e ci spinge verso compiere o non compiere quest'atto. Si traduce sotto il profilo empirico sostanzialmente nella inutilizzabilità dello strumento. Sostanzialmente possiamo dire che attraverso questa interpretazione quindi è stata totalmente preclusa la possibilità di svolgere investigazioni difensive all'estero. Il problema della canalizzazione c'è chiaramente, ma è anche una questione di tempistica. Innanzitutto, in fase investigativa, il pubblico ministero non è obbligato a risponderci, non a rispondere con decreto motivato, ma neppure a rispondere. E qui si potrebbe pensare che effettivamente l'ordine europeo di indagine abbia fatto qualcosa in più. È stato previsto il potere di richiedere, l'obbligo di rispondere, ma forse si sarebbe potuto puntare un pochino, come dire, verso una via leggermente più virtuosa, cioè riproducendo quel sistema che è stato previsto in caso di richiesta di sequestro, che è ben più garantita degli altri strumenti, applicandolo a tout court in realtà a tutte le ipotesi di richiesta di emissione di un ordine europeo di indagine, perché avrebbe avuto almeno la garanzia di una risposta motivata e della possibilità di presentare eventualmente una forma di gravame nei confronti del giudice per le indagini preliminari procedente in fase investigativa, perché sappiamo quanto è importante la tempistica. Se non utilizziamo quello strumento, arrivati alla fase processuale, molto probabilmente quella prova diventerà del tutto disutile o comunque si sarà assolutamente dispersa. In questo progresso, diciamo, giurisprudenziale c'è stato qualche piccolo arresto, una sentenza del Tribunale di Merito di Brescia che aveva riconosciuto, diciamo, con una sorta di obiter, aveva provato a utilizzare l'ubi lex voluit, la norma non vieta, quindi possiamo farlo, ma non aveva accolto in realtà la richiesta della difensiva, perché in quel caso si trattava di un notaio, mi pare, che avesse certificato la propria stessa dichiarazione, e la Corte d'Appello di Merito di Brescia, se no bisogna comunque rispettare la procedura sufficientemente rigida del 391 bis, aprendo implicitamente all'idea che in caso di rispetto della normativa interna l'atto sarebbe stato utilizzabile. Poi si è avuta un'altra evoluzione positiva, che va salutata certamente con favore, creando una distinzione, anche se per certi aspetti un po' criptica e nebulosa, creando una distinzione da un lato tra documento e documentazione, che ben conosciamo da un punto di vista interno, ma dall'altro tra investigazioni compiute prima dell'iscrizione della notizia di reato e indagini compiute successivamente all'iscrizione. In che senso? La giurisprudenza ha segnalato come, anche questa è una cosa che mi giunge nuova, ma per mia ignoranza, come prima dell'iscrizione della notizia di reato è una scelta volontaria della parte privata. Il nuovo arresto riguardava la possibilità di acquisire un elemento probatorio richiesto dal difensore della parte civile. Poi ognuno, fino a quel momento, era sempre stato rigettato, in questo caso è stato accolto, ma ben venga, ognuno poi può trarre le conseguenze che crede. In questo specifico caso si trattava di un documento in possesso di una pubblica amministrazione che semplicemente il difensore si era fatto trasmettere tramite un legale, mi pare, se ricordo bene, un legale del luogo. Qui appunto vi dicevo, mi sono interrotto, la giurisprudenza ha detto la scelta se entrare, diciamo, all'interno della regolamentazione tipica delle indagini preventive precedenti all'iscrizione della notizia di reato è una scelta del difensore, che può decidere di compiere sostanzialmente attività in via informale, ovvero, se è stato formalizzato l'incarico, svolgere indagini preventive. Io ho qualche dubbio su questa decisione, immagino difensore a dichiarare no, le sto svolgendo a titolo di investigazioni preventive, no, invece in questo caso era una mia ricerca privata per mera cultura. Questo francamente un po' di dubbi me ne lascia, ma almeno in parte risolve qualcosa. Che cosa risolve? Perlomeno un primo passo verso l'acquisizione di documenti già esistenti all'estero, perlomeno una differenziazione tra la documentazione, nel caso specifico dell'investigazione difensiva, e il documento già preformato, per il quale non riesco a immaginare quali difficoltà potevano esserci, tra l'altro presso un'amministrazione pubblica, per l'acquisizione dello stesso, e quale principio generale avrebbe questo dovuto violare. Potrei parlare per ore di questo argomento, anche perché mi piace particolarmente, ma non voglio non voglio togliere tra l'altro ulteriore tempo, perché capisco anche l'essere, come dire, confinati al prima di pranzo. Semplicemente chiudo con una considerazione di carattere più generale. Se perlomeno con l'ordine europeo di indagine si è cercato con una piccola incursione, io credo forse che per convincerci che questa forma di armonizzazione possa portare a degli effettivi miglioramenti, convincerci anche che possiamo avere un processo penale migliore e più garantito anche attraverso la cooperazione, serviva fare molto molto più di quello che si è fatto. Grazie.
Grazie professor Barrocco. Certamente un campo in cui tanti passi devono ancora essere abbozzati prima di essere, prima di essere formalizzati, perché davvero ci sono delle lacune, nonostante qualche spunto e qualche sprazzo positivo nella prassi. Adesso è la volta del tema, di trattare il tema dalla cooperazione giudiziaria all'armonizzazione europea in materia di confisca. E questo tema lo tratterà la professoressa Roberta Casiraghi dell'Università Cattolica di Milano, che ha studiato anche specificamente questo argomento e naturalmente sul piano della prospettiva della cooperazione internazionale in modo specifico. È un tema in cui sarà interessante notare, sia pure nel breve tempo, poveretta, è collocata alla fine di questa lunga mattinata. È un campo in cui si è sperimentata sia l'armonizzazione, si è tentata sia l'armonizzazione sia il mutuo riconoscimento. È uno dei rari campi in cui abbiamo iniziative dell'Unione nell'uno e nell'altro dei due poli che contendono, diciamo, la dialettica dei nostri temi. Quindi subito la parola alla professoressa Casiraghi, che ringrazio.
Grazie Presidente, ringrazio anche la professoressa Gabriella Di Paolo per l'invito e mi unisco al ricordo della professoressa Marchetti. Venendo all'oggetto della mia relazione, è ormai un dato di fatto che per assicurare che il crimine non paghi sia necessario rafforzare le norme in materia di recupero e confisca dei beni criminali. E tale rafforzamento, come ha indicato poco prima il Presidente, è passato sia attraverso la cooperazione giudiziaria sia attraverso l'armonizzazione. In particolare esamino quindi i due ultimi atti in materia che vengono in oggetto, che vengono in rilievo, ovvero il regolamento 1805 del 2018 e la direttiva 1260 del 2024. Se il regolamento ha l'obiettivo proprio di rafforzare il mutuo riconoscimento prendendo atto di una certa disomogeneità tra le regole nazionali, e per questo si spiega il regolamento, quindi prendendo atto dell'imperfetta armonizzazione, la direttiva invece ambisce a prevedere in un certo senso norme minime proprio allo scopo di consentire il ravvicinamento delle disposizioni degli Stati membri e quindi di raggiungere una più effettiva armonizzazione che è parsa fondamentale proprio per poi garantire realmente il mutuo riconoscimento, perché il mutuo riconoscimento, basandosi sulla fiducia reciproca tra i paesi, richiede, in un certo senso presuppone una certa quota di armonizzazione, altrimenti avremo il fallimento del mutuo riconoscimento. Cercherò di tratteggiare a grandi linee i due atti partendo dal regolamento. Il pilastro dell'intera procedura è dato dall'articolo 18, il quale prescrive in capo all'autorità di esecuzione l'obbligo di riconoscere il provvedimento di confisca ritualmente trasmesso e di prendere sostanzialmente tutte le misure necessarie alla sua esecuzione come se si trattasse di un provvedimento di confisca nazionale, sempre però che non sussista uno dei motivi di rifiuto. Ed è qui interessante soffermarci, ovviamente non elenco tutti i motivi di rifiuto, ma mi soffermo su due motivi di rifiuto anche per il rilievo che possono avere nel quadro interno. Anzitutto va menzionato quello che è opponibile allorquando in situazioni eccezionali sussistono seri motivi per ritenere che l'esecuzione del provvedimento di confisca comporti, nelle particolari circostanze del caso, quindi concretamente, una palese violazione di un pertinente diritto fondamentale previsto dalla Carta. In particolare si ricorda il diritto a un ricorso effettivo, il diritto a un giudice imparziale, i diritti della difesa. Secondo motivo di rifiuto che rammento è quello derivante dalla mancata partecipazione personale di colui che subisce il provvedimento di confisca, qualora non si sia contemporaneamente realizzata una delle condizioni alternative previste, tra cui quella che egli sia stato informato in tempo utile del fatto che tale provvedimento di confisca possa essere emesso in caso di sua mancata comparizione in giudizio. Vedremo poi perché vengono soprattutto questo motivo viene in rilievo con riguardo alla confisca nei confronti dei terzi. Passando alla direttiva 2024, essa appunto in un certo senso nasce proprio dall'esigenza di evitare o quantomeno limitare le occasioni di rifiuto all'applicazione del regolamento. Premetto che la direttiva non si occupa solo di delineare modelli di confisca, ma cerca anche di tratteggiare norme minime in materia di reperimento, di identificazione e di gestione dei beni. Qui per motivi di tempo mi limito a indicare le diverse tipologie di confisca che sono tratteggiate dall'articolo 12 all'articolo 16 della direttiva stessa. Sono previsti 4 modelli di confisca, 3 modelli erano già previsti nella precedente direttiva del 2014, c'è invece un quarto modello che è quello l'autentica novità, perché per la prima volta in un certo senso si fa espressamente riferimento a un modello di confisca senza condanna. Ce n'era già uno, che è quello anche delineato dall'articolo 15, però riguarda situazioni molto particolari. L'articolo 12 prevede la confisca sostanzialmente tradizionale, fondato sulla condanna definitiva, declinato tanto nella sua forma diretta, tanto in quella nella sua forma per equivalente. Si precisa solo che con riguardo alla confisca di valore degli strumenti del reato si prevede solo, data la sua natura punitiva, essenzialmente punitiva, si rammenta espressamente il principio di proporzionalità. L'articolo 13 invece impone agli Stati di consentire sostanzialmente la confisca nei confronti dei terzi, solo però a condizione che confiscare a fine dei terzi, ovviamente quando il trasferimento a terzi è avvenuto al fine di evitare la confisca stessa. Infatti proprio questa confisca nei confronti dei terzi si giustifica alla sola condizione che il terzo sapeva o avrebbe dovuto sapere sostanzialmente che il trasferimento dei beni è stato effettuato proprio per evitare la confisca, e quindi sostanzialmente si deve dimostrare in un certo senso che il terzo non sia in buona fede. Sottolineo che è onere dell'accusa dimostrare la mancanza di buona fede del terzo, perché altrimenti sostanzialmente verrebbe aggirata la presunzione di innocenza. Vengono indicati degli indici di malafede in un certo senso, si fa riferimento in particolare come indici di consapevolezza o quantomeno di colpa il fatto che il trasferimento o l'acquisizione siano avvenuti a titolo gratuito o contro il pagamento di un importo significativamente inferiore rispetto a quello di mercato. Sottolineo però che non si tratta di presunzioni, sono dei semplici indici che non possono però mai essere letti alla stregua di presunzioni, proprio perché, come ho detto prima, è onere dell'accusa poi dimostrare tale consapevolezza o quantomeno tale colpa. Passiamo al secondo modello di confisca, articolo 14, confisca estesa, sostanzialmente assimilabile alla nostra confisca allargata. Si prevede che questa forma di confisca debba essere applicata almeno ai cosiddetti Eurocrimes, laddove siano punibili con una pena privativa della libertà di durata massima non inferiore ai 4 anni. Mi limito qui a sottolineare l'incertezza dello standard probatorio. Perché? Perché in inglese si parla di satisfied, mentre nella versione italiana si fa riferimento al giudice deve essere convinto, mentre nella versione inglese si parla del giudice deve essere soddisfatto, nella versione italiana si dice il giudice deve essere convinto, e si è sottolineato come convinto si ponga possa porsi su uno standard più elevato rispetto a soddisfatto utilizzato nella versione inglese, e che comunque però siamo al di sotto della soglia del pienamente convinto, quindi c'è anche qui un problema di standard probatorio. In ogni caso, anche qui mi limito a sottolineare che il giudice deve considerare tutte le circostanze del caso, tutti gli elementi di prova disponibili, tutti i fatti specifici. Si fa riferimento anche, ad esempio, al valore dei beni che è sproporzionato rispetto al reddito legittimo. Tuttavia, mi limito lo sottolineo proprio perché può venire in rilievo con riguardo alla nostra giurisprudenza, all'applicazione della nostra confisca, qui il valore sproporzionato è solo un indice e non può essere l'unica base da cui far derivare l'illecita origine del bene. Terzo modello, si prevede una confisca senza condanna. Prima ho detto che l'articolo 16 considera è la vera novità, però già l'articolo 15 e sulla scorta di quanto già prevedeva la direttiva 2014, prevede una sorta di confisca senza condanna, però è molto specifica questa ipotesi, in quanto questa forma di confisca può essere applicata quando sostanzialmente non sia possibile concludere il processo penale per determinate circostanze, per determinate cause. Nella direttiva del 2014 si faceva riferimento a ipotesi sostanzialmente marginali, si parlava di malattia o fuga dell'interessato. Con la nuova direttiva del 2024 a queste ipotesi si aggiunge il decorso e soprattutto per quanto può interessare il decesso e per quanto può interessare il decorso dei termini di prescrizione. Nella proposta di direttiva si rimaneva vaghi nell'indicazione dei termini di prescrizione. Nel testo definitivo si fa riferimento a termini di prescrizione qualora siano inferiori ai 15 anni. Sottolineo che la concreta applicabilità di questa confisca è subordinata alla condizione che il procedimento penale pertinente, se fosse proseguito, avrebbe potuto portare a una condanna. Quindi è evidente sottolineare questo e spetta all'accusa dimostrare la sussistenza di tutti gli elementi del fatto illecito, del reato, e nonché, sebbene si sia sottolineato con uno standard probatorio meno rigoroso, l'origine illecita dei proventi o comunque il carattere strumentale al reato dei beni da confiscare. Arrivo ad ora velocemente, ma almeno forse sono stata veloce, ma non voglio rubarvi troppo tempo, anche per dar spazio ad alcuni riflessi con riguardo all'ordinamento interno. Arriviamo alla confisca prevista dall'articolo 16, ossia un modello di confisca senza condanna, che lo stesso articolo 16 in un certo senso definisce residuale rispetto alle forme di confisca precedentemente previste. Adesso vi limito ad accennare al carattere residuale, poi faccio qualche breve approfondimento su cosa si intenda con residualità di questa forma di confisca. Sostanzialmente, cercando di limitare al più possibile questa forma di confisca senza condanna, l'ambito di applicazione è ristretto a quello ai reati gravi, punibili con pena superiore nel minimo a 4 anni, e si applica solo ai proventi o ai prodotti del reato. Perché? Perché la norma richiede espressamente che i beni identificati derivino da condotte criminose. Sempre allo scopo di circoscrivere il perimetro di questa forma di confisca, si prevede che le condotte criminose debbano in un certo senso aver prodotto un vantaggio, si dice un vantaggio economico considerevole. È vero, come vi ho detto adesso, questo parametro serve appunto per circoscrivere l'ambito di applicazione di questa forma di confisca, però mi sia dato di rilevare il carattere forse scarsamente denotativo. Che cosa sia il vantaggio economico considerevole è difficile quindi il rischio ovviamente che sia lasciato alla discrezionalità. Si fanno salvi poi i diritti del terzo in buona fede, si prevede poi che gli Stati membri possano fissare un periodo di tempo entro il quale ritenere che tali beni siano derivati da condotte criminose. Si fa riferimento alla possibilità, quindi in termini facoltativi, che gli Stati prevedano che questa forma di confisca debba essere preceduta dal congelamento, quindi dei beni. Sottolineo la facoltatività perché nella proposta di direttiva era invece obbligatorio questo carattere, che invece adesso si è passato alla facoltatività. Inoltre, SIL considerando 33 richiama, seppur in senso non proprio forte, il principio di proporzionalità. Veniamo poi a capire come si può arrivare a questa confisca. L'articolo 16 stabilisce che nel determinare se tali beni debbano essere confiscati si tiene conto di tutte le circostanze del caso, come al solito, ma si fa riferimento ad alcuni indici ben precisi. Si fa riferimento al fatto che il valore dei beni sia sproporzionato rispetto al reddito legittimo dell'interessato, si fa riferimento al fatto che non vi sia una fonte lecita plausibile dei beni e terzo requisito, questo un po' un po' criticabile, si fa riferimento al fatto che l'interessato sia collegato a persone connesse a un'organizzazione criminale. Perché è criticabile? Perché la connessione addirittura non è tanto non è all'organizzazione in quanto tale, ma a chi è meramente coinvolto nell'organizzazione. Quindi quello che l'auspicio è un'interpretazione restrittiva di questo parametro, fermo restando che, anche qui lo sottolineo, che nonostante in un certo senso purtroppo la disposizione apra alla valorizzazione di indici presuntivi, questa elencazione è meramente esemplificativa. Quindi comunque il giudice deve inserire questi indici all'interno di una valutazione complessiva in cui debbano tenersi conto sostanzialmente di tutte le circostanze del caso. Anche qui appare un'altra volta lecito domandarsi sullo standard di prova richiesto. Anche qui nella versione inglese si utilizza il verbo, giudice si dice deve essere soddisfatto, però si è evidenziato come uno standard probatorio poco rigoroso possa porre dubbi di compatibilità con il regolamento, richiamando l'articolo 18, scusate, il considerando 18 a cui avevo fatto cenno prima. Ho finora trascurato una questione centrale ed è quella di delimitare l'area di applicabilità del regolamento e della direttiva. Entrambi i testi si riferiscono alle confische applicate nel quadro di un procedimento in materia penale e entrambi i testi precisano che si tratta di un concetto autonomo del diritto dell'Unione Europea interpretato dalla Corte di Giustizia, fermo restando, anche qui secondo la traduzione italiana, e poi vi evidenzio il perché, fermo restando la giurisprudenza della Corte Europea dei diritti dell'uomo. Tuttavia il richiamo alla giurisprudenza CEDU va un po' inquadrato e va un po' anche capito se davvero questo fermo restando questa locuzione fermo restando sia opportuna oppure non vada in un certo senso riletta. Per capire quindi cosa si intenda cosa si intenda con il richiamo alla Corte europea, bisogna in un certo senso partire dall'originaria proposta di direttiva, di regolamento, perché partiamo prima dal regolamento, poi mi concentro un attimo sulla direttiva perché le problematiche bene o male sono le stesse. Nella proposta di regolamento il mutuo riconoscimento si imponeva solo ai provvedimenti assunti nell'ambito di un procedimento criminale. Ed è stata proprio la delegazione italiana, in un certo senso, a auspicare, a sollecitare un ampliamento. Ovviamente lo scopo era quello di includere anche la confisca di prevenzione sostanzialmente. Ma se così è, in un certo senso risulta, la finalità sostanzialmente era quello di ampliare l'intenzione, che poi è stata accolta, è quella di dare un ampio ambito di applicazione al regolamento per favorire nel modo più ampio possibile il mutuo riconoscimento. Ma se così è, risulta in un certo senso inappropriato l'impiego della locuzione fermo restando per richiamare la giurisprudenza della Corte Edu nella definizione della materia penale. Sappiamo bene perché nasce la nozione autonoma di materia penale nell'ambito della giurisprudenza della Corte europea. L'obiettivo è evitare una sorta di truffa delle etichette degli ordinamenti nazionali e permettere di estendere le garanzie penalistiche anche a procedimenti non definiti penali dagli Stati. Però se così è, ribadisco, far coincidere le due nozioni di materia penale, la nozione convenzionale e la nozione eurounitaria, darebbe luogo a una sorta di cortocircuito all'interno del regolamento. Ecco perché il termine inglese notwithstanding, usato appunto dal regolamento, forse, o meglio, è meglio tradurre con l'italiano nonostante, malgrado, non fermo restando. E cosa ne risulta sostanzialmente? Che il concetto di materia penale previsto dal regolamento e per coerenza mi verrebbe da dire dalla direttiva è autonomo non solo rispetto agli ordinamenti dei singoli Stati membri, ma anche rispetto alla giurisprudenza della Corte Edu. Però poi vedremo però i problemi che anche questo pone. D'altra parte questa nozione ampia di procedimento in materia penale trova un po' anche una sua conferma nel considerando 13 del regolamento. Analoga norma era prevista nella direttiva, poi nella proposta direttiva, poi nella versione definitiva è venuta meno. perché il considerando 13 ci dice che il concetto di materia penale contempla tutti i provvedimenti di congelamento e di confisca emessi in seguito a procedimenti connessi a un reato, e per esplicita menzione si richiamano anche i provvedimenti emessi in assenza di condanna e i provvedimenti che non trovano corrispondenza nello stato d'esecuzione. Si escludono sostanzialmente solo i provvedimenti emessi in procedimenti in materia civile e in materia amministrativa. Se però appunto le caratteristiche della materia penale vanno definite sulla scorta del criterio della connessione al reato, ci troviamo di fronte al pericolo che la nozione di procedimento in materia penale possa abbracciare anche provvedimenti applicati in procedimenti che non conoscono un adeguato statuto garantistico. Sostanzialmente questo è il rischio. E in un certo senso, forse per far fronte o per cercare di scongiurare o quantomeno di limitare questo rischio, si spiega il motivo di rifiuto che abbiamo visto prima della violazione di un pertinente diritto fondamentale. In astratto, paradossalmente, il richiamo alla giurisprudenza della Corte europea potrebbe essere meno problematico con la direttiva, che ha l'obiettivo proprio di creare norme minime. Però qui cosa avremmo? Avremmo una contraddizione tra regolamento e direttiva, e contraddizione che rischierebbe anche di compromettere la loro funzione in un certo senso complementare, perché abbiamo visto che la direttiva nasce proprio in ottica di rafforzare le potenzialità del regolamento. Qualcuno auspica quindi un intervento della Corte di Giustizia che possa in un certo senso meglio chiarire la definizione di materia penale. Ad ogni modo, nonostante quest'ampia estensione che sembra riconoscere il regolamento, lo stesso regolamento si preoccupa però di costruire una cornice garantistica alle confische. In particolare se ne occupa il considerando 18. Non è chiarissima la norma. Io ho cercato di capire, mi sembra che da questo considerando si possano distinguere 3 livelli di garanzie, a seconda che si tratti di un procedimento penale, a seconda che si tratti di un procedimento che rientri nell'ambito di applicazione del regolamento, e infine viene indicato un terzo livello di garanzia per i procedimenti che abbiano ad oggetto la materia penale. Si precisa così che per il primo, ovvero per il procedimento penale, vengono richiamate sostanzialmente una serie di direttive che io non sto qui a menzionare ovviamente. Per il seconda tipologia di procedimenti si richiamano le garanzie previste dalla Carta, e infine, ossia per i procedimenti in materia penale, quindi procedimenti non penali, dovremmo intendere quindi procedimenti non penali ma rientranti comunque nella materia penale, si richiamano le garanzie essenziali dei procedimenti penali previsti dalla Carta. Resta ovviamente, anche qui ci sarebbe da discutere, mi limito a dire che però non si tratta, l'individuazione poi di queste garanzie essenziali non è poi così scontata. Quanto riguarda poi invece la direttiva, centrale l'articolo 24 che prevede espressamente per gli Stati membri l'obbligo di garantire ai destinatari della confisca, quindi non solo l'imputato ma anche i terzi, il diritto a un ricorso effettivo, il diritto a un giudice imparziale per proprio salvaguardare i propri diritti. Viene poi ovviamente sancito obbligatoriamente per gli Stati l'obbligo di salvaguardare il diritto di difesa, viene riconosciuto agli interessati l'effettiva possibilità di contestare il provvedimento di confisca davanti a un organo giurisdizionale. In un certo senso, nell'analisi della norma, anche qui viene in un certo senso confermato come spetti all'accusa l'onere di dimostrare l'origine illecita. Spetta all'accusa addurre le circostanze rilevanti del caso e gli elementi di prova che giustificano la confisca, semmai all'interessato va riconosciuto il diritto di contestare tali elementi. Viene poi riconosciuto il diritto di avere un difensore, di essere informato di tale diritto. Vengono anche elencati una serie di diritti informativi, o meglio l'interessato deve essere informato dell'emissione di un provvedimento ablativo, e c'è l'obbligo di motivazione. Se questo è il quadro europeo, spostandomi velocemente sui riflessi interni, sono diversi diversi motivi, i profili di possibile contrasto. Mi limito a indicare due aspetti. Anzitutto emerge l'incompleta tutela dei terzi. L'elenco è lungo, basti rammentare l'articolo 104 bis, comma 1 quinques delle norme di attuazione, che collega la citazione dei terzi alla successione sequestro-confisca, ma in questo modo si dimentica in un certo senso che la mancata partecipazione dei terzi al procedimento in cui si discute di confisca non preceduta da sequestro possa ostacolare la circolazione della confisca. Avevo citato prima il motivo di rifiuto dovuto alla mancata partecipazione dell'interessato. Ancora andrebbe aggiornato l'elenco dei soggetti beneficiari del patrocinio a spese dello Stato per consentire anche ai terzi non abbienti di poter avvalersi effettivamente del diritto di difesa. Andrebbero riconosciuti al terzo i diritti d'accesso al fascicolo, il diritto alla prova. L'interlocuzione dei terzi non dovrebbe essere limitata ai soli profili dell'appartenenza e dell'estraneità al reato, e l'elenco potrebbe proseguire. C'è poi ovviamente, per concludere, la questione della confisca di prevenzione. Ho già detto che il ricorso alle formule procedimento in materia penale, procedimento connesso a un reato, suggeriscono la sua inclusione nell'ambito di applicazione dei testi qui esaminati. È però altrettanto noto come tale provvedimento ablatorio sia considerato non penale, non solo dalla nostra giurisprudenza, sia di Cassazione sia costituzionale, ma almeno al momento siamo in attesa della vicenda Cavallotti per vedere se possa apportare qualche novità anche dalla Corte Edu, con la conseguente sottrazione di questa confisca allo statuto tipico delle garanzie penalistiche convenzionali. Da ultimo c'è la sentenza Garofalo. Senza star qui ovviamente a evidenziare la questione del CEDU, ritornando al rapporto con le fonti in esame, anche qui emerge un possibile cortocircuito. Come vi ho detto prima, il regolamento al considerando 18 esige il doveroso rispetto delle garanzie fondamentali previste per i procedimenti penali previsti dalla Carta dei diritti fondamentali. Il rischio qual è sostanzialmente? Il rischio è che la confisca di prevenzione astrattamente inclusa fra i provvedimenti per quali sono applicabili le fonti in esame possa nel concreto, nelle circostanze concrete, sostanzialmente non trovare riconoscimento qualora lo stato d'esecuzione in un certo senso richiami e applichi rigorosamente lo standard di garanzia che dovrebbero caratterizzare i provvedimenti ablativi destinati al mutuo riconoscimento, potendo trovare applicazione proprio il motivo di rifiuto della violazione di un pertinente diritto fondamentale della Carta. Allo stesso modo è problematica la riconducibilità della confisca di prevenzione, quando non è scontata, all'interno del modello di ablazione patrimoniale previsto dall'articolo 16. Considerato quella cornice garantistica con cui, seppur imperfettamente, qui non mi sono soffermata eccessivamente sulle possibili imperfezioni, che anche la stessa direttiva non è stata esplicita nel riconoscere una serie di diritti che invece forse, se non nei considerando, avrebbe meritato maggiore attenzione, però c'è una cornice garantistica e sembra che questa cornice garantistica, la nostra confisca di prevenzione, non sia ancora in grado idonea ad assicurare. Basta ricordare l'articolo 24 che sancisce in capo all'accusa l'onere di dimostrare l'origine illecita dei beni, sostanzialmente non prevedendo alcuna forma di inversione dell'onere della prova. Richiamo poi, considerando 46 e 51 della direttiva, che in breve richiamano una serie di garanzie, tra cui la presunzione di innocenza e la direttiva che dà attuazione alla presunzione di innocenza, e qui si potrebbe inserire la questione della confisca di prevenzione applicata nonostante l'assoluzione e basata sulla stessa base probatoria. Ci potrebbe poi essere un ulteriore profilo di tensione laddove, che ho rilevato soprattutto leggendo il parere del professor Albuquerque presentato per la vicenda Cavallotti, sostanzialmente, in cui sostanzialmente viene sottolineato che dal carattere residuale della confisca si dovrebbe vincere la necessità che un processo penale si sia svolto e non sia stata possibile applicare una confisca diversa. Vi dicevo prima del carattere residuale. Il professore dà questa interpretazione, quindi che sarebbe possibile applicare la confisca senza condanna solo nel momento in cui le altre confische non è stato possibile applicarle. Sappiamo invece come la nostra confisca di prevenzione sia in un certo senso possa aver luogo prima, durante, dopo e autonomamente dal processo penale. Per completezza rilevo poi che questa questione era già stata sottolineata dalla dottrina e questa questione era già stata affrontata e si era arrivati ad una conclusione opposta basata sul considerando numero 34, che sostanzialmente brevemente ammette che la confisca di patrimonio ingiustificato possa anche essere ordinata separatamente dal procedimento penale relativo al reato. Quindi c'è questa, bisogna vedere l'interpretazione che si deve dare al carattere residuale previsto per questa confisca senza condanna. Arrivo proprio alla conclusione con una piccola osservazione. Mi sembra che sia ormai anacronistico, magari purtroppo o per fortuna non lo so, però anacronistico ormai ripudiare qualsiasi forma di confisca senza condanna. È però ineludibile, penso, arrivare alla costruzione di un condiviso giusto processo al patrimonio che permetta di perseguire ovviamente la lotta alla criminalità, non possiamo più farne a meno, però è importante non fare a meno neanche delle fondamentali garanzie individuali. Grazie, scusate per aver rubato il tempo.
Grazie, Grazie professoressa Casiraghi, nonostante il tempo limitatissimo, l'esposizione è stata completa, lucida e ricca anche di spunti problematici che nascono anche dalla conclusione. Non possiamo farne a meno, ma la dobbiamo costruire bene, sto quadro di garanzie, e al momento direi che proprio non ci siamo. Io credo che abbiamo esaurito in questo modo finalmente finalmente non per i relatori ma per l'orario. Rinvierei eventuali interventi a momenti più comodi e adesso c'è la pausa. Riprenderemo, mi comunica la professoressa Di Paolo, alle 15:30.
Dear colleagues and friends, please, we are trying to start again after a long morning and the lunch. Thank you very much. Now we have, as in the program, the round table on the APPO, and the title is, as you may read on the program, The State of the Play. This is a topic that I think is the most important development we had in the space of freedom, security, and justice, the most recent development after more than 20 years of debate, scientific debate, institutional debate, and now came to analyze how it's happened in the last 2-3 years, because as we know, from 2021, the EPPO is not anymore only a project, but is a body working with a very complex legislative framework, different layers, the regulation, the internal rules, and very often you have to tackle the relationship between the regulation and national rules, of course, because as you know, the regulation contains a high number of references to national law, more I think that 50 or more or less. So the situation is very complex from the perspective of the legal framework, but also if we look to the jurisprudence, we had a couple of relevant rulings of the ECJ, of the European Court of Justice, and we are debating now about amendments to the regulation. The idea is, in this roundtable, to give you an overview about areas of the regulation that needs to be amended, and to speak about main issues or some issues arise in the practical implementation and the practical use of instruments, investigating instrument, and also, I think, in the prosecution decisions. I don't want to waste time because we are very late, 1 hour of delay. So it's a great pleasure to introduce the person, the colleague and friend, Katalin Ligeti, professor at the University of Luxembourg. And Professor Katalin Ligeti is also the president of the International Association of Criminal Law, the most important, if I may, association of criminal lawyers, scientific organization, and independent organization, I would add more important. And she's the first woman to cover this role. So I'm happy also for this reason. Katalin is not only a professor at the University of Luxembourg, but now she's covering also the charge of dean. And he was the leader many years ago, if I'm not wrong, of relevant projects about the EPPO. One of them is a huge project about procedural rules that should be applied to the EPPO. And as we know, this project was remained, I could say, only on the paper because we don't have common rules governing investigation and prosecution of the EPPO. But this is another part of the story. But as you may understand, Katalin is specialized, I would say, in this field, and I'm very happy that she has accepted to come to Trento. That is not just around the corner because she's has a lot of commitments for the International Association and also for the University of Luxembourg. Therefore, thanks again, Katalin, and I give her the floor.
Thank you very much, Gabriela, and thank you for these very warm, welcoming words. It's a great pleasure to be in Trento. This is also my first time. And I thank not only for the excellent program of this conference, but also for the excellent hospitality, which I think is exceptional. As you see, we coordinated a little bit, and Gabriela had to coordinate this round table to divide the topics among ourselves. And as you see on my title slide, my subtitle is The Apple Between National Procedural Law and Union Oversight. So as the title reveals, I will talk about the judicial review, but I would like to do this in a context and also telling you why I think that judicial review is extremely important when it comes to the activities of the EPPO. And I think it has a lot also to do with that very specific context which was mentioned, which is a very complex legal framework, a very complex structural setting of the Apple. For the context, we are at the right moment to have this discussion for many reasons. The Apple has been now working for 4 years, more or less. There had been recently an impact assessment on how national systems adapted for the workings of the EPPO and how efficient the Apple is. The findings have been published by the Commission, and the new impact assessment is really starting just these days by the Commission with the help of a consultancy, looking into how the Apple regulation could be improved. And stakeholders, if I may put it that way, already laid open their priorities for reform in relation to the Apple regulation. Most importantly, the Apple itself. Ms. Laura Corduta-Kövesi has already published what are the priorities from the perspective of the EPPO. I don't hide, Article 42 and judicial review is not on this list of priorities, but I do think it's very important to talk about this aspect of the workings of the Apple. Of course, there are many other elements around the workings of the EPPO. Of course, we talk a lot, and we will talk, and my colleague speakers on this round table, we talk, of course, about competence, about evidence, Article 25, and other matters. But if we now look into the functioning of the EPPO, there are other aspects and other issues which I think receive much less attention in the debate. And I am hopeful that this new impact assessment will also look into these aspects and not only on those, let's say, red flagged or highlighted articles. Like, for instance, what does the independence of the EPPO means? The EPPO argues that it's an independent judicial authority. It shouldn't have the status of an agency. And it has a lot of practical implications for the workings of the EPPO. It has something to do with its financial independence. Very important. Can an agency, a judicial agency, be really independent without financial independence? What is the role and the powers of the administrative director? Who decides, for instance, if there are enough EDPs, delegated European prosecutors, in a country? Is there enough budget for the operation of the case management system of the EPPO? Should the registry of the EPPO be multilingual? There are many, many practical aspects of the workings of the EPPO to which I think has no assessment yet looked into. And I really hope that the ongoing assessment will go beyond just the articles. And I'm quite sure that Andrea will also share with us some insights on these internal workings. There is a lot of question also around the status of delegated prosecutors. Should there be single head, double head? Should they have the status of special advisors? How does the operational autonomy of the EPPO works? What if a country like Slovenia decides we don't appoint EDPs, but the EDP should mandatorily investigate cases? So I think that there are many questions around the EPPO, and at least just to come back and link back to the morning session of this conference, this is certainly not an area of stagnation or lack of development. There is a lot happening on the ground, and it really merits a lot of attention. John Farfalla mentioned this morning that the last 15 years of development of the European area of criminal justice led to a very strong reinforcement of the transnational dimension of this area. And I would like to actually start from there, because if we look into the annual report of the EPPO, I believe that one aspect that sets the EPPO apart from national prosecutions is the very high percentage of transnational cases. According to the annual report of 24, 488 cases were VAT fraud cases, and we know from the competence of the EPPO, these cases only come into the competence of the EPPO if these are transnational. But altogether, 767 cases are transnational, so really roughly a quarter of cases that the EPPO deals with are transnational cases. And my question that I would like to address in my presentation, how does this transnational aspect work with national criminal justice systems, national criminal procedure, and national judges reviewing the legality of the procedural acts of the EPPO? I will give you a very brief historical overview on how the system of Article 42, which is on judicial review, is framed in the legal framework. I'm sure you are all familiar with it, but I think it's quite interesting to look into what was the critique back the days, what are the scholarly critique on the way judicial review is regulated in the legal framework. And if this critique is mirrored in any way by practice of national courts, of national judges, when they exercise actually review of activities of the EPPO. And with the help of the legal service of the EPPO, I looked into some national case law. It's not representative, but I think it shows some tendencies, and this is where I will focus also on how much guidance, of course, these national judges get from the European Court of Justice. Is this enough? And eventually, whether Article 42 should be one of the provisions for priority when the European Commission is looking into an amendment or a potential reworking of the regulation. So to start with, and Gabriela already mentioned in her introduction, the EPPO is hybrid in many ways. It's in charge of investigation and prosecution, but the adjudication is before national courts. The central structure is completed by a decentralized structure of the EDPs, and the European rules on prosecution are complemented with national criminal procedural rules, but also with soft law, both European and national. So indeed, it's a complex legal framework. The question from the beginning was, how can the review of legality of activities of the EPPO be ensured? And one could think, and many in academia, including myself, argued that the EPPO is a union body, so judicial review should be, of course, at the level of the EU courts. This is not what we see in Article 42 in the treaty, because Article 42 in the EPPO regulation, because Article 42, first paragraph, provides for a derogatory system, so to say, of judicial review and largely subjects the EPPO's procedural acts to review by national courts. And if we look into the legislative history of the EPPO regulation, it becomes also evident that the Commission's original proposal has changed quite a bit during the negotiations from proposal to actual EPPO regulation, but Article 42, surprisingly enough, had very little modifications. The Commission came up in the original proposal that for the performance of its actions, the EPPO should be assimilated to a national authority, and actually did not give up much this idea until the EPPO regulation. So it's national review, except for the scope of preliminary reference, which is specified in Article 42(2) of the EPPO regulation. So on very specific elements, if it touches essentially on European law or the regulation itself, national courts can seek guidance from the European Court of Justice. The Commission gave 5 reasons for this derogatory system. Most of these reasons are more practical, I would say, than theoretical. The hybrid nature of the EPPO was seen by the Commission as a good reason to subject the EPPO to the EPPO's activities to national judicial review. It has a strong interaction with national judicial authorities and with national law. National courts have easier access to the case file, that is for sure. There is a need not to overburden the European courts. That's also, I think, a very compelling reason. And the Commission argued that there should be consistency between ex ante authorizations, which are given by national courts for EPPO investigations, and ex ante review. Many academics, as I mentioned, including myself, from the very moment the Commission proposal and later on the EPPO regulation was published, criticized Article 42, saying that this will lead essentially for national courts making different and potentially even contradictory assessments about the legality of the acts, procedural acts of the EPPO, especially when the central office, so the chambers, take decisions which affect several member states. Now, in the following, I would like to look into whether this critique is actually mirrored by practice by national courts. What we see from the cases, and as I mentioned, it's not an entirely comprehensive, let's say, empirical look into all of the national judgments which I passed down by national courts. But what the legal service the legal service of the APO collects all these cases, and what they show in the cases is that national courts don't really use the possibility for getting guidance from the Court of Justice, even if they can. Now, one can speculate, why is this? One very easy reason to think about is that it causes delays in the proceedings, and this is not well reconcilable with all the expectations on expediency in handling cases. Another explanation, which I think is more tangible if one looks into the different cases that and different judgments that national courts hand down, that it seems that even when there is an aspect which touches upon elements where there could be a preliminary reference, national courts believe that they have full clarity on European law, so they don't need to ask the Court of Justice. Now, is this problematic or not? I think it's, I put reference to two Italian cases. I got them from the legal service. I don't know if they are published actually in Italy. They relate to EU subsidy, and the question was whether the Italian, whether the EPPO can also investigate and have competence to the inextricably linked national subsidy, so violation of national rules on subsidy. Two courts, also geographically located quite close to one another, Palermo and Trapani, came to two different conclusions. The court in Palermo said yes, inextricably linked offense, so EPPO can investigate. Trapani said no, investigations for the inextricably linked offense is not possible. Is this problematic for the EPPO? I would argue yes. What can be done about it if national courts don't refer and don't seek guidance from the Court of Justice? What we just see from the preliminary references, there are very few. There is actually a very recent one, and I thank you, Andrea, because he shared it with me, introduced by the Belgian court, and it's about a customs case that the investigation dates back to 19 and 20, so before actually the EPPO became operational. But the summons to the offenders were delivered on a date where the EPPO was actually already operational. But the EPPO was not informed about this investigation, so the question is whether it should have been, and if it should have been, if it would have been informed, it could have exercised its right of evocation. So the question relates to the interpretation of Article 24 of the EPPO regulation, how to interpret at any time after the initiation of an investigation. National authorities have the obligation to inform the EPPO so that it can assess whether it exercises its rights of evocation or not. So maybe we can say that national courts slowly start to take advantage of the possibility of the dialogue and guidance they can get from the Court of Justice. But it's surprisingly, I would say, surprisingly in comparison to the large volume of cases that the EPPO has, and in comparison to how many times Article 22, Article 25, Article 24 come up in these cases, they don't turn to the Court of Justice. So instead, they actually exercise the review based on Article 42.1 under national criminal procedural law. Article 42.1 is very broad. It doesn't give much guidance to the national court or national law how to handle this review. It doesn't say who is entitled to request the review, what are the timeframes or procedures, what are the modalities for this review, what is the scope of the review. is the national court confined to only state the violation, or can it actually remedy the violation? Is it limited to the legality, or can it go beyond legality, like, for instance, expediency of a certain measure? So it gives a lot of leeway, actually, for national criminal procedure. What we know from European law is that there must be judicial review if fundamental rights of persons are impacted. But what if the EPO's procedural acts do not directly impact the suspect or other persons in criminal proceedings? And here we have a very recent judgment coming from April from the Court of Justice, which concerned investigations in Spain, also in a subsidy fraud case. 2 directors of companies were investigated by the EPPO, and the EPPO issued summons against witnesses. The question was whether this can be reviewed and challenged. The court took, and I will not do a detailed analysis of this decision, but what I just want to highlight is that the court had the opportunity to actually decide that procedural acts of the EPPO is an autonomous concept of EU law, but then differently from existing other case law in European criminal law, especially governance and other cases, the court did not go on to actually assess whether that witness summon is a procedural act or not, but instead it gave guidance to the national court according to which to decide. So deferred back actually the assessment of the possibility whether this is this particular witness summon is a procedural act of the EPPO. The European Court of Justice gave guidance, gave a lot of elements for the national court to decide. It also did not decide on the form of the judicial review, whether it should be direct or it can be indirect. So what we see from this judgment is that the European Court of Justice attaches a lot of weight to procedural autonomy of the member states when it comes to judicial review and EPPO investigations. And it seems that is quite cautious in going further or giving more, let's say, interpretation and concrete determination. Now, this will actually bring us back to square one, where the national courts can do this judicial review with the guidance that they get from the Court of Justice. First, they don't seek for so much guidance, but when they seek, the court is very respective of procedural autonomy. And I look into the example of VAT investigations, VAT fraud cases. I take this example because these are clearly transnational cases. And for me, the question is, why national judges feel so comfortable to exercise judicial review without going to the Court of Justice? And if this is a sufficient perspective from the national judge on the transnational dimension of the case. So VAT fraud cases are clearly, if they come to the EPPO, they are transnational. According to the EPPO regulation, when several connected offenses fall within the EPPO's competence, the case should be investigated by the EDP, where the focus of the criminality lies. The question is, where is the focus of criminality for these VAT fraud cases? And what we see in the EPPO practice, and maybe Andrea will correct me if I'm saying something wrong, is that there is no settled no real settled practice with the EPO. One can do these cases two ways. One way is to give the investigation to one EDP, who is the lead EDP of the investigation, and the permanent chamber, either during the investigation or after the investigation was concluded, sends part of the case to the countries and the EDPs concerned. Another way of handling these cases is actually treating them, I would say, as quasi-national investigations by mirror investigations in all of the countries where this VAT carousel fraud is present. And I think that these mirror investigations are not uncommon in the practice of the EPPO, which then leads, of course, to a situation that the national judge looking at the VAT fraud case, which has a lot of transnational elements, will only look at the national investigation and look into judicial review in relation to that national part. But from the suspect's perspective, the suspect is confronted with evidence which was collected in multiple parallel investigations according to very different legal safeguards. So I would argue that, in my opinion, neither the practice really of handling these cases in the EPPO nor Article 42 is really helpful for judicial review and protection of fundamental rights in EPO investigations. And certainly Article 42 merits a closer look by the legislator when thinking about amending the EPPO regulation. More guidance can be given, I think, in the text of the EPPO regulation already on Article 42.1, how to exercise actually the judicial review by national courts, but also how to handle really the transnational aspect of these EPPO investigations. These are not all of the EPPO investigations, but as I mentioned at the beginning of my presentation, a large number, I would say, not yet majority, but if sanctions violations will come potentially as an enlarged competence of the EPPO, I think even more, there will be many, many cases of a transnational dimension, and this is not captured from the perspective of judicial review. I stop here. Thank you very much.
Thank you, Katani, for this comprehensive overview and very rich suggestions about the issue of judicial review. I think that you gave us a lot of food for thought looking to the practice. And speaking about the practice, I immediately give the floor to Andrea Venegoni. Many of you already know Andrea Venegoni. He's now, at the moment, he's a European prosecutor for Italy, but in the past, he worked many years at the Olaf. So he had a different point of view in the past, but I think that now we are speaking about the practice. We are trying to coordinate our intervention, and Andrea told us that we will speak about the functioning of the PPO from the internal side, of course. Thank you very much, Andrea. And
thank you. Thank you very much, Gabriella. Thank you very much, first of all, for the invitation. For me, it's a pleasure to be here in Trento after so many years and to be with you, because after all, most of us have made a common path over a professional path in the previous years. We have known for more than 10 years, and when we spent together part of our time when I was in Olaf on this project on establishing the PPO. Then in the PPO now there are some people, well, I joined the PPO 2 years ago, I have to tell you, so some people have started to work in the PPO before me, those who joined at the beginning of the PPO. And sometimes they tell me, At the beginning, in 2020, 2021, we were the first to arrive in EPPO, but I always say, but you don't know that there are some people like me and like them who have known EPPO before PPO was established. So maybe I'm a bit ahead of you because of this reason. And for me, it's also very interesting just because I had this professional opportunity to contribute, to write the proposal of the Commission and to think about the structure and the functioning of EPPO before it existed. It's a very interesting experience to compare the thoughts that we had at that time with the current situation and to see if the if the current situation corresponds, somehow matches with our reflections that we did at that time. So thank you again for inviting me. I think the most useful thing that I could do for everybody, also to give you the opportunity to exploit the advantage of having someone who works in EPPO and also so to leave space for some questions if you want, is to give you an oversight of the achievements, I would say. So things that so far worked well, we can say in EPPO, and of the topics that we can say are still under the spotlight, especially for the future. Now, as you know, next year, the process of review of the EPPO regulation is going to start, so there are a lot of things at stake, a lot of things that the practice of this year has shown that deserve some change or some adjustment. In my view, the main achievement that certainly we can say EPPO has reached so far is the development of the concept of single office, we have to say. EPPO basically has been conceived to be a single office. A single office means that the EDP working in the office of Venice, who covers this area, and the EDP working in Madrid, in Tallinn, or in Prague are colleagues of the same office. This is the most important novelty of EPPO, and I would say achievement, because today really we have a common spirit inside EPPO, also thanks to the practice, for example, so working together on the cases, but also thanks to some initiatives by the central office, like having meeting trainings together in Luxembourg, where all the EDPs can gather and know each other. So now we can say that more or less we all know each other. There are approximately 150 EDPs today in EPPO. And yeah, we can say that, as I said, we all know each other more or less, and this helps very much also in cross-border cases, obviously, in establishing contacts, in exchanging information and evidence in cross-border cases. This is, if we want to say that EPPO had to create a single European office, I would say that this goal has been achieved. Also thanks to the commitment, to the effort of Laura Covesi, of the chief prosecutor, who devoted a lot of her time to build up this concept. So we can really say that we are building up a new European judicial authority, because at the end of the day, EPPO is a new European judicial authorities who is entitled to carry out criminal investigations in the territory of the member states, besides, in addition, let's say, to the national authorities. This is, in my view, the most important achievement that is not maybe, that has not been completely understood by the national authorities. So we are starting to have some discussions, let's say, with the national authorities, because this is a revolutionary concept, if you think about it, because obviously only the national authorities have been entitled to carry out criminal investigations in the state territory for ages, for centuries in some cases. And now the fact that a new body, a new judicial authority can do the same things by replacing the national authorities is something that is astonishing for some of them. When they get in touch with us for the first time, they tell us, but who are you? What do you want from me? If you want to exchange information, I can tell you something, but sometimes they have not understood yet that we can carry out investigations on their place. So this is the first achievement, in my view, very important. Another interesting achievement, interesting for me at least, is the functioning of the permanent chambers. I don't know if you are aware more or less of the structure of EPPO. As you probably know, the permanent chambers did not exist in the proposal of the Commission in 2013. They were conceived and introduced in the regulation during the negotiations by the member states, together with the College of the Prosecutors, because in the original proposal, the college didn't exist as well. So there were a lot of doubts at that time about the functioning of the permanent chambers, because the permanent chambers are a sort of small panels composed by 3 prosecutors each, and they have to assess the cases of the member states other than the member states where the prosecutors come from. So just to make a practical example, in the permanent chamber where I'm a permanent member, I don't assess the Italian cases. I assess the cases of the other member states. Then, as Italian prosecutor, I am guest, permanent guest, we can say, of the other permanent chambers to introduce the Italian cases and to discuss the legal issues in each Italian case. There were a lot of doubts about the functioning of the permanent chambers, because someone said, how is it possible that 3 prosecutors coming from member states other than the member states of the case can understand the legal issues, the legal problems of that case? Honestly, I have to tell you, in my view, they are performing very well, because the prosecutors composing them are experienced prosecutors, and because there is a mix in the decision of the permanent chambers. I always say there is a mix of national law, because each prosecutor says, also in my member state, this situation is governed in this way, so maybe if I was in my member state, I would decide like that. It's a mix of European law, obviously, because we are bound to the regulation and to the European principles. But also, I would say it's a mix of, we can say, common sense in a way, in the sense that some issues, okay, they are legal issues, but they are, we can say, common legal issues everywhere. So if I have to assess whether or not a certain situation amounts to a fraud, I don't need necessarily to know all the legislation of that member state, but I can also use my common sense and say, well, probably we still need this information to understand exactly whether or not this is a fraud. So this mechanism is very interesting, and we also had cases in Italy, for example, where the permanent chamber rejected the proposal of the EDP. Apparently, it was a decision that didn't make so much sense. For example, permanent chambers that requested the EDP to carry out additional activities. And when the EDP carried out those additional activities, they found evidence that otherwise they wouldn't have found. And so the dismissal became, after some months, a proposal of prosecution. It may happen, and it happened concretely. So that means that this mechanism is performing, from my point of view, well. Maybe, obviously, there is still something to adjust. Obviously, the assessment of the permanent chamber changes depending also on the complexity of the case, because one thing is assessing a specific legal issue, a specific situation. Another thing is assessing a huge cross-border case that requires to read thousands of pages, also in our informatics system, which is maybe is not the most practical informatics system, let's say. So there is still something that obviously can be improved, but in general, the mechanism works very well. Also, I would say the mechanism of Article 31 is pretty satisfactory, especially after talking about the role of the Court of Justice in the in the implementation and improving the EPO regulation after the decision of the Court of Justice in the Austrian-German case that you probably know in December 2023, that somehow clarified who can challenge what and where. And this clarification from the Court of Justice helped to make this mechanism of Article 31 easier, let's say. So now Article 31 is commonly used. It's working very well. Also, on Article 31, obviously, there are some issues that should be specified about the transfer of evidence. But if I look at the Italian case law, honestly, I don't have in mind cases where the transfer of evidence from another member state was challenged before the Italian court. I'm not aware of that, I would say. So that means that probably so far, at least in the Italian cases, the transfer of evidence worked well, even when evidence is collected abroad. So these are only some of the good achievements, in my view, that EPO has reached in these first 4 years. What should be under the spotlight in the future? Many other things, let's say. Certainly, another outcome of these first 4 years is the clear, let's say, the emerging, we can say, of clear different investigative and prosecutorial skills, if we want to say like that. In the sense, this is very clear when you look at the number of the annual report, the annual that Katalin already showed. Currently, we have, at the end of 2024, we have around 2,600 ongoing investigations, and out of these 2,600, 760 cases are Italians. So we are, by large, the country with the highest number of cases. Does it mean that this is what the press always asks me every year after the press, when the annual report comes out? Does it mean that Italy is the worst country in the European Union or in EPO, that we have more fraudsters than the other? Or I always give the other version. I say, no, we are the country that has the best investigators and the best prosecutors, obviously, because we have a specialized financial police, we have prosecutors who has worked in a system where the prosecutor is the boss of the investigation, so we know how to lead the investigation, how to lead the financial police. But clearly, I would say there is a strong imbalance among member states, and I think this shouldn't happen, especially among member states with the same dimension, more or less. So this is something that, in my view, has to be looked into in the future. Another big issue, obviously, it was mentioned already, but it's clear also from the previous presentations, is the lack of common or at least harmonized procedural rules. This is also an issue because, okay, Article 31 works well, but I always say if we had a certain degree of harmonization of common rules, procedural rules, everything would be more clear and we would have less legal problems than we might have today, potentially. Also in a perspective of protection of the defensive rights. I keep thinking that to the end of protecting the right of defense, it's better to have a certain degree of common procedural legislation rather than having the fragmentation that we had in the past and that we have currently in EPO. So I think that also the defense lawyers somehow should be in favor of establishing a common set of procedural rules in order to protect the suspects in cross-border investigations. Certainly another topic that still has to be completely fixed is the topic of the relation with the national authorities. I already mentioned it partially. This has to be absolutely fixed because we don't have to to have any kind of contrast with, we have to cooperate with the national authorities. We are a separate judicial authority, but we have to cooperate with the national authorities. Our problem should be the fraudsters, not our national prosecutors. So we should be on the same side. We need to find a way to fix this problem. Another issue that, in my view, deserves a reflection, and here I partially recall what Katalin said, is the problem of the shared competence with the national authorities, the famous Article 25, as we said. The system turns to be too complicated, in my view, today. It's too cumbersome. You have to make a lot of, sometimes also practical calculation to check the punishment, to check the sanction, or to check the amount that has been evaded, the damage to the national system rather than to the European system. It's too complicated, and also because the reality is not black or white, but sometimes the reality is gray. Now, as Katalin said, we have cases where the same company, for example, submits 3 applications, and in 2 of them they receive European funds, in 1 of them they receive national funds. Probably they don't even know the nature of the funds, they only want public funds. So for them, it doesn't matter if they are national or Europeans. And this is a very strong legal issue. It turns to be a very strong legal issue. We have to fix it. Just to complete what Katalin said, I can tell you that in Italy so far, we also had, not in Article 25, but in another similar issue, in a VAT fraud case, where we prosecuted a case in which the overcome of the threshold of 10 million were not exactly clear. There was an objection to the judge, and this legal issue reached the Supreme Court, and the first decision we are aware of the Supreme Court about the consequences of EPPO prosecuting a case that apparently does not fall completely into the EPPO competence were favorable to us, because the Supreme Court said, but it doesn't matter. The important thing is that it's a prosecutor who prosecuted the case. It doesn't matter if it's national or European. So for the moment, we are using this, obviously, this decision, but it is, I completely agree with Katalin that the national judges should learn to make use of the preliminary ruling to the Court of Justice, because otherwise the system will never progress. If the judges don't go often to the Court of Justice, we will never have clarification on certain key issues, and in each member state, each court will continue to rule according to the national law or according to their feeling, let's say. But this is not the way how EPPO should work. In this sense, I would say it's the first impression that I had when I took this position in EPPO, and I'm still firmly convinced about that we need, at least in Italy, but I think everywhere, we need to organize trainings for the judges, not for the prosecutors, because with the prosecutors now, more or less, the relationships are clear. But who has in his hands the EPPO procedures is the judge. It's the judge who decides. And if the judge is not fully aware of the EPPO legal framework, we may have problem in cases, because probably the judges believed at the beginning that in the EPPO trials, the national law applies, but it's not that easy. It's not completely like that, because maybe at 90% the national law is applicable, but there is a 10% of intrusion of the European law, but that 10% can make the difference. So judges must be absolutely aware of the EPPO legal framework, criminal judges. Other ongoing issues that should be discussed in the future, okay, the relationship with the other European bodies, Olaf, Eurojust, Europol. Okay, we should maybe stay one afternoon to discuss about this topic. Probably the most problematic is the one with Olaf, obviously, because as we know, now EPPO is the criminal judicial authority. So in a way, there was a sort of partial overlapping with the Olaf activity. As you probably know, the Olaf regulation has also been amended in order to create some spaces, some rooms for the Olaf investigations, also to support the EPPO investigations. But in practical terms, we have cases with Olaf complementary investigations, for example. In a way, they work well, but they are single situations. In my view, the problem has to be fixed in a more general way, and it has to be settled in a more clear way. Well, and then on the back of all these topics, there is another essential topic that Katalin also mentioned, that are the resources. We can make all the reflections, all the thoughts that we want, but if EPPO doesn't have the resources, we can't do anything. In this sense, the chief prosecutor rightly, in this 6 years, 7 years of her mandate, has devoted a lot of her time to the relationship with the European bodies to have the necessary resources to make EPPO work. Because now, if we want to have a bigger number of cases, we need more EDPs, but if we want to have more EDPs, obviously we need more money. In theory, my experience shows that we should also take on board the staff, not only in the central office, but also the staff in the decentralized office, because this is, again, another huge problem. If the staff comes from the national, from the member states, and the member states do not support sufficiently the administrative staff, this is a problem. Without the administrative staff, also EPPO, like any other judicial office, doesn't work. But again, to take on board the staff of the decentralized office, we need more resources. So it's there are huge, and then last but not least, the material competence also, which is another big issue. Do we want to keep in the future the same competence on the PIF offenses, or do we want to expand the EPPO competence to other criminal offenses, and which criminal offenses? In the last 4 years, all the list of the possible criminal offenses has been already mentioned as possible future competence of EPPO: terrorism, environmental crimes, violation of the restrictive measures. Now we'll see when the revision process will start. We'll see if the Commission now wants to propose something. But again, this is a huge topic that has to be addressed. So this was just an overview, I would say, of the different topics. And I think I would stop here. And then if there will be a session, if you have some curiosity, or if you want to know something from inside, I will be happy to answer. Thank you very much.
Thank you very much, Andrea, for this overview from inside. So the idea I had listening to you is you had a strong feeling to be part of the same body, but the main issues are about the relationship with others. Others, I mean national authorities, and of course other agencies. And the second, material competence. I think that you should fix main problem you said before expanding competences, but this is only my personal point of view, of course, because to expand material competence to terrorism and transnational other type of crimes, you should be aware that your structures and rules governing prosecution are well done. So, but it's only my personal opinion. And just one remarks about training. Very important point. Training most focused on judges because they are the key for the dialogue with the European Court of Justice, but also in the judicial review on single procedural acts to ensure protection of fundamental rights, especially in case of intrusive measures, investigative measures, and also in decision about the prosecution, whether or not to prosecute, because in some states there is judicial review. So I think that Italian judges, as we heard this morning, are very active. Many preliminary rulings in different fields, European arrest warrant and other instruments. Many decision was raised by Italian judge, but this is a very new field. But this is a crucial revolution, we could say Copernican revolution. So every change needs time, because also a new mindset should be developed. And this, of course, is a long path development. We need time to work and as scholars to monitor developments and to study and to propose to the Commission or at the institutional level change that be seen as good to improve the system, respecting, of course, fundamental rights and efficiency. Now we continue to speak about
exactly the same
judicial review, the same topic with Professor Serena Protocolo of University of Turin. Also, Serena is one of the scholars that works a lot on this field, as Andrea remarked. And in the subdivision, in the coordination of our roundtable, Serena said, I want to speak about the use of preliminary ruling of national courts and a brand new story.
Who knows?
Oh, no. We are here to listen to you. You have the floor. Thank you very much.
Thank you, Gabriella. Thank you for this invitation, and thank you for organizing such a high-level conference. So thank you so much, and thanks to Luca, who helped me, because I have to confess, I recently turned 50, but I didn't accept that I must do everything with my spectacles. So the slides I sent to him were the wrong ones. So thank you for helping me. So the title of my short intervention could be "Or," because as you've heard by the previous intervention, by the previous speaker, there is a topic about judicial review, which also implies the role of the European Court of Justice. Andrea mentioned the fact that we really need to trigger the preliminary rulings by national judges, or should we also allow the European delegated prosecutors to go straight to the court? So this is the reason why I suggested, when we decided to set up this roundtable, I suggested this topic, because this is something that is beyond the lines, actually, of Article 42, paragraph 2 in particular, and this is something that we need to address. So, as Kathleen said, the discussion about Article 42 in general hasn't been that big issue, but probably the main issue of that discussion was about paragraph 2, I mean, the introduction of a role of the Court of Justice of the European Union in the judicial control of European EPPO acts, actually. So I would say that this has been the main part of the trialogues on that aspect, and paragraph 2 is actually the result of it. I'm not sure these are the right ones, but I will go on and see whether this works. Okay, so how are we sure that this is an option? Could we say that EPPO and delegated prosecutors are allowed to go to propose preliminary rulings to the Court of Justice of the European Union? Well, under the normative point of view, that would be tricky, actually, because Article 267 of the Treaty of the Function of the European Union, as you know, mentions the fact that preliminary rulings should be raised before any court or tribunal of a member state, and those courts and tribunals of member states should bring these cases to the court. So we have a very a strong argument here to say that only courts and tribunals are the ones entitled to raise and bring cases to the court. Article 19, paragraph 3 of the Treaty of the European Union repeats the same concept, actually. So the court gives preliminary rulings at the request of courts and tribunals of the member states. So is it a real option, the one that I suggested at the beginning, that is to say to trigger somehow the competence in preliminary rulings by the court straight from the EPO institutions, actually? Let's see what, first of all, what courts and tribunals means, because in those texts that we mentioned, Article 267 and Article 19, paragraph 3, we may find the solution to and the answer to our question. What that courts and tribunal mean? Well, actually, in the context of the European Union, we don't have a definition of that in the treaties, which is quite acceptable. I mean, there shouldn't be an expectation of a definition of that, but the application, the Court of Justice case law gave raised to this question, actually. So recommendations by the Court of Justice of the European Union to national judges could be considered a source of recommendation and parameters and criteria to consider what a court or a tribunal is. And at the end of the day, we must recognize that courts and tribunals have become an autonomous concept in the case law or the Court of Justice of the European Union for the purposes of preliminary rulings, actually. So this is where the autonomous concept has been developed by the court. These are not the right ones, but however, sorry, there are mistakes in here. As you can see, I should have used spectacles. So we have huge elements in the case law of the court since 1966, actually. So the Vaz and Goebbels case started an extensive interpretation of the former Article 177 of the treaty, pointing out some criteria that should be considered and applied in order to establish whether a body is eligible to raise a preliminary ruling to the court. First of all, it must be a body established by the law. It should be a permanent body, as you can see. It should have a binding competence, so no arbitration. This is something that makes the body not eligible. It should come from a litigation, actually. The body should be ruling upon the law, so no equity courts are eligible for preliminary rulings. And moreover, in an Italian case, Pretore di Salò, quite a long time ago, the court said that independence and impartiality are a criteria that should be taken into account, a criterion that should be taken into account to establish whether the body is allowed or not. So parameters to establish independence are both the appointment system. So we have Lorena here, is a great expert about the topic. Challenging and recusal of the body are other aspects, parameters that should be applied to understand, to measure the independence of a body which is willing to raise a preliminary ruling to the court, irremovability of the members as well. So there are more typos here because this is not the right version, okay? But in the Corbiot decision of 1993, the court said that independence may have many different meanings, actually. So external independence, which is the one we are more used to think about, it's an institutional independence related to the other powers of a state. But also internal independence is very relevant to the Court of Justice of the European Union. That means we need to look into the internal organization of the body, how the body works and how it is able to organize their competences, actually. We have to say that, acknowledge that the two criteria merge later into one general idea and criterion of operative independence, more typos, sorry. In particular, Gabel-Friese decision by the Court of Justice of the European Union is very useful under this point of view because sets a number of prerogatives that the body should have. And in that specific case, the court acknowledged the fact that the Tribunal Administrativo Regional de Catalunya, which is actually part of the Spanish Ministry of Economic Affairs, is eligible to raise a preliminary ruling. So very extensive interpretation. But that came to an end, actually, because a few years later, there was 2005, a new trend started. So with the decision in Seifert and others, the court established that a preliminary ruling coming from the Greek authority for competition shouldn't be considered eligible for raising a preliminary ruling to the court. So I know this is okay. So the other criteria that we mentioned before have been applied from time to time in an inconsistent way, let me say. So we do have adversarial proceedings. This is an aspect that sometimes the court applies, but not always. So also in audito altera parte proceedings have been sometimes considered the good basis for raising a preliminary ruling. So inconsistency under that point of view. Litigations tend to be applied in a more consistent way, but not in every case. In this case that I reported here, the Court of Justice ended up with the inadmissibility of a preliminary ruling by Tribunale di Milano in relation to the approval of a company act. That is a necessary meaning to start and to recognize the activity, start the activity of a company, and that was considered not to be a litigation case. And one interesting, very recent criterion that has been introduced is the entitlement of the body to be a party in the proceedings challenging its own decision. This is a quite recent decision that I mentioned, but this is a brand new criterion that has been applied recently by the court. So let's go straight to the other topic. So specifically talking about preliminary rulings that have been raised by prosecution office. What did the court say? So here we have two interesting cases, one from Torino, one from Trento. This is why I'm very happy to bring them back. So two actually joint cases in 1996 were raised by Procura della Repubblica presso la Pretura. So this is this is an old institution for our foreign colleagues, which was merging both investigating and judging powers in the same body. Actually, that was a very specific characteristic of that body. Actually, in a couple of decisions, a reunited decision in 1996. Sorry for typos again. The Court of Justice ruled for the inadmissibility of preliminary rulings raised by Procura della Repubblica, by the Pretura. The case was related to labor safety law. Actually, the court says the office and the body raising the preliminary ruling is a party of the proceeding. This is not eligible. This is not admissible. So inadmissibility of the decision. A more recent case from Procura della Repubblica di Trento actually relates to the admissibility of preliminary ruling that had been raised about the execution of a European investigation order issued by a German administrative body, actually. So Procura della Repubblica needed an interpretation, needed raise a preliminary ruling because they needed to be sure about the interpretation of the directive on European investigation order, but the court said that that was not eligible, actually. There are very interesting opposing conclusions by the Advocate General Sanchez Bordona, who deemed, on the opposite side, Procura della Repubblica should be and is eligible for raising preliminary rulings because this is a body established by law, first of all. It is a permanent body. Its function is mandatory, no way to avoid it in the proceedings. It abides by and applies the law, of course. And moreover, this is a very interesting aspect, the opinion of Sanchez Bordona said, the decision by the Procura della Repubblica di Trento may have the power to stop the proceedings. So they are the ones who are actually applying in a quite definitive way the European Union law, because if they reject the request, there won't be any judicial stage in the proceeding, and that will be the end of the proceeding, stopping any development of that, actually. So what about EPPO, actually? So Article 42, paragraph 2, as we said, provides for the preliminary competence of the Court of Justice of the European Union on specific aspect of the EPPO. So how to trigger such a competence? Through national courts, actually, but also possibly through EPPO and delegated prosecutors themselves, actually. Does it comply with the case law that we have seen so far? Should delegated prosecutor be allowed according to the strict interpretation that we have seen the Court of Justice has repeatedly delivered so far? First of all, we do have, as Andrea said, issues in specific legal orders. So the Italian ones that we want to take as an example is clearly a complicated case, actually, because in the indirect implementation of the regulation, it isn't possible to consider the Italian public prosecutors, European delegated prosecutors, as bodies who are entitled, because they are clearly parties of the proceedings. They have exclusively investigative powers, so they wouldn't meet the criteria that have been established by the court. And even in the recent decision Kathleen mentioned just a few weeks ago, in the Spanish case, actually, it seems that the delegated prosecutor don't have the same prerogatives as the juez de la instrucción. And so should they be considered eligible to raise preliminary rulings? So is this a case to review, maybe not the regulation on EPPO, but to review the Court of Justice of the European Union position on this topic? I would say that that wouldn't be that difficult, actually. I suggest we follow Sanchez-Bordona's conclusion in the case that I mentioned before by Procura di Trento, actually. And I would value, in particular, the last point of his opinion, the one that I mentioned before. So with regard to the impact that the interpretation of the EU law by the prosecutorial office, EPO in this case, may have on the proceedings itself. I think that this is something that could be valued, actually. So, of course, triggering and pushing national courts to raise more preliminary rulings, but also probably enlarging the area of eligibility of public prosecutor's office, and in particular using the EPPO as a way to open up the stage by the Court of Justice of the European Union. So that could be, we need to allow EPPO members and delegated prosecutor to be able to ask to the Court of Justice of the European Union which is the correct interpretation of the EU law. So this is just a proposal, but I think this is without touching and going and expecting for amendments of the regulation. I think we can and we should expect for an amendment of the position by the Court of Justice of the European Union on these topics. Thank you for your attention. Sorry for the typos.
Okay, we go further in this round table. We heard before that many issues regards relationship between the EPPO and other authorities. And I'm very happy now to give the floor to Vanessa Franson, because I think that as we agreed, she will go further in this topic. Vanessa Franson, just to introduce you, she's professor at the University of Liège. Is this right? Liège. Okay, yeah, Liège. And also in Leuven as Michele Panzavolta. And I'm happy that this is the first time she's here, and I hope this will be not the last. And Vanessa, as I said, will go further on this issue, the relationship with other bodies, let me see what we said, judicial authorities and custom administration. So very interesting point of view. And of course, a relation with national authorities, different kind of authorities outside of the internal structure of EPPO. Thank you very much, Vanessa, you have the floor.
Thank you very much for the kind introduction and for the very welcoming words. I will happily come back if the opportunity presents itself. I think we have all had already a long day, so we'll try to focus to a few key points. I didn't prepare slides a bit due to lack of time, but also to give myself the opportunity to jump a few points and go to the ones that have not yet been discussed. To myself, I gave the title EPPO and National Authorities in Ill-Defined Relation. Just as a short word of introduction, why focus on national authorities? I think Andrea already mentioned it in the previous part of the panel. They are crucial to the functioning of the EPPO, because the EPPO doesn't have its own police force, doesn't have its own customs administration, for instance, and obviously has to play by the rules, including procedural safeguards that, as other persons have already said, include judicial authorization or review. So they play obviously a key part in the whole play, if I may say, of the EPPO. I've identified 3 points that I would like to discuss with you in the limited time that we have. First of all, a brief word on notification. So the notification obligation in the regulation, which has already been touched upon briefly. Then second point, the conduct of the investigation. How is the relation with national authorities? Is it tense or is it very good? I will give a few examples. And then the third point will turn to judicial authorities, in particular judges, the relation with judges. On the notification obligation, as most of you know, the EPPO regulation provides for an obligation for national authorities, all national authorities, to notify a case, to bring it to the EPPO's attention if they think that the EPPO could exercise its competence according to Article 24, paragraph 2 of the regulation, which provides for this obligation of notification. This applies to all national authorities, even though not all legal transpositions, it's not really a transposition, but let's say the legislation at national level that makes it possible for the EPPO to function. Not all legal frameworks have explicitly provided for such an obligation, but then of course we fall back on the regulation, which is quite clear. A question that is now emerging is, what is the consequence of the failure to notify the EPPO? The regulation itself doesn't provide for a sanction. In my own legal system, a first instance court ruled recently that in a customs case where the EPPO had not been notified, that after all, considering this had not taken place, that the prosecution had to be declared inadmissible. And that explains why, quickly after, the Belgian customs authorities started emptying their drawers, if I may say so, because they were, of course, very much afraid that the same would happen in other cases. And that explains also why now this case is emerging to the Court of Justice with a new preliminary ruling. So we will have to see what this new preliminary question or question for a preliminary reference will bring. But I would just like to provide for a side note on what has been said. Yes, in many cases that have been recently notified to the EPPO, facts go back to 2019 or 20. But this doesn't necessarily mean that the customs authorities waited for 5 years with their notification. What happens regularly, which is legal in tax cases and also customs cases, is that the customs authorities discover an irregularity and then can go 5 years back, which then means that in the case file, there will be facts of 2019 or 20. This doesn't mean that the customs authorities or any other national authorities have waited for 5 years. So we will have to see. In an off-record discussion with a national EDP, we had a discussion between customs authorities and EDP. And the customs authorities are very much looking at when should we notify? Should we notify everything, knowing that the way the EPPO's competence is regulated is quite complex? So should we, to be sure, as provided by Article 24, if the EPPO could exercise its competence, we notify? The reaction of the EDP was quite astonishing. This person said, well, I don't want all your cases. We already have enough on our plate. So you please make the selection before getting in touch, which is, of course, a very tense relation between the EPPO regulation, the fact that there's a first case in Belgium, where a court ruled that if there was no notification, that inadmissibility of the prosecution is the consequence, and dealing on a daily basis with cases that could belong to the competence of the EPPO. So there's clearly a difference between the law in books and the law in action. I think there's also another explanation, that is that within the European Union, we have different legal systems, and some of them are based on the principle of prosecutorial discretion, and others are based on the legality principle. In my own system, it's the first one that prevails, and so the reaction of the EDP is quite natural. I don't want all your cases. I want the ones that really matter. I don't want all the cases that belong to the EPPO. But that is not exactly what is provided by the EPPO regulation, of course. Turning to the second point, the way investigations by the EPPO are conducted. According to Article 28 of the regulation, it's the EPPO who conducts the investigation, and either the EPPO can undertake the investigation measure itself, or it can instruct national authorities to do so in accordance with the regulation to the extent that it provides for rules, and of course, national law. A first question that arises in that regard is who is actually in charge of the investigation? And I'm sure that during the assessment, the second assessment round of the EPPO regulation, that the question regarding investigating judges will come back to the forefront. In my own legal system, we kept investigating judges within the EPPO investigations, which was a very particular choice, which is not a choice that has been followed by Spain, France, or Luxembourg. But I think, as I have defended in an article in 2021, I think it is justified for the Belgian legal system, because the way the judicial inquiry is organized under national law, it allows still for a lot of possibility for the prosecutor to steer the investigation. The public prosecutor can ask for additional investigative measures, for instance. If the judge refuses, there's an appeal before the pretrial court. There's other arguments. If you are interested, I can share that article. But there's also another question. What about customs cases? Who's in charge then? Who's in charge of the investigation? The philosophy of the regulation is, of course, even though it's not explicit in the wording of the regulation, that we have the EPPO who is in charge of the investigation. With regard to customs, again referring to my own legal system, the solution that was chosen by the legislator to provide for a national framework allowing the EPPO to function is quite a solution à la Belge, if I may say so. And the conformity, compliance of this legal framework with the regulation, in my view, is doubtful, both in the law, on the books, but also in practice, and I would say even more in practice than the law on books. What is the solution that is taken, followed by the Belgian legislator? You should know, first of all, that under Belgian law, customs authorities have the monopoly of criminal prosecution. They are an administrative authority, but they wear a double hat. Every customs investigation opened in Belgium will go from an inspection, which we can say is actually real administrative law, but then at any point in time, without knowing it, will turn into a criminal investigation. And there's no clear distinction. There's no point at which you can say now it becomes a criminal investigation. The legal framework is identical, so there's no additional safeguards from the point on that it becomes criminal. So it's an old system that is based on old Dutch legislation from the early 1900s. Then has been codified somewhat 50 years ago, and it's very, very different from criminal procedure. It's so different that in almost all universities, except my own and Antwerp, no one teaches this law because it's too different and it goes against what any criminal procedure lawyer considers to be appropriate. Nonetheless, this derogatory legal framework has been confirmed by the Constitutional Court because customs law is so different, which I dare to question. So under this system, the customs authorities have the monopoly to prosecute. How to marry this with EPO investigations? In the legislation that was adopted in 2021, the law now provides that you need a designated custom official who is independent from his administration, but it remains a customs official, so it's not a public prosecutor. And the relation between this official and his own administration is doubtful. I've already heard that he or she is a bit of an outlaw, that he's suspicious for his own administration, but he or she is also suspicious for the EPPO. So a bit of a strange bird. This official maintains the autonomy, the monopoly to prosecute, but he will prosecute according to the decision of the permanent chamber. Now, he will still exercise all his powers in accordance with the customs legislation, even in an EPO investigation. How does this apply in practice? Well, in practice, even though the designated customs official should cooperate with the EDP, the administration continues to do business as usual. And it's not clear to what extent the administration communicates with the designated official. It's not clear to what extent there's any line of communication between the administration, the official, and the EPPO. The impression we have, based on the first pending cases, is that the administration continues to function as they used to do, ignoring the designated official. And there's definitely not much communication between the moment the final document, record, procès verbal of the investigation is sent to the suspect, without any knowledge of the EDP. So this is not exactly what is the philosophy or the rule of the regulation. Another question in this regard is, which law applies if national authorities are instructed to undertake an investigation measures by the EDP or by the EP in some cases? The regulation says in accordance with this regulation and in accordance with national law. But what does this mean? Which national law? And I again refer to customs investigations. If we know that the customs officials have a different legal framework with lower procedural safeguards. For instance, under customs law, you can do a search of private premises without judicial authorization. When you do need a judicial authorization, you can do so without opening a judicial inquiry, which in all other criminal cases is required under Belgian law. They can also seize goods, and if you want the lifting of that seizure, you need to pay. Even if you don't agree, but you need to pay for the value of the goods and the duties that are to be paid. Otherwise, there's no lifting of the seizure. It's not so clear, once the EPPO has taken the case, which legal framework applies. We know that the designated customs official has to abide by his own customs legislation, but on the other hand, you have the EPPO in charge of the investigation. And the EPPO follows the regulation and the Code of Criminal Procedure. To illustrate this, how about the access to the case file? Under customs law, there is no right whatsoever to access the case file. You will have to wait the end of the investigation, and that may take a couple of years. Under the Code of Criminal Procedure, obviously, you do have a right to request access to the case file, which may be refused. But if it's refused, it has to be reasoned and you have an appeal right before a court. I asked our EDPs how they see this. They don't know. They don't know if in a customs EPPO case, they should apply their Code of Criminal Procedure. The same with the lifting of the seizure. Once the EPPO has taken over the case, shouldn't the Code of Criminal Procedure apply to that seizure? It seems there's no answer whatsoever, but it does make a huge difference, of course, for the suspects. I see time is running. Is there any guidance that is given by EU law? I refer to this recent judgment of the Court of Justice of 8 April 2025, where the court re-insisted on the principle of equivalent protection, and interestingly said that there's less possibility for a legal remedy in the EPPO case than there would be if the case had been handled nationally by an investigating judge. And so that this should be taken into account. I find that very interesting as a line of reasoning, because that's exactly one of the reasons why back in the days, when we conducted an independent study for the Ministry of Justice in Belgium, we argued that considering that you have investigations led by an investigating judge with more procedural guarantees than investigations led by the public prosecutor, and considering that our constitutional court insists on those differences, that you cannot simply say, because it's an EPPO case, the protection level is lower. But if you apply this to customs cases, I think we also have to conclude that the higher level of protection should apply. To conclude on the third part, on the third point, because I don't want to skip it, the relation with national courts is really ill-defined, I would say. There's very little in the regulation about the relation between the EPPO and national courts. There's the question, for instance, on the investigative measures with judicial authorization, as Catherine has already explained. With regard to cross-border investigation measures, we now have some clarification, and I hear that that has been very welcome, but I also refer to writings of other scholars who have written closely after the judgment of December 2023, in which the first Apple case was ruled on cross-border investigation measures, that there should be a follow-up at national level. If you have an assisting EDP, what judicial review should then take place? If I look at my own legal system, there has been no change whatsoever. So if there would be a search of private premises in Belgium, where the Belgian EDP is assisting the handling EDP in another member state, there's no difference. We don't have a legal framework that says now it should only be a formal check and not a substantive check. So there is still no follow-up. So I think there's still some work to do. Other issues to signal is, for instance, the dismissal of cases. We've heard that in some cases, additional investigation measures by the permanent chamber has led to a prosecution instead of a dismissal. But I think one dimension in this has been forgotten a bit when drafting the regulation, and that's the role of victims. In some legal systems, victims can file a civil party petition, which means that even if the permanent chamber has decided that the case should be dismissed, that the victim could nonetheless reopen the case. Reopen is not the right word, but could bring the case to a national court or judge, whether investigating judge or trial court, by using this procedure. So the EPPO strategy could be undermined. There's many questions about simplified procedures. For instance, what will happen if the permanent chamber considers that an out-of-court settlement should take place, orders or instructs that this route should be taken? Then you have a national judge who checks the conditions, but also the proportionality and the opportunity of settling the case. What if this judge says no? What are the consequences? Who should reopen? Who should retake the case? The EPPO, I assume, but how this will this be dealt with? So to conclude, I think there's still, and I skipped a number of points, of course, but there's still quite some room for clarification. I don't think it's a good idea to wait for the Court of Justice to clarify all these points, even though the role of the court is very valuable. But I think it would be valuable that the legislator, in revising and evaluating the Apple regulation and reassessing it, it would be good to clarify finally some points that, according to the negotiators of back in the days, were left unclear to reach an agreement. So let's now clarify them, I hope, and I hope that the member states and the Commission will have the courage to do so. Thank you.
Thank you very much, Vanessa, for this interesting overview about the relationship with national authorities. Listening to your words, I thought at the very beginning, when we spoke about models of criminal investigations, all over the world, not inside Europe, and the model of criminal investigation adopting the regulation, because in the EU regulation, there is a clear model of investigation with investigation are in the hand of the EPPOs, not of the investigating judge, not of other national authorities. So it is very difficult to find a compromise between this model, very clear, and different models inside, especially Europe with investigating judge and other models, also with the custom field, a very interesting perspective with the monopoly of prosecution in the hand of the custom authorities. I don't think that this is in compliance with the EU regulation, to be honest, because we are speaking about space for improvement of the regulation, but I think that in this case, it's not a regulation that must be abandoned, but the national legislation governing these fields. You said we had a very old system in the customs, so perhaps a modernization of this field could be interesting and should be the better solution. However, instead of asking for an agreement to or others. However, this is always my personal point of view, so I don't want to say further. Perhaps other speakers or other colleagues in here have different ideas, and if you want to raise questions or to share remarks with us, of course, you must, is always very welcome. But before giving the floor to the public, we continue our path. Let me see with the other contribution by Michele Caianiello, and that should speak, according to our gentleman's agreement, we could say, about amendments, possible amendments of the Article 33 of the EPPO regulation. 37, sorry, I read, I made a mistake. Before giving him the floor, just to remember that Michele Caianiello is a professor at the University of Bologna, alma mater, so everyone knows alma mater, so I don't have to say more about this. And of course, Michele, as all colleagues and friends that are here, devoted a great part of this research and studies to European cooperation in criminal matters and the EPPO subjects. So thank you very much. And Michele, you have the floor.
Thank you. Thank you. Good afternoon to everyone. Thank you, Gabriella, for inviting me here. I'm so happy to be here and may say that I'm getting back home with more knowledge than when I arrived. So thank you very much for having me in this wonderful event. My topic today is try to explain why I think that we should amend Article 37 concerning evidence. And my idea is that we would need a better version of the Article 37 that in a way shapes the way in which the European Court of Justice should handle the topic of admissibility of evidence. This assertion of mine may be controversial because many think that there is no need of amending the Article 37. After all, Article 37 is good as it is. For example, a very important scholar who wrote the commentary on the EPO, Dominik Brodowski, and then wrote an essay on the New Journal of European Law, stated officially that there is no need. After all, Article 37 just claims that for the mere fact that an evidence comes from abroad cannot be denied admissibility. And for the less, regarding the way in which it may be adjudicated admissible or not, is a matter of national legislation. And it's good that things continue to develop that way. Having a standard uniform inadmissibility of evidence rule would undermine national systems, maybe provoke some inequality treatment among national prosecution and EPO prosecution, so it's better leave the things as they are. On the other side, I was inspired in preparing my speech by another essay written by Michele Pantavolta, so you should have used him twice, this morning and this afternoon, an essay published too in the New Journal in 2022 concerning problems, troubles, inconsistencies that the ACJ is encountering when dealing with admissibility of evidence. After all, admissibility was tackled in a quite an uncertain way by the ACJ, originally concerning data, or starting with webmine licenses, and then getting on with la Quadrature du Net and Procuratur, saying that what matters is the possibility to effectively comment for the defense the data produced by the counterpart, usually the prosecution. But what exactly is effectively comment in the two judgments, la Quadrature du Net and Procuratur, the problem was relegated to matters over which judges do not have enough knowledge, as this morning was already recorded. While recently in the Encrochat judgment of the last year, this aspect, matter over which judges do not have enough confidence or familiarity, sort of disappeared and remain the right to effectively comment. But rightly, in my opinion, Professor Pantavolta claims that the right to effectively comment may be not enough. Sometimes is also a joke or a mockery, with all due respect. Think, for example, a person who was lured in speak about against himself because he was not made aware of the right to remain silent. He was not made aware of his position as a suspect, and he gave statement thinking that he was obliged to say the truth. And then it comes out that it's a mistake. But as a remedy, we say, oh, look, sorry, but do you have to comment? You want to say something about this incriminating statement that you, thinking you were obliged to render them, you gave? Please, don't be shy and say something else, like we have in the regulation concerning Olaf. In the administrative proceedings, if a person of concern gives statement against himself, those statements may be used as long as the person has the right to comment. But sometimes right to comment is even a worse than a remedy. So I think that not everything concerns the protection principle, as Michele would say. So we need to give the European Court of Justice more effective tools concerning the admissibility of evidence. My impression is also that the court is quite reluctant in dealing with admissibility. So whenever they can, they avoid to answer the problem, but they are very close to the border. After all, if we think about the two judgments that we already recalled this morning, they are just one step back from entering the problem of admissibility. The first concern, the case concerning Germany and Austria, and about who is the one judicial authority issuing the warrant. Well, what happens if that warrant is missing? What? And nonetheless, the evidence is obtained and presented in court. What? Well, of course, the court did not answer that because it was perhaps not necessary to solve the matter. But next time, they could oblige it to answer. And the other one, the Spanish case, well, Lorena would know better about it than me. But if I get it right, the problem was raised by the defense concerning other person called to give statement as witnesses. But according to the Spanish law, they should have applied to a judge, perhaps le juge d'instruction, I don't know, or another judicial authority, claiming that their role would be as a potential suspect, not as witnesses. So what if this person gave those statements? Instead of raising the problem by the way the problem was raised by the defense, not by those persons? And what if the Court of Justice did not rule a preliminary ruling concerning the possibility of raising the problem at least incidentally, and if there is a proper remedy in the national legislation, provided that equality of treatment is ensured? So again, we would have a problem concerning the violation of right to silence. And we should have applied the directive, the 343 directive of 2016. But that directive does not provide any rule of exclusion and make the same as commenting, using with care or caution, free evaluation, giving less weight, or excluding. What? So we need to have more consistency, I think, in this topic. And sometimes prevention is better than cure. So perhaps now is the time to tackle the problem and not later. As far as I know, there are no projects concerning the amendment of Article 37 regarding the admissibility of evidence. There are two projects, one that makes the evidence collected by the staff of the ADPs equal than the evidence or information collected by the ADPs themselves. And of course, we can all agree that it's quite acceptable and quite reasonable to make the treatment of the staff of the ADPs and the ADPs itself, especially if we think that in some country there are no ADP at all. So perhaps they need staff, at least. Like Slovenia is, if that is a good example, as Andrea Venegoni said. So that is an amendment that is acceptable, inevitably. The other concern translations. Translation made by the EPO office. By the way, do the EPO office have a translator or a specific branch of the institution dedicated to translation? Or is that just done with DeepL or ChatGPT, as I do usually when I have to translate, because in that case we'll may have the same role as professional interpreters, but I don't know. We may question the quality, of course. But anyway, it's not a problem. Translation is a service, and there is no reason to exclude those translations as maybe used or from being used by the court or by the defense. But that's it. No other amendment is provided. So for now, what we know is Article 37 leaves to national legislation the topic of exclusion of evidence. For gathering, collecting of evidence, usually lex loci is preferred. And there is no evidence xenophobia, as Professor Brodowski would say. And finally, regarding the question number two, the comment number two, that the evidence need to be freely assessed. It's up to national legislation to explain why, but we know that the principle of free evaluation should rule. Well, this amendment rejected in a way the original proposal dating back to 2013, and perhaps implemented the suggestion of the model rules. Because in a way, I think that the model rules provided simply that the mere fact that an evidence was collected abroad was not a reasonable ground for excluding the evidence. The Article 30 of the Commission proposal said something different. Said that evidence should be evaluated, or admissibility should be evaluated concerning the right to a fair trial and defense right violation. So in a way, preserving Article 47, 48, and the fairness of the procedure. But on the other side, that says something that really was quite wrong. That for the mere fact that the EPO presented evidence that should have been admitted before any court without any validation. So this second phrase was quite problematic because it could have created inequality problems regarding evidence coming from abroad in horizontal cooperation and in the EPO system. Because in horizontal cooperation, we may have a control or a validation control by the judicial authority of the locus fori, and not the same would have applied for the EPO system. So in the end, the legislature decided to strike out this passage, but also the passage concerning the fairness of the procedure and the defense right. So at the moment, we do know what cannot constitute a ground for inadmissibility, the mere fact that evidence comes from abroad or was taken in another country, but we do not know what should make evidence inadmissible. By the way, I don't think that in Europe, in the European Union at the moment, we have such a big evidence xenophobia. So whatever is the system receiving the evidence, all our states are quite eager to admit evidence. And EncroChat shows that no matter if we have a legal provision concerning inadmissibility, like the inutilizzabilità in Italy or the Spanish system or other system, there is quite an open mind in admitting the evidence, at least for two reasons. The first is that evidence is already collected. So what is the problem after all? We do not have, if we put in the shoes of the locus fori, we do not have to conduct the operation. The operation are already finished. We just have to open the door to data collected. And that is not very problematic. But secondly, for a diplomatic reason, in judicial cooperation, whatever horizontal or vertical, or the ICC or the European Union, whenever you are choosy concerning evidence coming from abroad, whenever you say, I don't want that evidence, the risk is that the next time you will not receive that evidence. So it's better that you are more open-minded that within your own system. Otherwise, we may compromise the system of judicial cooperation concerning matters. So we need to accept and cutting edges to accept evidence coming from abroad. But this is the limit, because again, we do not have a consistent system, and the European Court of Justice did not give us guidelines or sufficient guidelines. So a possibility could be to adopt a flexible rule, but this is just a matter for debate. So perhaps neither the original author of the idea yet shares the same opinion he had 2 years ago, but nonetheless, is quite a good method that he proposed. I'm referring to Michele, and this is why I'm proposing you. So setting out the values protected by inadmissibility of evidence. And the scale of values proposed in these essays are quite interesting, I think, because they are first reliability, so the truth, and accuracy of fact-finding. Evidence should mainly regard that in the Bentham approach to evidence. Secondly, protective principle, so the effective comment, especially if we interpret the word comment as challenging, not only giving an opinion over a data, over an evidence, but looking into the way in which it was collected and conserved and stored and then presented. Well, if commenting means that, we may agree about that. And finally, the integrity of the system. Sometimes truth is important, protection was respected, but nonetheless, integrity would be compromised by the admissibility of the evidence. So if we share all these values, why not putting them within the Article 37 and allowing the Court of Justice to have a guideline for developing their own case law in a more consistent way? There is no way to escape this problem. Sooner or later it will arrive. And I think the legislator should be brave enough to anticipate the problem. Finally, I also think that usually procedural systems are built upon procedural sanction. So the identity of a legal procedure order is when putting a stop to an information, no matter how important it is, how valuable it is, but putting a line between what is permitted and what is not. Because after all, we have to remember that procedural rules are not recipe guidelines, and when they are not observed, there's sanction, and not only a cooking that is badly done. So my hope is that we will find the strengths to tackle with the Article 37 and introduce some element that may help the development of case law in this field. Thank you.
Thank you very much, Michele. Listening to your words, I thought to what we said this morning, because as we said, there is a red line when we speak about evidence, because if we think to evidence in the horizontal cooperation, but also in this vertical integration, I could say the issue is always the same, because there is, I would say, the sensation that the field of evidence is like a prohibited garden where EU legislator doesn't want to enter because member states do not want that
the EU legislation 120. So the problem is always the same. We have very different rules in gathering evidence, very different standards of admissibility, and it is very difficult to find a proper solution, because also the proposal, we heard Lorena this morning, the proposal for a mutual admissibility of evidence and specific on electronic evidence is just a scholar proposal at the moment, and I think that will be not a political will to go further in this direction. But this is a crucial point with prosecution and investigation. The two main points are gathering of evidence, and then, and I'm giving a bridge to Rosanna, decision on prosecution using this evidence gathering different methods and in different member states in case of transnational investigation. So we have the last contribution to our discussion, and I repeat again, if you have suggestions, remarks or questions to our speaker, you are welcome. But before we finish this roundtable, giving the floor to Rosanna Belfiore of the University of Catania. Rosanna, as the other speaker, I want to be boring, but she also specializes in the field. She wrote a book about gathering evidence abroad, and she had many contributions about also the APPO, also when the PPO was not a reality, but was just a project, as we said before. So I'm very happy to give the floor to Rosanna. She will speak about cross-border investigation and evidence again. So this is another confirmation that this is a very crucial point, as we all know. Thank you very much. You have the floor.
Thank you, Chair. Thank you, Gabriella, for inviting me to this very important conference with such distinguished scholars. I know I'm the last one. I know it's late. I know we are all tired, so I will stick to the time I've been allocated. Coming to the subject I am going to deal with today, the cross-border dimension of EPPO's investigations is essential in the fight against crimes affecting the financial interests of the Union. In investigations involving two or more member states, EPPO's supranational nature is the added value, which is given by closely coordinated investigations and prosecutions at a central level, together with effective cooperation at a decentralized level, beyond the dynamics of mutual recognition, which are still heavily conditioned by logics linked to national sovereignty. Article 31 of the regulation, paragraph 6, is very clear to me. Only if the assigned measure does not exist in a purely domestic situation, but would be available in a cross-border situation covered by legal instruments on mutual recognition, the EDP may have recourse to such instruments. Mutual recognition is an alternative to the EPPO mechanism, is not the rule of that mechanism. Mutual recognition, recital number 73 further clarifies this concept. Legal instruments on mutual recognition should not replace the specific rules on cross-border investigations under the regulation. After all, that Article 31 aims to introduce a new system is what the EPPO College said in its guidelines back in 2022. I'll quote them. Article 31 created a new mechanism for the EPPO cross-border investigations. It created an entirely new and autonomous EU legal concept. Again, the guidelines. Article 31 creates a self-standing sui generis legal basis for the EPPO cross-border investigations according to a new assignment mechanism that replaces mutual recognition instruments. As proof of the fact that Article 31 constitutes a new legal framework for cross-border investigations, the EPPO College recalls that the corresponding costs, including for translation, are to be borne by the EPPO to the extent that these are costs which are caused only due to the EPPO having assumed responsibilities for investigation and prosecution. The EPPO College underlines that it is in the interest of justice and of the EPPO itself that the office maintains independence on its investigations and operations to the largest possible extent, also from a resource point of view. Therefore, this new assignment mechanism is a matter of independence. Yet this simple concept of a new mechanism was called into question in occasion of the very first judgment of the Court of Justice concerning EPPO and in particular cross-border investigations. The opinion of Advocate General Capeta is very clear. We all know her opinion. As long as there are no common EU criminal law rules, the EPPO cannot but operate based on mutual recognition. The EPPO may be seen as the most developed mutual recognition instrument in the area of cooperation in criminal matters. The argument that the EPPO system is something more than mutual recognition could be accepted, she says, if understood as stating that the EPPO system establishes a different, higher degree of mutual recognition. Still, in the words of Advocate General, something more cannot mean something else. Instead, I believe that the EPPO system cannot but be something else. Or at least, to be realistic, the EPPO system has to aspire to be something else. Indeed, the new EPPO system for cross-border investigations is one of the added values that justified the adoption of the regulation in light of the principles of subsidiarity and proportionality. It is true that the European legislator renounced the idea of one single legal area, but still it established one single office, and Andrea Venegoni stressed this concept quite a lot. So this new assignment mechanism is also a matter of legitimacy of the regulation of the EPPO itself. The Court of Justice, for its part, did not take a clear position on the point. First, it underlined that the distinction between the justification of an assigned measure and its enforcement reflects the logics behind mutual recognition. Afterwards, it held that by adopting the EPPO regulation, the EU legislator intended to establishing a mechanism ensuring a degree of efficiency of cross-border investigations at least as high as that resulting from the application of mutual recognition, thus suggesting that the EPPO system is something else. The problem, if anything, is that this new system of cross-border investigations has proven to be cumbersome, to be bureaucratic, more time-consuming than the application of the directive on the European Investigation Order, as reported by the EPPO College, at least until the sentence of the Court of Justice, because Andrea Venegoni told us that Article 31 works smoothly. But then why, among the amendments proposed to the EPPO regulation, we find a proposal for an amendment concerning paragraph 6 of Article 31 in favor of extending the use of mutual recognition instrument to particular cases where such mutual recognition instruments are more efficient, appropriate. I'm not sure this is the best way forward. In the face of the objective difficulties encountered in cross-border investigations, this proposed solution is to follow the path that neutralizes the added value of a system aimed precisely at overcoming traditional cooperation schemes, even the latest generation schemes based on mutual recognition. I believe that faced with such an ambitious project as the creation of a brand new supranational body, the paradigm of judicial cooperation should be fully rethought. The new autonomous system based on the assignment mechanism suggests that close cooperation, consultation, and solution within the same prosecution office shall take the place of requests between foreign authorities, formal recognition, or possible refusal, without renouncing the necessary guarantees worthy of fair proceedings. Of course, this new paradigm needs to be endorsed by national authorities and needs to be enhanced by the Court of Justice. I agree that preliminary rulings are crucial for the development of judicial cooperation measures. So EPPO's overall success is in their hands. Let's not forget that a great number of EPPO's investigation, as Professor Ligeti recalled, have a cross-border dimension, about 1/3 or 1/4, and this has been revealed very clearly in the last annual report. In this framework, crucial is the issue of judicial control, of course. This issue has been dealt with very superficially by Article 31 and has been addressed by the Court of Justice in its very famous preliminary ruling. We all know that the Court of Justice distributed the responsibilities for examining the justification and the execution of the assigned measure between the member state of the handling EDP and the member state of the assisting EDP. In line with this system of a de facto double authorization, but still one single judicial authorization on the substantive conditions of the assigned measure, without prejudice to the fundamental rights stemming from the EU Charter, it is for the member state of the handling EDP to provide in national law a prior judicial review of measures which seriously interfere with such fundamental rights. I think that the Court of Justice interpreted Article 31 by opting for the most balanced reading of the rule between efficient investigations and effective protection of fundamental rights, including defense rights. Not only that, the Court took a step further. The Court implied that when an investigative measure is particularly invasive, prior judicial review is always required. In other words, the profound meaning of this ruling is that prior judicial review is due regardless of whether the measure is ordered in EPPO proceedings, unless we accept that a double standard applies, depending on whether an invasive measure is ordered by a national prosecutor or by an EDP, even though I don't see how a double standard could be compatible with fundamental rights stemming from the EU Charter. In addition, prior review in the form of authorization is the guarantee that the Court of Justice is long holding in its harmonizing case law. I'm thinking of the already mentioned case where the ECJ held that it is precluded to national legislation to confer upon the public prosecutor's office, rather than a judge or an independent body, the power to authorize access to traffic and location data for the purposes of a criminal investigation. I'm also thinking of that other recent case where the ECJ held that access to data contained in a mobile phone must be authorized by a court or an independent administrative body. I spoke of harmonizing case law because in these mentioned cases, the Court of Justice is not talking about judicial cooperation, but national criminal procedures. Not for nothing, in Italy, we first had to modify the law that allowed the public prosecutor to order access to traffic and location data so as to provide for an authorization by a judge. And we will soon have to resolve a dispute that arose within the Court of Cassation regarding the question of whether the Italian prosecutor is an independent administrative body, such as to be able to authorize access to data contained on mobile phones, as domestic law currently provides for. All this while modifications of the Code of Criminal Procedure are under discussion in order to assimilate seizure of mobile phones to the rules of wiretapping, which requires the authorization of a judge. In this context, the ruling of the Court of Justice in the Encrochat case should not mislead, as it apparently seemed to retreat on the guarantee of prior judicial review. In that case, the Court of Justice actually ruled on the competence of the public prosecutor as issuing authority, ordering the transmission of evidence already in the possession of the executing state, where the initial gathering of that evidence should have been ordered by a judge in a purely domestic case in the issuing state. It is true that beyond the wording of the directive, the court could have established the need for prior judicial review in the issuing state when it comes to the transmission of already existing evidence, and the initial gathering of that evidence concern a mass interception of telecommunications in the issuing state on encrypted mobile phones using inaccessible technical basis. However, the Court of Justice preferred to stick to the questions referred for a preliminary ruling. Mutual recognition does not allow the issuing authority to review the lawfulness of the separate procedure by which the executing member state gathered the evidence sought to be transmitted. The directive on the European investigation order only allows for an ex post judicial review and an assessment on the respect of the rights of the defense and the fairness of the proceedings only once the evidence has been obtained. Directly linked to the topic of cross-border investigation is the issue of admissibility of evidence. Of course, this has been discussed all day long. The issue of admissibility of evidence gathered in another member state. If cross-border investigations are to be treated as an autonomous system of assignment, as they are embedded in an unprecedented legal framework. It is the issue of admissibility of evidence gathered across borders that continues to arise in its traditional form. The problem of double legality, which is the conformity of evidence both to the law of the state of collection and to the law of the state of the trial, does not change, even in the context of EPO proceedings. And this lingering problem, on the other hand, is the consequence of the fundamental choice made by the European legislator to separate the level of prosecution, supranational, from the level of jurisdiction, purely national. In this perspective, it may be useful to resort to that rule adopted already in the Directive on the European Investigation Order and reproduced in the EPO regulation, according to which the assignment may contain, where applicable, the formalities and procedures of the handling EDP's national law, according to which the assigned measure needs to be carried out. An important rule to make admissibility of evidence more likely. A rule whose implementation, however, as happens already in the European Investigation Order procedures, depends on the foresight of the handling EDP, and is, in any case, bound by the compatibility of the formalities and procedures indicated with the legal fundamental principles of the member state of the assisting EDP. Also relevant is Article 37, of course, the non-discrimination clause. We know it very well, but the non-discrimination clause does not exclude that where incompatible with domestic law, evidence is not admitted or in any case is not used. Also because the trial court remains free to assess such evidence. After all, it is a duty for national authorities to ensure compliance with the evidentiary procedure provided for by the domestic legislation, which is the only one to refer to. In fact, this is the ultimate guarantee to protect jurisdiction from unlawful evidence. Which is far from a remote possibility. I think of a very recent case that has been issued in Italy, although in the context of international judicial cooperation, in a sadly famous case in our country, I'm referring to the Regeni case, where the trial judge deemed null an interrogation conducted in Egypt at the request of the Italian prosecutor due to incompatibility with the information and defense rights of the person being interrogated, as provided for by Italian law as well as by Egyptian law. There was a double check. In conclusion, and really I'm concluding my very brief speech. To address the issue of admissibility of evidence, suggestive could be the proposal for mutual admissibility of evidence and electronic evidence that Professor Bachmeier talked us about this morning. In this proposal, the mother rule for admissibility of evidence provides, on the one hand, that evidence obtained in compliance with lex loci shall be admissible in criminal proceedings of the forum state unless it infringes fundamental constitutional principles of the forum state. It provides, on the other hand, that evidence transferred to the forum state must be still submitted to an assessment of its compliance with guarantees with sufficient guarantees to safeguard the fairness of the proceedings as a whole. I think this proposed rule is a good compromise between existing rules. It partly evokes the non-discrimination clause provided for in the EPO regulation. It essentially follows the principle of inquiry within the limits of the directive on the European Investigation Order as interpreted in the Encrochat ruling, and it openly draws on the well-known Strasbourg case law on the fairness of the proceedings as a whole. Who knows, this may be the way forward, or at least the starting point for a discussion. So thank you for your attention.
Thank you very much, Rosanna. The evidence field is always the more complex and difficult field to handle. And for this reason, Michele Caianiello said that she wants to add something to what we said before. But before giving him the floor, do you have questions, remarks, suggestions? There are many. I know that you are tired, very tired. The day was long. Lorena?
Thank you. I mean,
sorry, Lorena, can you reach?
Oh, yeah.
Because there are that are following online. So
Yes. Please reach the microphone.
This one is working?
Okay.
It's better.
Thank you so much. I don't want to extend the time of the conference, but I was once instructed that a conference without questions and debate is not a good conference. So I'm just trying to make it even more excellent than what we heard during this afternoon and during this morning. Congratulations again. So this question, again, take it for free to answer or not to answer. The aim is only to just not wrapping up, but enhance the discussion. I have a lot of questions, but I will keep it to the very, very, very minimum. My first question was to address to Serena Quattrocolo, but since she said she already left, there is no possibility to discuss on the issues on the judicial authority and how by public prosecutors and the opinion of Sanchez Bardona, if it would have been different if it was not addressed to the Italian Ministerio Pubblico, which is an authority that enjoys a lot of independence. I would say the only one in Europe who is amount really in all aspects to a judicial authority. I wanted to also to address one question related to the material competence on as Andrea Menegoni presented on the European Public Prosecutor's Office. I was asking myself, because there's a lot of issues always related to Article 25 and the damages and the quantity, and as you say, it's complex cases, and sometimes they divide cases. So in order also to lower the damages limit, should it be possible to establish, if not common rules, at least guidelines or recommendations on how to assess the damages and calculate those damages, so that at least there would be a kind of harmonized element to determine the competence? That would be my first question. My second question is, what do you think of, obviously, consolidation of the EPPO as it works now? I fully agree with it, but I've been thinking also that if we are dealing with some supranational element and supranational interest, which is, to my mind, a truly environmental law that it applies without any frontiers, and I think all member states should be equally interested in prosecuting it, and it's under prosecuted, and it's causing huge damages, and it's related also to fraud and organized crime. So it might be interesting to start there, where there is already a huge acquis in European Union law, and there is already a supranational, let's say, investigative or controlling mechanism, which is the Copernicus satellite, already overlooking the environmental infringements, environmental compliance law. So I would like to know what is your opinion? The whole panel is addressed here of extending. I'm not saying right now, I'm saying in the next future as a priority, the material competence of the EPPO on environmental crime. Finally, resources. What we are witnessing is that certain member states are trying to strangulate the efficiency of the EPPO, not only by reducing staff, administrative staff, but also reducing allocated specialized anti-fraud law enforcement. This is the case in Spain, and where anti-corruption office has a really, really very specialized fraud police, while the others don't reach it. So how to address this? And the last one, I was shocked by, Vanessa, your presentation about customs authorities really having this blurred system of administrative criminal investigations. My only question is very, very, very limited. Do they really have also powers to search of premises? You said yes. Also homes. And second, are they considered judicial authority for the aims of the European Investigation Order? So thank you very much. Thank you for reading the proposal on admissibility, because I had sometimes the impression that when people talk about the proposal on admissibility of criminal evidence at the European Union level, they think immediately of exclusionary rules, and we don't want to have exclusionary rules. And the idea is that how to treat inadmissibility. Inadmissibility should be treated more or less as the European Court of Human Rights is assessing it. So not sole and decisive evidence rule, and assess fairness as a whole of the proceedings. So I think, thank you for reading it, and thank you for understanding it.
Okay, thanks. So the first one, yeah, the first one is to the European Italian prosecutor, Dr. Venegoni. Your reference to the common sense attitude approach of the permanent chambers drew my attention. So the question is very simple. Do you think that this practice of the PPO is actually pushing, at least indirectly, toward further harmonization of the rules of criminal procedure, and maybe could have an impact also on the jurisprudence of the Court of Justice, at least indirectly interfering with the national proceedings. And the second one is to Vanessa. I'm very interested in the Belgian practice on the consequences, I assume, on the national prosecution if the crime was not reported properly to the PPO. I just wanted to know, it's a curiosity, if in your opinion this jurisprudence was developed to protect the PPO, or if maybe there is another rationale that I cannot understand because it's related to your own legal order, and also which is your opinion from the legal point of view, because at least we can agree on the fact that the system is built up on shared competences. So it is established that both the national and the European prosecution can prosecute, is entitled to prosecute the PIF crimes. So do you think it's correct? Thank you so much.
Well, regarding the question on the guidelines on the damage, on the value of the damage, we already have some guidelines that basically the guidelines are that the facts must be always seen, must always be seen in a global way, let's say. Rather than in the application of Article 25, this is something that is relevant, for example, in the VAT fraud, because it's typical in the VAT fraud to have police reports highlighting, focused on specific operations among companies. And if you consider those specific operations, the threshold is not overcome. But in that case, we have the policy to keep if we see connections, for example, with companies in other cases, and we can already carry out this cross-check through the database, the policy is to keep the case, waiting for the developments. And then if really we manage to establish connections with other companies, other operations, then we can see the operations as a global huge scheme that in that case overcomes 10 million euros. So in a way, we already have something about that. Regarding the material competence, well, let's say, I don't know, from that point of view, I'm very pragmatic in the sense, yeah, probably the environmental crimes are very well candidates to become the next competence, but I think it is something that will be seen during the negotiations. It's a matter of political will. Theoretically, yeah, it could be a good proposal. But let's say we are practitioners, and so we are very pragmatic. We will deal with what the politicians will give to EPPO, I would say. And then there was your question. On the harmonization. But could be, but in the mid-long term, I would say, certainly not immediately. No, but I think that in a way, the permanent chambers are already creating a sort of new European law. I have this feeling, I don't know, but I have this feeling. Now, okay, after 4 years, we are already in a position to have a little case law from the decisions of the permanent chambers. And if you put together some decisions, you might see this mix of different laws. But okay, maybe it's too soon to draw this conclusion. We'll see.
Thank you very much, Andrea. Other questions were for Vanessa, if I'm not wrong, about Belgian practice.
So one question was about the customs authorities, whether they can search private premises of individuals. No, the legislation is more limited. So it will be business premises usually. Nonetheless, we know that ECHR Article 8 also applies to business premises. So under the Code of Criminal Procedure, there would nonetheless still be a judicial inquiry. Of course, the legislation is more specific, that's true. But in my view, there's definitely need for a reform. And to follow up on what you asked, Gabriella, we're working on that reform. But the question or the difficulty is that that reform implies the customs authority. And they are obviously not very willing to give away the powers that they have. Also because they're very concerned about the financial liability of the Belgian state towards the EU, because the state has to pay. to the EU. So that's their one of their concerns. There's many other concerns too. The fact that if they wouldn't conduct full-blown inquiries, the job would be much less interesting, and so they would go elsewhere. But that's something completely different. Then there was another question about whether the customs authorities are a judicial authority under the EIO directive. Yes, the customs authority can issue an EIO within their powers, of course, but has to be checked by an investigating judge. This judge will not apply his own rules, but will just check whether, formally speaking, the EIO is in conformity with the EIO legislation. So it's just a brief legality check. It's not, you know, adding a judicial authorization. That's not the case. From past interviews, I know that the Belgian custom authorities has experienced sometimes difficulties when they send an EIO, for instance, to Germany or other member states, where then judicial authorities receive a customs authority EIO and they say, what is this? But under Belgian law, this is indeed the case. To reply to your question, Luca, on why this first instance court decided that the admissibility or the prosecution should be declared inadmissible, I will refine the decision. It was a very short decision, like 2 pages. It's a first instance, but I think it referred to the fact that the competent authority, according to law, had not prosecuted the case. So that's in line a little bit with the case law that we have on exclusionary rules. Although it's older case law, which has not been codified into the legislation. So there's a question whether this criterion still applies. But I will find a decision. It's in French, and I will get back to you if I think it's perhaps a one-off, but I don't know. But customs authorities are clearly concerned about how to go about. Yeah.
Thank you very much, Vanessa. So the last should be Michele, I think.
Oh, yeah.
I couldn't see other question on my notes. So you have the floor.
It's a very brief
but-
consideration.
yeah.
Thank you. I know that member states are jealous and reluctant to give power to the European Union in the field of evidence, but I think that they are looking at the current situation with the eyes of the past, with the wrong lenses. The scenario now is different. And I think there are 3 reasons why we should be, and they should be, less worried about giving power to the supranational level. The first is that systems are aligning. So no matter if they are adversarial or inquisitorial, but Lorena, of course, told this various years ago, but now I am understanding. So they are aligning in the end. If you ask an Irish scholar or an Italian scholar if what is the most important phase of the trial, they will tell you the pre-trial phase. No matter if you are adversarial or inquisitorial, but that is the most important phase. Secondly, many countries, not only in the European Union, have either a provision or a practice concerning exclusion of legal obtainable evidence. So now it's not anymore something that cannot be spoken, thinking about exclusionary rules transnationally. But finally, this is particularly true for digital evidence, because we do not have traditions. We do not have the problem of cross-examination. We do not have the problem of the use of a police record and something like that. Digital evidence is something new, over which we are all facing a new scenario. So this is why we should be more brave and giving the power to a supranational institution, and having a consistent way of dealing with this type of evidence would be very important. So that's it.
Thank you very much, Michele. I'm looking to you. Other words? Without words, we are too much tired. So I close this meeting just with a warm, with many warm thanks to every person who is still here. It's more than 6 o'clock. To our distinguished speakers and to the public. I hope that we will have another meeting, another chance to meet in Trento, I hope, but if not in Trento, in other place where we may continue our discussion about developments of international cooperation in greenville matters in horizontal and vertical dimension. Thank you very much to all. You are free now. I forgot, lo dico in italiano, anche un ringraziamento davvero sentitissimo allo staff dell'Università di Trento che ha reso possibile tutto quello che abbiamo fatto, dall'ospitalità, viaggi, pernotti, la registrazione, il link che ci consente di essere collegati con le persone da remoto, nella persona in particolar modo di Giorgia Sartori che si è occupata diciamo dell'ospitalità, che vi ha scritto più volte, poi dei nostri studenti che ci aiutano, 150 ore che ci aiutano anche nel garantire questa accoglienza e queste parti diciamo più burocratiche, la registrazione e quant'altro. Noi facciamo ricerca ma senza il nostro personale amministrativo, questo vale anche per la procura ma vale anche per noi che siamo dei docenti, non potremmo fare molte delle cose che facciamo, quindi grazie davvero e spero